Court officer.
Secondary.
My lord, end up list is the election matter.
What is the urgency?
Tomorrow is meeting is there. Tomorrow is general body is there.
General body of
Panchayat general.
no confidence.
No confidence.
Government advance copy.
Yes. I'll give sir.
Government.
Sir.
Government. ಅದು ಯಾವ ನಂಬರ್ ನೋಡಿ ಅದು ಸ್ವಲ್ಪ ನೋಡಿ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
One 2018 first appeal matter, your lordship. This is appeal is by the defendants. So we are for the respondent and she is age old lady, your lordship. Suit for partition, it is decreed. It is for early hearing. I have filed application that has not been considered. Your
ಕೊಡಿ
tomorrow it may flash.
ಆಯ್ತು ಬರ್ಲಿ.
Submission, my lord. Some MFAs in respect of land acquisition cases only for capitalization method, not in any potential in all. And 1718 is there. There are so many matters are pending before district court on the ground of valuation, my lord. So they are pressing for it.
ಕೊಡಿ.
My lord.
One is writ appeal, my lord. It was not posted. After vacation, it was there. It was not posted.
My lords, this is criminal appeal, my lord, in murder case. Since 11 years, he is in judicial custody.
ಕೊಡಿ.
Please.
ಚೆಕ್ ಮಾಡಿ ಬನ್ನಿ. ಅದು ಚೆಕ್ ಮಾಡಿ ಆ ಲಿಸ್ಟ್ ಇಂದ ಹೆಂಗ್ ಮಿಸ್ ಆಗಿದೆ ನಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಇಟ್ಸ್ ನಾಟ್ ಇನ್ ದ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್.
Once it was came on board, my lord, later we come.
You are ready?
Yes, my lord.
You are ready?
Yes, my lord. Any date kindly. For appellant, my lord.
11 years ಅಂತ ಚೆಕ್ ಮಾಡಿ. ಇದ್ರೆ ನೀವು ನಾಳೆ tomorrow?
No, my lord, 2-3.
Okay. We want you to prepare a short synopsis also.
Grateful.
If lawyers are fully ready, we will also dispose it of with ease. So whatever your assistance, you will get a quicker order.
Grateful.
Yes.
One more. My lord, serial number 12, I want to withdraw it becomes infectious.
The serial number?
12, my lord. Contempt petition.
One nimsha, just wait.
Yes, please.
Hold. Put it. No, 14%. I know the date. Date put or jail. Yes, page wise.
Page number 6, till number 27 and 28. Page number 7, till number 29 to 34.
My lord, serial number 30.
30.
My lord, kindly have it next to
You appear for the
petitioner
petition.
on behalf of Gopal
That
Krishna.
request, release the matter, date. Yes.
Page number 8, serial number 35 to 37, 9, 39 to 42, 10, 43 to 47.
Your Lordship, serial number 45. I'm
Yes.
appearing for the appellant, Your Lordship. May kindly have it next week.
At request. Inform the other side,
Please, Your Lordship.
relist the matter on.
29, Your Lordship.
Please.
ಮೂರು ಅಪೀಲ್ಸ್ ಪೇಪರ್ ಬುಕ್ ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ?
ಇದೆ ಇದೆ.
ಮೂರು ಅಪೀಲ್ಸ್ ಇದೆಯಾ?
ಇದೆ.
ಈ ಮೂರು ಅಪೀಲ್ಸ್ ಅಲ್ಲಿ ರೆಡಿ ಆಗಿ ಬರಬೇಕು. ನಾಳೆ ತಗೊಳ್ತೀವಿ, ಒಂದನ್ನು ನಾಳೆನೆ ತಗೊಳ್ತೀವಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಅನ್ನು ನಾಳೆ ತಗೊಳ್ತೀವಿ.
ಪ್ಲೀಸ್.
3 ದಿವಸ ಇಲ್ಲೇ ಇರಬೇಕು ನೀವು. ಮಾರ್ನಿಂಗ್ ಟು ಈವ್ನಿಂಗ್ ಇಲ್ಲೇ ಇರಬೇಕು. ಎನಿ ಟೈಮ್ ರೀಚ್ ಆಗ್ಬೋದು. ಈ 3 ಅಪೀಲ್ ಅನ್ನು ಕೂಡ ಮುಗಿಸ್ಬೇಕು. ನಾಳೆಯಿಂದ 3 ದಿವಸ ಇರಬೇಕು ನೀವು. ನಾಳೆ ನಾಡಿದ್ದು ಮತ್ತೆ ಫ್ರೈಡೆ. ನಿಮ್ಮ ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಟು ಬಿಡಿ. ಇಲ್ಲಿ 3 ದಿವಸ ಇಲ್ಲೇ ವೇಟ್ ಮಾಡ್ಬೇಕು.
Orders serial number 1, RS Kadaganchi.
May I make a humble submission, my lords? Ali, he is in serial number 1, 3 yellow or there is one. Proxy counsel on behalf of RS Kadaganchi.
Pass over ಮಾಡ್ಬೇಕಾ?
It may be passed over to politely, my lords, at 12 o'clock because meeting is at 3 PM, my lords.
Correct.
12 ಗಂಟೆಗೆ ಮಾಡೋದಿದೆ. He is also first matter ಅಲ್ಲೂ ಅವ್ರದೇ ಇದೆ. That's why humble submission.
12 o'clock.
12 o'clock.
Right.
Otherwise, if it is called at 2:30, meeting will be.
No, we are aware of it. That's why have we put it first on the orders list?
Yes. Oblige, my lords.
What is your decision now? You have to take a call.
Yes, ma'am.
There are two simple methods. I leave it to you. If I were a lawyer, I would have said, I'll advise them how to move a motion of no confidence and wash it off. Instead of getting stuck, stay for 1 week, 2 weeks, etc. But anyhow, it's your call. You take your call. So 12 o'clock when it's called, you take a call, stand, please.
On compliance of office objection, third time, serial number 2, Sanganagowda Biradar.
My lords, I am for appellant in this case, my lords. And ನಾನು ನಿನ್ನೆ ಕಂಪ್ಲೈ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ. ಮತ್ತೆ
ಚೆಕ್ ಮಾಡಿ ಅದೇನೋ ಚೆಕ್ ಮಾಡಿ ಏನೋ ಇರುತ್ತೆ.
ಏನಾಯ್ತು? ನಿನ್ನೆ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಆಯ್ತು ಮಾಡಿ. Weeks time granted. Necessary compliance.
Much.
Fifth time, serial number 3, Vasanta Kumari P.
Yes, government ಏನದು? ಬೇರೆ ಏನೇನೋ ಇದೆ. Weeks time granted finally for compliance. No representation of the complaint. Relist the matter on. Yes, next.
Serial number 4, BB Patil.
Same order.
Serial number 5, Bhimaraya MN.
Filed by 14 person, my lord. Legal cell ಇಂದ ನಮಗೆ ರೆಫರ್ ಆಗಿದೆ ಮೇಲೆ. ಫಸ್ಟ್ ಟೈಮ್ ನಾನು ಒಕ್ಕಲತ್
ಆಯ್ತು,
ಹಾಕಿದ್ದೀನಿ.
ಮಾಡಿ ಅಷ್ಟೇ ಮಾಡಿ.
Kindly 3 weeks time, my lord.
ಕೊಡ್ತೀವಿ ಮಾಡಿ.
Yes, sir. Kind of.
ಯಾಕಂದ್ರೆ
Kind of.
RP of the year 2016.
Kind of, my
Land Council for the
lord. 3 weeks ಕೊಡಿ, my lord. ಅದರಲ್ಲಿ
ಕೊಡ್ತೀನಿ ನಾನು.
kind of.
Submits that office objections will be complied with. In light of the same earlier order, posting it for dismissal is
I appear for the petitioner. My lord, copy served on respondent family court matter, my lords. It is served through Commandant CRPF, Bangalore.
Tenth of January.
Please.
Notice the letter addressed by the commandant to the Additional Registrar General, High Court, Kalaburagi bench. Full stop. It is observed that notice has been served on the respondent herein. Full stop. Letter is dated 10th of January. Full stop. We find that, however, there is no representation on behalf of the respondent. It is made clear that proceedings will proceed in the absence of the respondent if the respondent doesn't put appearance through a counsel by the next date. Full stop. Relist the matter on date. 28.
Oblige. I'll address the argument on 28.
Yes, yes.
Oblige.
File your synopsis.
Please.
7, Sudhir Singh R. Vijapur.
Yes.
Recalling application for
Ah,
non-compliance of office objection.
ah.
Yeah, so raise the office objection regarding the delay in recalling knowledge. I correct it.
So you comply with it. Huh? The petitioner permitted to comply with the office objections. Yes.
Please, 8 also same.
Huh?
8 also same.
8 also same. Yes. You want a date? We'll fix a date.
Please, madam.
Relist on date code. 29. In the interregnum, office objection to be complied with.
Please.
Number 9, Subhash Mallapur.
It's maybe taken next week, madam. It's a case where your lordship had heard and had asked me to withdraw the writ petition, my lord. I have sent the intimation, my lord, sorry, not respond. Innu respond ಮಾಡಿ.
ಅಲ್ಲ ಒಪಿನಿಯನ್ ಫಿಟ್ ಫಾರ್ ಅಪೀಲ್ ಅಂತ ಮಾಡಿದ್ರೆ ಹೇಗ್ ಮಾಡಿದ್ರು?
ಅವ್ರು ಮಾಡಿದ್ರು.
ಅವಾಗ ಕರೆಕ್ಟ್. ಅವ್ರ ಒಪಿನಿಯನ್ ಕೊಡುವಾಗ they had mentioned is it's a case fit for
Yes.
ಹಾಕಿದ್ರು.
ಹೌದು.
Okay, you tell us now. We'll
Oh,
discuss
I
it,
have
but-
no locus standards.
Huh?
Locus standing. The matter has been remanded to the authority who had, my lords, entrusted the entrustment order has been set aside along with the articles of charge. And they have given liberty to the competent authority to take necessary steps, my lords. So I don't have locus standing. I have suffered an order with this regard.
Now you take, just tell us the brief facts, at least to dictate facts here.
Notes that the,
Otherwise, just read the order of the KAT, that is sufficient. We'll dictate it.
Yes.
Page 46, just read it. Take us through the order.
my lords, he was working as, my lords,
Just read the order, small order. 7 pages order, you read it, the whole facts will come out.
filed by one.
46.
Both applications are under section 19 to set aside the impugned order dated 17/1/2017 passed by the first respondent as annexure A.
No.
Yes.
You're reading at page, which page?
At page number 11, man. Brief,
No,
may I
you
read
read
the
the-
para 4, I will. The brief acts that both the applicants
Huh.
are,
From para 3 you read.
the application number 311/18 is filed by one Vijay Kumar Dandappa Halkodi. In application number 310 is filed by one Srishalappa Gurupadappa Sharsetti. Both application are under section 19 of so and so. Praying for tribunal to set aside the impugned order dated 17/1/2017 passed by the first respondent produced herewith as annexure. In both the application, the article of charge issued by Lokaयुcta dated 6/4/2017 by the second respondent is produced as annexure A2. both in the both application. The brief facts as pleaded in both application by the applicant are that in the first application, the investigation officer TAC of the Lokayukta submitted a report that binding content of asphaltate of the road was due to that the potholes were formed. The said work was executed during the year 2010 and 10-11 and 11-12 within the limits of Bijapur subdivision. The allegation was that the potholes were reoccurred and surfaced in the other area where the work was not executed. On the basis of the said report, on the basis of the said report, government passed an order entrusting the inquiry to the Honorable Lokayukta by its order dated 17/1/2017 to conduct departmental inquiry and submit report against the applicants and others. There is no application of mind while passing the order. In pursuant to the said order, the additional register Inquiry 3 Karnataka Lokayukta issued articles of charge on 6/4/2017 without following the due process of law. Therefore, being agreed by the order passed by the government under Rule 14A of Civil Service CCA rules, and also issuance of article of charge, also challenging the same on the ground as mentioned in the application. Both applications are before the Honorable Court.
The present petition has been filed by the.
May I read that? Seventh para, it will be helpful. Seventh para.
No, I've read it. The present
On
petition.
perusing the pleadings of the said application.
I've read it. The present petition has been filed by the Lokayukta, calling in question the correctness of the order passed by the tribunal in application number. You have filed against both, against both.
Here only one minute. The other Gurupatappa has not.
ಅದೇನಾಗಿದೆ ಇನ್ನೊಂದು
ಅದು ನಂಬರ್ ತೊಂಬರ್
ಅದು ಇದೆಯಾ
ಇದು ಇಡು.
ನಾವು ಅದು ಇನ್ನೊಂದು ನಂಬರ್ ಹೇಳಿ ಅದು ಮಲಾಪುರ್.
I don't have the number.
ಅಲ್ಲ, you have filed it, isn't it?
I have filed.
Correct. So what you do, we'll have it tomorrow. You give the number to the court officer. Huh? We'll have it tomorrow and dispose of by a common note. You have filed, isn't it?
Day after tomorrow, I'll check and answer.
No, correct. We'll pass over, you find out.
Yes.
If you have not filed, we'll dispose this.
Oh, Manoj, I have filed, Manoj, I'll get the number because both have been. Check. Application number 310. 310.
ರಿಜಿಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಮಲ್ಲಾಪುರ ಅವರೇ?
Yes.
ರಿಜಿಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಆಫೀಸಲ್ಲಿ?
ಮಾಡಿದ್ದು ಸರ್.
ಮತ್ತೆ ಅದರಲ್ಲಿ ಇದನ್ನು ನೋಡುವಾಗ ಆ ಫೈಲ್ ಕೂಡ ಇರ್ತದೆ ಗೊತ್ತಾಗಲ್ವಾ? ನೀವೇ ಹೇಳ್ಬೇಕು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಯುವರ್ ಡ್ಯೂಟಿ.
Yes, I'm sorry.
ಇನ್ಫಾರ್ಮ್ ದ ಕೋರ್ಟ್ ಏನೇನು ಹಾಕಿದೆ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ ಅಂತ.
2:30 ಬರುತ್ತೆ sir.
Pass over.
2:30. 2:30.
ಅದಿದ್ರೆ
Yes.
we'll list and discuss.
Yes.
Number 10, Ravi B. Patil.
Lordship, yesterday, Lordship,
Correct.
I have furnished the
PF.
correct address of the respondent number 7.
But
Today I
PF
will pay the PF. Lordship.
because the interim order was conditional on payment of process.
Yes.
So now you pay the process and you file a memo for extension, we'll extend it. You have a look at the order sheet, pass over or
Yes.
close. In the order sheet,
I have gone through.
it was mentioned that
Yes, Your Lordship.
if we'll extend it only if you pay process.
Yeah.
Now address is furnished. So process you furnish it and you come and make a submission, file a memo for extension, we'll extend the interim order.
Yes, Your
Huh?
Lordship. The Lordship, there is a memo filed by the appellant Lordship on 18
Correct.
January 2023. I'm not pressing this memo.
Memo for?
Memo for furnishing correct address Lordship. Earlier I have filed on 18th
No,
18
correct, but,
January 2023.
Now to which address notice must go now?
Yesterday itself I have filed a fresh memo.
Fine, correct.
Yes, Your
So
Lordship.
process fee you pay, you come back and I file a memo for extension, we'll do. Have a look at the order sheet.
Okay.
Pass over.
Number 11, Ramachandra K.
I am for complainant, my lord.
GA accepts.
My lord,
1, 2.
I am for complainant.
Yes.
I filing the memo my lord, along with the documents, my lord. Their contention, my lord, 4-1 notification, my lord, 2 acre 30 gunta was acquired of the complainant land. In the 6 notification, my lord, that is reduced to 1 acre 30 gunta.
4-1 is 2 acres,
2 acres 30 gunta.
3-0.
Yes, my lord.
Ah,
Thereafter, my lord, 6-1, my lord, we restricted only, my lord, 1 acre 30 gunta.
1 acre, 30.
30
gunta.
gunta.
So you
So-
left out 1 acre.
Yes, my lord. But he is asking, my lord, 2 acres 30 gunta. He is not entitled.
What is the direction passed?
Consider the representation of the lord. For payment
Their
of the,
representation they wanted for the entire extent.
yes, my lord.
Now they have filed the affidavit.
Please,
You
my
have a look at it. We'll have it
Please.
tomorrow. We'll have it tomorrow. Have a look at it.
please, my lord.
You must collect it from the government advocate.
Please, my lord.
GA
Kindly have day after tomorrow, my lord. Kindly have day
with
after.
enclosure. Release the matter day after tomorrow.
Please.
Please, my lord.
Number 12, Manure Ashok Kumar.
Counsel for the complaint has filed a memo for withdrawal, which reads as follows. In light of the same, the proceedings are dropped.
Number 30, NS Deshpande. Santosh A.
I will notice consider. Notice consider. यार संतोष इधर हाँ और कर ले इधर साइड no representation on behalf of the petitioner. It's the counsel and Sri N.S. Deshpande filed his memo for retirement. However, Santosh A still continues on wakalat. Made clear if there is no.
My lord, NS Deshpande is no more. The Santosh and NS Deshpande, they are of colleagues, one office.
So both have filed a memo.
Yes. The Santosh hacker.
ಏನ್ ಬೇಡ ಇದೆ ಅವ್ರು ಬರ್ಲಿ ಅವರು What the number is there? No, phone number. Pass over. Unless the engineer looking for the permission. Yes.
Till number 30, 40, Sangana Basawabi party.
Each time granted to take steps. Yes.
Number 50, Deepak Bharat.
In this, both the appeals, the single judge order has been questioned, my lord. There is a delay in filing the appeal. Lord's, my lord,
Delay in 15.1.
yes, in both the appeals, there is
One
delay
appeal.
of few days, 30 days in one appeal, my lord. In another appeal.
Condone the delay.
Yes,
The IA.
And I have filed a application for dispensation of translated copies as well.
So where is your IA in 15? Where is the IA for condonation of delay in 15? Only in 15.1 it is there.
one day, in one matter it is posted.
In 15.1.
Yes.
IA for condonation of delay is allowed,
Yes.
excepting cause shown.
Yes.
In serial number 15, IA 2 of 24 is allowed and petition and appellant is dispensed with production of translated copies for the present. Similarly, IA 3 of 2024 and 15.1 is also allowed and appellant is dispensed with production of translated copies of annexures mentioned in the application for the present.
My lords,
Then-
my lords,
The short accommodation.
urgency, my lord, let the accommodation may be given, but there is some urgency, my lord. What has happened? I have purchased from decree, my lord, 2 portions I have purchased. Another purchase was in 18. All the 3 bit of lands were purchased by registered sale deed. Subsequently, my lord, I had made an application for Urban Development Authority for amalgamation. I took a permission from the corporation for construction. That was obtained. Subsequently, after lapse of 1 year, when I commenced construction, it was about for the structure, my lord. Structure was already finished. The adjacent landowner files an application to the authorities, Urban Development Authority, that amalgamation granted is not correct, since I have the right to weigh. And he files suit also, my lord, right to easementary. The suit was pending consideration. The Urban Development Authority inquires into my title, my lord, and gives the finding to the effect that, my lord, since my vendor had not having clear title, that's why the amalgamation granted is not correct. That I had questioned before the learned single judge. Learned single judge, my lord, in the first matter, had remanded back the matter to the authorities to an effect that the document has to be produced, and thereafter, after subsequent to that, the order has to be passed. My lord, I had filed that order, I had questioned in first writ appeal. Subsequent to the remand, my lord, the authorities came to the same conclusion that, my lord, the amalgamation granted is not correct, since there is a defect in a title. My only submission is that, my lord, once the amalgamation is granted by the authority, my lord, they cannot review their own order. And thereafter, my lord,
So how much time the order was reviewed?
my lord, thrice, my lord. Once they suspend temporarily, thereafter, my lord, in order to get rid of the litigation, since my already structure is there, I have constructed the substantial.
Already constructed.
Yes, my lord. Substantial construction has been over, my lord. Now, my lord, in order to get rid of that, my lord, I had made an undertaking to the effect that, my lord, I will leave 10.6 feet of my space in a cellar portion for way to the adjacent owner. For that also, my lord, the first instance, my lord, he agreed. Subsequently, my lord, again he
Appears for the authority.
Yes, myself, your lordship.
You appear for the authority.
Urban Development Authority.
Ah.
I will get the instructions because before this honorable single judge, I was not appearing.
No, correct,
So
sir.
yes.
Once administrative power is exercised,
Yes,
there is no power to review exercise of administrative power.
yes,
Suppose you have granted a license,
yes,
passed an order, unless the statute provides
yes.
that you have the power to revoke. Normally, you can't do it. That's the first principle. Examine it.
Yes,
Now, meanwhile, if there's a suit pending, it has to be trashed out in the suit. Yes. Suppose they ask mandatory injunction, you demolish it, give right away, he's bound by it.
Whatever the result of the suit, I am
Examine
binding.
it.
Yes.
Because that's how
Now, my lord.
has to be looked at. Though we'll enter into the merits.
No.
We'll have it next week.
Now, what has happened, my lord, due to the cancellation of my amalgamation, my lord, my construction permission has also been cancelled. The time being, it has been stayed. Now, this is a scenario, my lord. Again, the fourth respondent, who is a private party, makes an application to the corporation to effect that my notation entry, which has been made in my name, it has to be for cancellation. Now, the corporation has started initiating for cancellation of my notation entry on the basis of this.
Which respondent number?
3.
Number 3.
Who appeared?
I apply.
You can't do that. How can you?
Verify, my lord. Copies are stored and they posted. I'll verify.
No, at least we'll stay that. Until we decide this, you can't do that.
That is not a part of the writ. That is not part of the writ appeal, because after subsequent to filing of the.
Then you seek for direction.
But
We
now,
will
my
take
lord,
up the matter
my
on
lord,
merits.
my only submission is.
No, we'll take it up on merits next week.
I am not having that.
Whatever interim direction you want, also you ask.
Now, only submission is that, my lord, if the stay of amalgamation order, which is subsequently passed, that is stayed. All
Everything
the
else will-
consequent, let that accommodation be given on merits, I am ready on any date. In second matter, my lord, if the stay is granted for time being also, my subsequent proceedings will be stopped. That is the only apprehension of mine.
No, but then your construction is not complete.
No, I will, my lord, till the disposal of the, let there may be observation, my lord, till disposal of the matter on merits, I may be.
Who appears for the private party?
Private party have served the copy, my lord, as per the direction of this court. And my lord, he has not appeared. And I have served the copy as well.
Notice
also is
was.
Yes, notice also is there. I have served the copy.
420 ಹೋಗಿತ್ತಾ R4 ಗೆ?
He had been directed to serve, I have been directed to serve the counsel who was appearing in a writ petition, my lord. I had served the copy. I have intimated him also, my lord. I am copy of the writ petition, both writ appeals have been served.
He appeared in the writ proceeding.
Yes.
Now you are seeking interim relief in 15.1.
Yes. My lord, the subsequent writ appeal, learned single judge has only observed that, my lord, since earlier coordinate bench has given a finding to the effect that, my lord, the opportunity given to the respondent authority for rehearing, I cannot give any fresh finding on that. Let the matter may be decided by this court. Since I had mentioned writ appeal pending of that remand order also. There was no order on merits, my lord, in subsequent 15.1 order, 15 point writ appeal. May I take to?
No. Now the court has only permitted revisiting of that order.
Yes, may I take to?
The court has permitted the authority to revisit
my lord.
of amalgamation.
Yes. Thereafter, my lord, in subsequently, my lord, afterwards, as it is cancellation of amalgamation was made. I filed a writ petition challenging that also, my lord. The subsequent writ petition 15.1, the learned single judge observed that since earlier coordinate bench has interfered in that matter, now that is pending before this honorable court, and let the matter may be heard along with this. May I take to page 21?
No, so that WA 200125 is 15.
125 is 15 years. Yes.
Correct. So what is that and what is this?
Yes, madam. The earlier order, which was remanded back to the authorities, that was challenged. It pending consideration, my lord. It was not brought before the division bench. In the meanwhile, my lord, the authorities confirmed the order of cancellation.
Where is the finding on merits of that order? Which is second writ? In 201847, In WP 201847,
Yes. Yes.
In WP 201847, court only says right is there. But where is the finding that the order is correct?
Yes.
Now, which is that order now?
Uh,
Which is the order of the authority?
After remand, Milord.
Yes, after remand.
Yes, annexures, yes, Milord.
Annexure
Yes, 176 page in sub 15.1, 200312.
70.
176. Milord. Operative portion is 179
So
operative.
that 9724 you are seeking stay.
Yes.
Isn't it?
Yes.
We'll stay that 9724, let us. In WA 200312, the appellant is challenged the order passed by the learned single judge in WP 201847 of 24. The learned single judge had upheld the contention of the respondents to the effect that the authority which issued the amalgamation order could revisit the order in light of the observation at para 9 of the order dated 29/5/2024, extracted at para 3 of the order in WP 201847 of 2024. Counsel for the appellant submits that civil suit
Yes.
is pending between the parties.
Yes.
Regarding right of way, and accordingly, the authority could not enter into such aspect, which is a matter pending consideration before the civil court. In light of said contention raised, there would be stay of the order dated 9/7/24.
Yes.
At annexure.
Yes. Annexure, yes.
At annexure S.
Yes.
Now you undertake not to put further construction
Yes.
till the next day.
Till next date of hearing.
Correct.
On merits, if it is taken.
Matter to be heard on merits. Counsel for the appellant submits that he would not put up construction till the next date. Deal is the matter on.
It may have it in first week of the 5th, it may be more convenient.
On problems. Now you have a look at it.
Yes.
What is the suppression he has made?
Yes.
And if the matter suit is there between the parties, then let them fight it out in the suit. Have a look at it.
Much.
Number 60, Arun Kumar Amaragandappa.
Uh, 15.1 ಅಲ್ಲಿ 1 of 24 ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ವಾ?
16, my lord, serial number.
Yes.
I appear for complainant. In fact,
In this matter, my lord, I have drafted the, my lord, counter affidavit. I have sent back last week only. And in turn, Kalaburagi Urban Development Authority sent to the Urban Development Secretary, Bangalore. ನಿನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ದೆ ರಾತ್ರಿ. ಇವತ್ತು we are getting the counter affidavit.
I will file in the meantime, after serving the other side, I file in the counter, my lord.
Relist the matter on next week date. 29th.
Please, my lord.
Number 70, Ratnayan Shivayogi Mutt.
File, one, akade.
I need password.
Pass.
Bill number 18, Mahesh Patil.
Today needful done, my lord.
Counsel for the petitioner submits needful is attended to office to verify and issue notice. Next.
Number 19, Kuleppa Heru.
Petitioner, my lord.
What is the office objection?
Our annexure A1 is not legible. It is not relevant for me. Kindly,
Counsel for the petitioner undertakes that if document number A1, if annexure A1
yes,
is relied on at the time of hearing, legible copy would be produced. In light of the same, office objection is kept in abeyance.
yes.
What is the matter?
My lord, in this, my lord, annexure A3, page number 17. I am a Urdu teacher. I am asked to teach mathematics.
ಇದು ಹೋದ್ ಸತಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ?
And my lords have already held that covered by decision.
Okay, you take notice.
KT has disposed of the application directing respondent to consider my representation without setting aside annexure. That is the only small point. Unless it is set aside.
You have a copy.
My lord's order is there.
No, correct. Just one. You have a look at it.
Please,
We'll have it on Thursday. We have passed order. He's only seeking setting aside.
That's all.
Have a look at it.
Copy.
ಕೊಟ್ಟಿದ್ದೀನಿ ಮತ್ತೆ ಕೊಡ್ತೀನಿ.
ಇದಲ್ಲ ಆರ್ಡರ್ ಕಾಪಿ.
ಆರ್ಡರ್ ಕಾಪಿನಾ? Allowed will operative portion annexure. Page number 5 is operative portion.
Now, meanwhile, you have to be given a posting, isn't it?
Not.
Meanwhile, you have to be given a posting where there's Urdu
Yes.
in a different college.
Yes.
So that you find out.
Yes. Yes. Let them find out.
Meanwhile,
ready.
you find out where the vacancy is. Have a look at the papers. You can't compel him to do mathematics.
Yes, madam. When he is Urdu, he has to teach Urdu only.
So,
Yes.
so that have a look at it, and where you are going to give him a posting, you'll have to.
Please, madam. For wherever Urdu, my lord, posts are there, he has to be accommodated.
Yes.
I'll go through and submit, madam, Thursday.
Thursday.
Please, madam.
Yeah.
I take notice for all the.
He accepts notice for respondents.
All respondents.
For the respondents. Release the matter on Thursday.
Please, madam.
We'll dispose it of.
Next matter is also same.
Same,
same.
same.
Kindly, formally,
Telephonically you find out.
Please.
Huh? He's
Form-
got a lot of clients, Urdu clients. ಅಲ್ಲ ಇರ್ಲಿ ಅದೇನಿಲ್ಲ ಸುಮ್ನೆ ಹೇಳ್ತಿದೀವಿ ಅಷ್ಟೇ.
formally, appeal subjection may be overruled.
The same order in 20.
Great.
ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕಾದ್ರೆ ಒತ್ತಡ ಮಾಡಿ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ, ಆಮೇಲೆ ಇದನ್ನು ಕೊಟ್ಟಿವಿ ಎಲ್ಲ.
Day after tomorrow, my lord.
Yes.
Great. Correct.
Gentry.
My lord. I have filed the synopsis, my lord. Your lordship directed me to submit the synopsis of the case. It's a discharge after a lapse of 12 years, my lord. Discharge from service.
Synopsis, sir?
Yes, my lord, I have produced, I have submitted, my lord.
How much time you'll take?
Madam, 15, 20 minutes. Sir.
I seek small accommodation, file your ಬೆಳಿಗ್ಗೆ file ನಿನ್ನೆ ಸಿಕ್ಕಿಲ್ಲ, I have to go through the synopsis and the file.
Go through, we'll fix a date. On the next date, we can.
Please, madam.
So we'll fix a date and next date we'll dispose. What is the point involved?
My lord, the issue is, my lord, that the order of discharge is a stigmatic order.
Yes.
My lord, and secondly, my lord, initially I had approached the tribunal, but the tribunal noticing that the prior approval of the higher authority has not been obtained, but direction were issued to the respondents to, my lord, obtain the prior approval. In the meantime, my lord, I approached the honorable court in WP, my lord, in WP 202928 of 22. Lord, during the pendency of that writ petition, my lord, once again the petitioner was discharged from service, placing reliance on the judgment of the tribunal. Even before the order, there are certain observations made by the honorable court in the order 9/11/2022, my lord, which your lordship may guide. That is at page annexure A12, my lord.
Page?
Annexure A12 is at page 99, my lord.
This is the order of the
the honorable court, my lord, in the first round of litigation against the order of the tribunal, I had approached this honorable court, my lord.
annexure.
A9, my lord, page 88, my lord, 86, my lord.
What was the observation?
Lord, your lordship, we will get it at page 92, my lord. Para 10, my lord. Under the aforesaid circumstances, the petition is disposed of, reserving liberty to the respondents to consider the declaration of the probation of the petitioner by discharge strictly in accordance with the Karnataka KCS probation rules 1977. The period of absence of the petitioner from the date of his relief under annexure A12 dated 17/1/22 till his reinstatement by virtue of the interim order of the tribunal shall be treated as leave, extraordinary leave, admissible to him. But this order was passed on 16/11/22, my lord. But the order was released only on 8/12/22. Now, before this order could be released, my lord, by another order, my lord, on 24/11/22, annexure A12 is passed, my lord.
Now A12 is passed on
My lord, this is passed on 24/11/22.
24/11/22. They reject your probation.
Yes, my lord. Once again, they rejected the probation, stating that they have obtained the approval of the higher authorities.
So you are saying this A12 has to be reconsidered in light of observation of the
Observation
division.
made by the honorable court.
Only on that point.
That is the first point, my lord. Secondly, my lord, the order of discharge itself, before the tribunal, I had raised this point. And second point that was raised was that the impugned order is a stigmatic order. My lord, the observation of the full bench of this honorable court, my lord, I have produced along with the memo, the judgment of 1996 SCC online Karnataka 552. Lordship got the judgment, my lord?
Just 1 minute. Now the punishment imposed.
Yes.
In the DE.
Yes.
Was not a subject matter of
No,
proceedings. Now they have taken note of that, isn't it?
Yes, but that could not have been is the observation of the full bench, my lord, which I am relying on 1996 SCC online Karnataka 552.
What does it say?
Para 19, my lord.
You have produced it along with your
Memo, my lord.
What is the judgment?
This is YN Krishnamurthy versus Karnataka Silk Industries Corporation Limited.
Citation,
Now, 1996 SCC online, Karnataka 552.
what does it say?
But it says that even if the past conduct is to be taken, shown while discharging him, but it would amount to a stigmatic order and it is not a termination simpliciter.
No, but now we are
19,
correct. We are now only on the question of completion of probation, isn't it?
Yes, my lord. My lord, what the authorities say is that I should have submitted application seeking declaration of probation. That is not so. Rule does not say that the government servant has to submit his proposal. The notice that was issued is that I have not submitted the proposal. That cannot be.
So no, just 1 minute. Now, so you are saying that if probation is not completed,
yes,
then the discharge cannot be with observation, is it?
Yes, madam. That is stigmatic. It would be a stigmatic observation. Your Lordship may kindly see para 19 of the judgment, madam.
We don't have the judgment.
Madam, my colleague has.
In synopsis, my lord.
I have given.
Page?
Page number 77, my lord. The judgment.
Para 19 of the judgment, my lord.
Paragraph?
Para 19, my lord.
No, but in the probation rules,
yes,
there is a stipulation that you have to mention the ground on which probation is not being completed, isn't it?
No, it is only they should say that this one is not satisfactory.
No, which is that rule? Which is the rule for regarding probation?
KCS probation rules 1977, no?
No, correct. So what we are saying, somewhere we came across that the ground of discharge may have to be mentioned in case of discharge.
But ground of discharge should be a discharge simply. What the observation of the court is that, my lord, the discharge should be a discharge simpliciter and it should not be
paragraph. Paragraph.
Para 19, my lord.
19.
Yes, ma'am.
Yes, read.
On an analysis of judgments referred to herein above, and on the basis of submission made on behalf of the parties, it can be said that the service of a temporary employee or an employee on probation can be terminated without holding inquiry or complying with the principles of natural justice if such termination, removal, or discharge is the result of consideration pertaining to the misconduct or lapses of the concerned employee. The purpose is that once the services are sought to be terminated as no more required, no punishment can be inferred to have been inflicted upon such employee. However, if the order of termination is based upon allegations amounting to stigma upon the appellant in relation to his employment, the holding of inquiry and the compliance of natural justice cannot be abandoned or forsaken. The employee cannot be handed over an order of discharge containing therein the allegations of misconduct or such imputation amounting to misconduct, which may adversely affect him in getting future employment. This is very important, my lord.
No, correct. But there was an inquiry, isn't it?
But the inquiry was there, and I have been inflicted with a penalty.
Correct.
But that cannot be a ground, my lord, to discharge me again.
No, but now, which is that rule under the Probation Act? Probation rules?
1977 rules, my lord.
6. 6. There is one judgment of the apex court. I'll give it to the court officer.
Please,
I'll give it. From Karnataka, it went before the apex court, same rule. The question that is raised was identical to what you are raising. The apex court has held under the rule, you have to mention the ground and then upheld the order of discharge, though the ground is stated that you are liable for misconduct. I'll give it to the court officer. We'll have it next week. Have a look at it.
Please.
There's a judgment of the apex court on the very rule.
Please, ma'am. But my only submission is this, my lord, the discharge should be discharge simpliciter. On the face of it, it should show.
Correct. That very point is considered. Have a look at the judgment. Have a
Please.
look at. You have a look at that because that appears to indicate that you have to mention the ground in terms of the rules. You have
But
to
I
mention
agree with my lord, that is a settled principle that a ground has to be mentioned. But that ground cannot be a ground which will deny him employment in future. That is what is the observation of full bench of this honorable court in Krishnamurthy's case.
Let us have a look. You have a look at the judgment. Get ready. Relist the matter. Relist the matter on first week and date. 5th.
Please.
Twenty-two. Sanjay Patil.
Miller's pass. Can pass.
Really, he was not on bail throughout. For the time being, I will not press, appeal may be admitted. But one thing is there, glaring error is there that the trial court did not give opportunity to hear on sentence. Page 74 ತಾವು ನೋಡಿದ್ರೆ. What the court says is, I have punished you for 302. The minimum sentence is life. Hence, you do not come under the Probation of Offenders Act. So, I need not hear you on sentence. Internal page 66 ಅಲ್ಲಿ.
There is no hear on sentence. Huh?
No hearing on.
Even otherwise minimum sentence. They not.
Allah, but the CRPC provides the.
It is there, that staging.
You cannot bypass the statute. Minimum sentence irbodu, but the conviction, after conviction.
It matters.
Not sentence. Of course, in other offences it may matter because it may lesser down.
Once the accused is convicted for 302.
Lesser down.
Admittedly, PO actually baralla.
Baralla. Life. I will file a memo to that extent that I will not press IA.
Third, admit. Registry is directed to secure the trial court records. Law counsel for the appellant files a memo.
I'll file.
So stating that is not pressing the IA.
For the present. There was one submission. 36.
Yes.
ನಾನು ನಾಳೆ ನಾಡಿದ್ದು ಆಗಲ್ಲ, ಮದುವೆ ಇದೆ ಮನೆಯಲ್ಲಿ. Any day minutes from.
You must block the date.
25th minutes.
That day will not take up any other.
Yes. 25th.
Synopsis must be ready.
I will do it.
Because this is the only one matter remaining, 9 year sentence. So 25th miss.
Yes.
Day number ಕೊಟ್ಬಿಡಿ. Number ತಗೊಳ್ಬೇಡಿ. Monday.
27. ನನಗೂ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ.
27th Monday.
Very well.
Phone number.
ಇದೆ ಸರ್, ಮಾಡಿದ್ರು ನಿನ್ನೆ ಮಾಡಿದ್ದಾರೆ. I told him that there is marriage in the house.
ನಿಮ್ದೆ ತಗೊಳ್ತೀವಿ, ಬೇರೆ ನಿಮ್ದೆ ತಗೊಳ್ತೀವಿ.
It's a short, it's a short matter. I will just brief your lordships in 10 minutes. Dying declaration ಇದೆ. ಮತ್ತೆ it may fall lesser than 302. She herself pours kerosene, goes in search of a matchbox. This husband will be there. He would say that ನೀ ಯಾಕೆ ಹಚ್ತೀಯ, ನಾನೇ ಹಚ್ತೀನಿ ಅಂತ ಹಚ್ತೀನಿ. All is the dying. If we believe dying declaration, it stands only on dying declaration because all of the eyewitnesses have turned hostile.
Only on dying.
Only on dying declaration.
Certificate ಕೊಟ್ಟಿದ್ದಾರಾ?
Fitness certificate ಇರೋದು ಈಗ issue. That is the issue as per 2022 judgment. Whether it requires, because 80% burn injuries, and the earlier doctor who treated her would not say anything. To a primary health center, she was shifted first.
recent judgment of the apex court that even 90% also, 95.
It depends on the part where the body has, I do agree, that is there. 100% idru ಆಗತ್ತೆ, but lips adu idu.
But law is summarized that in Irfan Naka case, you just go through that.
I will go.
Irfan Naka case. Irfan Naka was a state of UP. Just go through that, let us see.
Much. 27th.
So 27th will take up.
Yes.
Because only 9 years idu nimdu ಮಾತ್ರ
Yes.
ಉಳಿಯುತ್ತೆ.
Yes.
ಅದಕ್ಕೋಸ್ಕರ will-
Yes.
ಎಷ್ಟು ಇದೆ?
Number 23, Vishal Pratap
23,
Singh.
password, 230 L fellow.
Seal number 24, Government Advocate. Seal number 24.
This will be taken on Monday, my lord. In similar matters, it was decided, if possession is taken 25%,
Release start
subject to.
Monday.
The earlier order copy I will produce.
Seal number 25,
Please, your lordship.
yeah.
Yes,
Am I audible, lordship?
yes, yes.
Lordship, this is a matter under GST law, lords.
Yes. Yes, what is the issue?
No, lordship, in this, the issue is there was a notification issued for extension of the time limit for the adjudication laws under section 168 capital A.
Just 1 minute, just 1 minute. Who appears in tax matters?
For the state, my lord, we are
Advocate General is there.
Huh?
Additional Advocate
My
General.
lord, for the state, my lord, we are representing the matter. May I take a 1 minute time of your lordship, my lord? This is, my lord, my lordship is aware that the COVID period, time limitation for the passing of the assessment order, there is a prescribed time granted under the act to the assessing authority for the period of 2.5 to 3 years, like that. In this COVID period is a 3 months extended by way of notification by the central government, by the committee recommendations. So that was challenged by the petitioner before the 11th single judge, saying that this is the extension and time granted by the central government for the assessing authority, given the time for the period of completing assessment order period. That was challenged. That was dismissed the writ petition. Against that, my lord, so writ appeal is filed. So time granted by the central government by way of notification on the basis of the recommendation given by the committee of the central government, because in the COVID period, there was an exemption time is given to the assessee. So therefore, the time exemption given in the meantime that 1 year they are not working as assessing officer, that period for 3 months they are extended the time for the completion of the assessment order. During the COVID period, the assessing authority cannot be passed an assessment order as per the central government order. So therefore, the time has been extended now. So that was challenged by the petitioner.
Let us see. Yes, appellant, what is the point?
Lordship, may please refer to section 168 capital A, my lords.
No, you tell us the facts. Tell us the facts.
Lordship, Lordship, I am one of the subcontractors, my lords, wherein I am providing the contract services. What has happened is that they have issued a pre-intimation notice to me in DRC 01 capital A. My lords, may please see that at page number 214, my lords. 207, it starts from 207, DRC 01 capital A, Annexure J. What is thereafter, DRC 01 is an opportunity under Rule 142 1A as a pre-intimation show cause, my lords. Thereafter, my lords, we have filed a reply which starts from page number 214. Then, my lords, in the interregnum period, we approached this honorable court and we got an interim stay, my lords, which is there at page number 228. Now, on the date when we got the interim stay, my lords, may please refer page 228, my lords, for a moment. The order starts from page 229. heard learned counsel so and so for the petitioner so and so, and Shri with learned counsel so and so, learned deputy solicitor general so and so and so. Then there shall be stay to the further proceedings in the show cause notice. The show cause notice was stayed, my lord. Thereafter, and the show cause notice, my lords may find at page number 143. It is dated 29th September 2023. My lords, our submission is that as per section 73, the show cause notice for the year 2017-18 was to be adjudicated by 30th September 2023. And the provision says that show cause notice must be issued at least 3 months prior, which makes it 30th June 2023. The minutes they have issued a notification, which is impugned notification, on 31st of March 2023, extending the time limit by 3 months. And this is the impugned notification, notification number 9 of 2023, page 142. That is under challenge, my lords. As per our humble submission, my lords, section 168A, under which this notification of extension has been issued, and it is the submission of my learned friend that it is issued by way of recommendation of the GST Council. Our humble submission is that it is issued for a special circumstance, my lords. Section 168A, if my lords may please refer to section 168A of the Central Goods and Services Tax Act.
GST Act.
If I may read, my lords.
Yes.
Power of government to extend time limit in special circumstances. Subsection 1, notwithstanding anything contained in this act, the government may, on the recommendations of the council by recommendation, extend the time limit specified in or prescribed or notified under this act in respect of actions which cannot be completed of compiled with due to force majeure. Lords, force majeure is defined in the explanation, lords. For the purpose of this section, the expression force majeure means a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any provision of this act. Lords, our submission is that there is no question of non-implementation of the provision of section 73. Section 73 was already in place. GST law recommends that everything needs to be filed online. The show cause notices are also issued online. Thereafter, lords, the notification issued on 31st March 2023. The COVID was over in 2021. So on 31st March 2023, extending the date till 30th September 2023 is not covered under the force majeure clause. That is what is our primary submission, lords. Then, lords, there are n number of judgments, lords, wherein multiple courts are dealing with this particular issue, lords. It's not, which is pending before many courts, and some of the courts have taken a call against us, lord. They have already adjudicated against us, wherein they have upheld the validity of this section 168A notification. And second, lord, this is first, my lord. This is the first ground. And second is, my lords, there is also violation of section 75(4). My lords, may please refer to section 75(4) for a moment.
Yes, read.
Lordship, section 75, subsection 4. One moment, lords. Lordship 6, an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty. This is one limb, lords. And therefore, or where any adverse decision is contemplated against such person. So, lords, even if you are willing to take a decision against me or an adverse decision, you are bound to give me a hearing. Wherein, my lords, in this matter, no hearing was given and the order was passed. My lords, may please refer the, I'll just point out from the annexure itself, my lords.
No, correct. Now the council is still not put on notice. Now the adjudication is done by the state authority.
State, lordship, state.
By the state authority.
By the state authority, lordship.
No, if you are saying only on the basis of opportunity of hearing, then we'll send it back. We'll keep all.
Yes, we have no objection, my lord.
Lordship
For
may do
that-
that. Lordship,
There are two parts. One, insofar as your point regarding validity of the extension, that we have to hear it.
Lordship,
That authority cannot decide, isn't it? So if on merits of your reply to the show cause notice, you want to keep this challenge in abeyance, then we can always send it back on merits while keeping this legal contention open.
Lordship may do that.
That for that concern, my lord, I think that they have filed an appeal. I don't know, my lord, but kindly the appellant has to be submit to the court whether they have filed an appeal or not. because
Lordship, no appeal.
the
has been-
direction by
No appeal has been filed, Lordship.
No, now
Well,
the challenge in the present petition is to which order? Order at annexure?
Lordship, order as page number 161, my lords, annexure C. This is the order, my lords. Annexure C, and annexure D is the summary of that order, which is DRC 07. They have issued a show cause and then they have decided it, lords.
Lord, in fact, the show cause notice issued in response to that, they are before the Assing Authority, they have appeared and filed the reply.
Lordship, that is for DRC 01A, which is pre-intimation. For show cause notice, we could not file reply. Before that, the order was passed.
No, correct. But insofar as the single judge has rejected your contention regarding extension, isn't it?
Lordship, yeah,
Yes,
Lordship,
please.
the extension was argued there, but 75/4 could not be pressed into service.
No, correct. So if the extension you are giving it up, then we can send it back and ask him to hear you on the show cause.
If
We have no
Millards-
objection, my lord.
Millards may send me back for the fresh adjudication and give me the liberty to challenge extension if it is necessary. We will not be pressing upon service at this point in time, Lords.
No, my lord, my humble submission in this regard, my lord, if you have given up this with regard to the section amendment, then we have no objection to be as a principle of natural justice, you can get it before the Assing Authority and directions of this honorable court, my lord, within the time limitation, we are going to be pass an order.
Now,
My lord, if he is going to be challenging that in the future, then now we are going to be praise this honorable court to decide on merit of the case on with regard to the amendment.
now
Amendment issue.
counsel, you may have to take a stand. Now, if it is only 75/4,
Lordship,
we may permit you to go back.
Lordship pleases.
However, your challenge regarding extension then will go. Otherwise, you have to wait outcome of this, that you take a call. Now, if
Lordship, can I seek instructions and come back
Yes.
at 2:30?
sure, we'll
I'll
have
do
it
that.
tomorrow. We'll have it tomorrow or 2:30.
2:30, Lordship, 2:30 today.
If you are giving up your challenge, so
Lordship,
far as the order of extension,
Lordship pleases.
then under 75/4,
Lordship pleases.
we'll ask them to give you an opportunity of hearing and reopen it and send it.
Lordship pleases. I'll seek instructions and come back, Lordship, at 2:30.
Pass.
Oblige, Lordship.
Subash?
Yes.
Insurance appeal, my lords, it's a case of no policy.
Ah.
My lords, there is a delay of 596 days, my lords. I am ready to deposit entire amount. I'm ready to I'm ready, attachment, entire amount I will deposit before this court.
ಎಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು 1.5 year ಎಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು?
ಆಮೇಲೆ ರಿಯಲೈಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ 2016 ಅಲ್ಲಿ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆ, ಇದ್ರ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ.
ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀವಿ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ. 1.5 years ನೀವು ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮಾಡಿ
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ really on 31st. The meantime, council permitted to send the copy to the council.
Yes,
For the
Council of
climate, before the executive court.
First or serial number 1.
Yes,
My lords.
yes, what is your stand? What is your stand?
My lord, since I have parties are present and I have suggested them, since the writ petition was dismissed and the petitioner who is challenging the order of the writ petition and there is no infirmity in the order of the single judge also, my lord. There is already a second motion was moved and today is the
Now,
motion.
the only point that he's raising is that under 49(1), it has to be a motion simpliciter.
Simpliciter.
Here, there are allegations. That's the only point. How we are going to get across that?
Please, my lord. Since there is the subsection 2 has been omitted entirely, yes. And
Then you withdraw the allegation and you do it afresh.
we will file a memo before the Assistant Commissioner stating that we will not pursue the allegations, my lord. We will not press for the allegation. The Assistant Commissioner may treat the representation as a section under section 49(1).
Note is correct, so it has to be redone. Now, just look at it. As of now, there is a time limit, isn't it? From the date of presentation, etc.
Yes.
So the only way now is to withdraw and you are at liberty to
Fresh,
issue it,
fresh representation.
fresh representation in compliance with mandate under 49(1).
That will be done, my lord, but what prevents them from again approaching the High Court? That issue will also be there in.
Which issue?
If
Now,
I file, suppose I file a fresh representation, my lord.
Do it correctly, he can't. See, his options.
It is not barred him to.
No, he's hanging on a straw.
Yes,
There's
yes,
nothing,
yes.
only one straw. And that straw is made use of here. So if you do it as a one-liner,
Yes, my
there
lord.
ends the matter and the AC does according to procedure, there ends the matter.
Yes, my lord. Very recent matter, my lord. Single judge, obviously single judge matter, my lord. Yes, my lord. Here they said that even though section there is an allegation in the no confidence motion, the Assistant Commissioner will regard only under section 49(1), my lord.
No, correct. But what happens to the allegation? It will be
Allegation
stigmatized.
it will not be considered, my lord. Yes, sorry.
That we are not for that view.
Yes, my It is very recently passed, my lord.
Moreover, my lords,
No,
with
just
sub-
one. Yes. Now but how do I overrule my?
Exactly, my lord. And I have also read the lordship's judgment also, my lord. But it is in 2019, my lord, before amendment. It is very latest after amendment, my lord. That is my only submission, my lord. I do not want to go against the judgment of the lordship, my lord.
No, 49(1), even as on date, is only simplicity.
Simpliciter. But here say the Adhyaksha who enjoys the confidence of the members, saying once he lost the confidence of the member, he cannot challenge that, no, I will challenge it in court because he does not have any locus standi, my lord.
Correct,
His
sir.
only option is to face the no confidence motion.
No, that
If
is
he-
there,
Yes,
that is there.
not on allegation.
No, just one. No, you withdraw you file afresh according to law. You have
Since
to undergo-
already second, no.
What to do?
Yes, my lord.
That is because they didn't come to you. They should have spent their fees, come to you, got legal advice, how motion is to be made
Yes, my
and
lord.
proceed.
Yes, my lord. That is true, my lord. But this judgment speaks about the consequences of section.
Correct. So we'll have to consider. If we have to consider, then we have to state and then consider.
Stay means, my lord, it will take more time.
That's why, from yesterday, what are we saying?
Yes, yes, right. This is only for the information of the court.
So correct. So
Yes.
what we are saying, if this point has to be considered, it's going to take some time, maybe next week or whatever. So you take your call. If you want to do it afresh, there ends the matter. Simple. You draft it, give them advice, and the government will ask them to take action in accordance, strictly in accordance with the time schedule prescribed.
One kindly pass over, my lord, one half an hour early.
Yes, yes. It is.
Vinayak Apte?
Provision rule 6 ಅಲ್ಲಿ ಒಂದು Supreme Court judgment ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಿಂದ್ಗಡೆ ಇದೆ. Supreme Court judgment.
Not a matter of substantive with regard to issues of succession certificate, my lord.
Now you will have to give us the legal position. Now there are two things. One, that by talaq,
That's what.
what is the procedure? And two, under the KCSR, what does the rule say? And there ends the matter. Now, if a nomination is made,
We issue notice in 1997, my lord, husband, and there are no issues from the wedlock.
so correct. Now you go straight to the point. Nomination is made under the KCSR rules of the brother, isn't it? So you are saying that brother is the
Nominee, he is entitled and already he has received other benefits amounts, my lord.
No,
There is no
correct.
dispute.
correct. So there is one judgment of the Supreme Court, Usha Devi versus Sarbati Devi. Usha Devi versus Sarbati Devi. I think 1986, which says that nominee is the hand that receives. And once the nominee receives, then the nominee holds it in trust for the others.
Yes, that is law, my lord.
Correct.
He has to apportion the amount. But there is no dispute so far other brothers and sisters are concerned.
Correct. So
There is no dispute.
there will be a discharge. So now you are saying the brother may be appointed as a
Nominee.
nominee.
And she has given nomination paper and she has deleted the name of her husband. And she has also shown my name. I have produced those additional documents, my lord, before this, your lordship. She has given letter also, my lord, page number 27, my lord. Page number 27.
So which is the rule under the KCSR?
Again, the trial court has written that, my lord. But he has not referred to that section in para 8 of the impugned order.
Now under section 372 of the Indian Succession Act, clause E, 1E says, in the absence of any impediment under 370, it could be granted. 370 says, you cannot give with respect to anything subject matter of 212 and 213. What is 212 and 213? 212 is immovable property, is it?
Directed and to right to interstate property. The interstate property. So right to executor or the
So 213 is will, that doesn't
ಅದು
come.
ಬರಲ್ಲ ಸರ್.
What is 212? It says subject to 212 ಅಂತ ಇದೆ. Interstate. Now, doesn't it come under 212 then? You just look at it. What 372 says, application for such certificate is made to the district judge, setting forth the following particulars. Ali, in the absence of any impediment under 370 or any other provision of this act or any other enactment to the grant of certificate to the validity thereof if it is granted. And then 370 says succession certificate shall not be granted with respect to any debt or security. Debt or security. Only debt or security.
And even I am ready to give security also, my lord, if court orders. Sufficient surety also I am ready to submit.
But at least you should have given the family tree, isn't it? Very
My lord, those facts are mentioned, my lord, in the petition itself. 2 brothers and 1 sister.
correct evidence alli, you're the only legal heir and apart from you, there is nobody else, is it?
2 brothers and 1 sister, my lord. Those whose names are mentioned in para 3 of the petition.
But how do you exclude those from the?
Even my lord, court directs, my lord, I will also implead them.
Huh?
I will implead them, they have no objection for issuance of certificate.
Do that. Do
I will
that.
implead them. They don't have any objection because I have shown their names, my lord, in the petition itself. That one Mohiuddin is the brother and Jeenat Kausar is the sister and Abdul Jabbar is also one of the brother and one more sister is Nazmun Nisa Begum. They don't have any objection. And even after filing petition, my lord, all concerned paper publication was given. No, nobody has come forward, nobody objected. If really they were interested, my lord, somebody could have come and even otherwise, my lord, to meet ends of justice, I will impede.
Do that.
Please, my lord.
When do you want it?
Or else, my lord, I will impede them, file application to impede them as petitioners.
Yes, do that.
That is
Do
fine,
that. Do that.
along with Wakalat, my lord.
The divorce is through how was the divorce done?
My lord, exhibit P4, in 1997, he issued notice, my lord.
Exhibit P?
P4, my lord. I may permit to pass.
This is an acceptable mode.
Yes. 1997, he issued notice saying that thrice talak, 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 that was accepted by deceased.
This
Why?
practice is sufficient.
Yes. Because under personal law, no decree is required, my lord.
Okay,
As
you
it is
implead.
required under,
You implead.
please, sir.
And
Because
file a-
honestly, other benefits are concerned, my lord, I have received. My brothers and sisters, they don't have any objection. And this is amount is 20 lakhs. This is the amount. Only with regard to that amount, my lord, a petition was filed.
You implead them.
Yes, sir.
And then you file a memo with these exhibits. Let it be a part of record.
Please, sir. Date may be given, my lord.
Relist on.
Date.
ಹೇಳಿ. ಯಾವಾಗ ಹೇಳ್ತೀನಿ?
Please, sir. 30th of this month.
Huh?
30th.
30th.
Please.
Yes.
Bill number 28, Mahesh Patil.
Lord. In the second matter, I have paid the, my lord, the deficit PF today, needful done. Insofar as, my lord, notice to R4 to R7.
No, but isn't this a premature stage?
Please.
Isn't it a premature stage? Provisional list, you have come at the stage of provisional list.
No, my lord, it is with regard to selection.
Final.
Selection, yes.
Final. Then single judge has written.
They are directed to redo the entire process,
Correct. So now.
but their application is rejected. Their in respect of petitioner's case, it has been rejected, my lord, and in respect of remaining respondents, that Learned Single just found that there is discrepancy, where in some cases they have produced Kannada medium and in English. That's why there was a direction to redo the entire process.
Correct. So what has happened now?
My lord, I'll verify. RJ Busara is not keeping well. Next week it may be taken. He is appearing for
My lord, today,
KPSC.
my lord, already, my lord, needful is done. My lord, next week it may be taken.
In second matter, lordship had directed
Second
earlier
matter,
also.
my lord, both are connected.
Counsel for the appellant submits that in 28.1, needful is complete. Relist the matter on. No, correct, but I am saying now what remains now? There are two parts.
Yes.
Now, whether it is Kannada or not. Now, if you were to take record a finding that those persons who are in the provisional list have not studied Kannada, irrespective of the certificate given, then you would reject it.
Yes. But the condition says that they should have passed in English medium, English medium. English medium, they should have passed in English medium. Those who are not passed in English medium, they cannot be selected. But the petitioner's case was that some of the students who have completed degree in Kannada medium also, they have been selected. That's why the Learned Single judge
has given a
direction that it has to be done. Yes, it has to be done only in accordance with the notification where Kannada, English candidates
have happened, we have to see.
But may I submit one thing, my lord? Here, admittedly, my lord, we have studied in Kannada medium, but the notification called, my lord, is for my lord, for the my lord, students, my lord, who have, my lord, completed, my lord, English medium. My lord, what they have done, my lord.
Are you eligible? How are you eligible then?
My lord, only, my lord, that some of the, my lord, many of the, my lord, the candidates
Are also Kannada medium.
Yeah, Kannada medium.
No, correct. So far as those candidates are concerned, single judge has said you apply the rule and redo it.
Yes, my lord. Yes.
Okay. But now you have no locus standi. If you are Kannada medium, in terms of the notification, if it's English, you have no locus standi.
Yes, but post developments, what had happened, my lord, notwithstanding, my lord, even now they have operated the, my lord, the additional list. In additional list also, my lord, even, my lord, the persons who have scored, my lord, lesser marks of, my lord, the Kannada medium, even, my lord, they have been, my lord, selected even after And my lord, now even surpassing us, even my lord, the persons my lord who have scored lesser marks than us in Kannada medium, even my lord, after this my lord, the litigation, my lord, they have operated the additional my lord list.
No, that separately you have to challenge. That we can't do in this. How can we do that? Those candidates are not there before the court. You challenge it separately, we'll see. Insofar as this is concerned, single judge has said, you examine and do it. So they will do it. If they are ineligible, they will not, they can't do it.
But
If some order selection, final selection list is done, contrary to the direct, the rules, you are always at liberty to challenge it separately.
my lord, it may be taken up, my lord, once this.
Relist the matter on date. Prima facie, it would be premature. On 29.
Please.
Number 29, Mahesh Patil.
Matter here. I have filed my lord my synopsis my lord as the last date of hearing my lord.
What is this? D, is it?
Yes, my lord. And my lord, look item. On the last my lord, date, my lord, our lordship had examined for a while. And my lord, I was asked to file the my lord, the synopsis and the I filed my lord, synopsis and all the judgments also.
You take us through your ready.
What's, 28 and 29 are both same matters, my lord, sir.
Lord,
Here, where there is acquittal in the criminal case, and in the DA, they have been convicted. And the tribunal, appellate tribunal has dismissed their claim. Here in this case, my lords, even though the complainant has turned hostile, but he admits that he had given the amount.
Let us see.
Observing that, my lords,
my lord, to recall on the last date, my lord, lordship.
No, correct. You are ready. You take us.
Please. My lord, the articles of charges, my lord, at
29 and Mallapur. Mr. Mallapur, 29 and one more,
next matter.
30.
Yes, ma'am. 32. 31 and
31.
my lord, 31 is completely, my lord, I'm not on merits at all. It is, my lord, they have no, my lord, rules at that time of, my lord, that is completely on technicalities.
That's not relating to the same.
No, not at all. Not at all.
29 and 32.
My lord, here, my lord, to recall, my lord, on the last date, my lord, lordship had asked me, my lord, to argue only with regard to, my lord, evidence, no evidence or on perversity. My lord, now, my lord, it is submitted with regard to, my lord, both the proceedings, my lord. So that apart, no, my lord, I may be permitted to, my lord, submit, my lord, the evidence first in the departmental. In fact. My lord, lordship may kindly, my lord,
take us through a synopsis.
Please.
On parallel proceeding also, what is the legal position you make submission?
Please.
Parallel proceedings.
Please.
What is the up-to-date legal position that?
Yes, yes, very much.
So now tell us, what are the, take us through a synopsis.
Yes. And my lord, before that, may I point out to the, my lord, the articles of charges for a moment. My lord, at the main petition, page 40. My lord, this is the, my lord, the articles of charge. My lord, page 41 is the relevant portion. Page 41. And my lord, the main sum and substance, my lord, of the articles of charges, my lord, is, my lord, in the last, my lord, last 4 lines of the, my lord, page 41.
Entire para has to be read, then it is correct.
Yes, I will read, but my lord, only, my lord, it must not be, my lord, time consuming. Only, my lord, you DGO demanded and accepted the bribe on so and so to do an official act. That is the, my lord, the sum and substance. Demand and acceptance, my lord, to do an official favor. That is, my lord, precisely.
Yes.
Now, my lord, the lordship may kindly, my lord, thereafter, my lord, even in the criminal proceedings, my lord, at page 52, 50, 51, 52. Page, sorry, my lord, page 71, in page 71.
$70.
71.
Huh.
My lord, the accused is hereby acquitted for the offences punishable under section 7 and 13. 1D read with section 13(2) of the Prevention of Corruption Act 1988. So I was, my lord, acquitted. And lordship may also notice, my lord, on the very next page at page 53.
The findings in that case, what are the findings?
My lord, in the departmental inquiry.
No, in the local 6 of 2013. In the criminal case.
Yes, my lord.
What are the findings?
My lord, it is, my lord, page 71.
No, correct. So we are saying.
Yes, my lord. Yes, my lord. Page 51.
Complaint has
Page
turned
51.
hostile. The complaint has
will,
turned hostile.
Well, page 51.
That the prosecution failed beyond reasonable.
May I, page 51, para
Ah.
32.
Para?
50, para 32, page 51.
Page number ಸ್ವಲ್ಪ double ಇದೆ.
Oh, sorry. my lord.
Paragraph, internal paragraph.
Page 70, my lord, internal para 32.
32.
32.
Huh.
On careful scrutinizing the oral and documentary evidence produced by the prosecution, it is clear that the prosecution has failed to establish that the accused demanded and accepted the bribe amount of rupees 2,000 as a gratification other than legal remuneration to do the work of the complainant. Further, the prosecution has also failed to establish that the accused, being the public servant, used corrupt and illegal means and abused her position as a public servant. Since the prosecution failed to produce consistent, corroborative and believable evidence, I hold that the accused is not guilty of the offences alleged against her. The only inconsistent version of PW1 complaint and the evidence of PW8, the TLO, is not sufficient to prove the charge leveled against the accused, especially when the version of PW6, who is not a witness for the demand of tainted money by the accused, is not at all helpful to the prosecution to bring home the charges leveled against the accused. Hence, the prosecution has failed to prove the points 1 and 2 accordingly. I answer both the points in the negative. So, my lord, page 53 is the, my lord, the list of witnesses, PWs. My lord, here, serial number 1, serial number 6, and my lord, the serial number 7 are some of these, my lord, common witnesses even in the departmental inquiry also.
Paragraph?
Page 72, in page 72, witnesses.
My
lord. There, my lord, 3 of the witnesses, my lord, PW1, my lord, PW6 and PW8.
These have turned.
These are some common witnesses even we can find in the departmental inquiry also.
Now, in the criminal case, who turned hostile?
My lord, the complainant. The very same version as it has come in the, my lord, even in the departmental inquiry also.
Complainant is PW1.
PW1.
PW1, PW6 and PW8 are common in both.
My lord, PW1, yes, my lord, PW6 and PW8.
Common in
for
both
a,
the
my lord, if I could take, my lord, page 126, ink page. Page 126. Page 126. These are the list of only 3 witnesses, my lord, in the departmental inquiry. My lord, PW1 is the complainant. PW2 is, my lord, one, my lord, who is, my lord, the punch witness. PW3 is the IO. PW3 is the IO.
PW2, PW6 in criminal.
Please.
PW2 is PW6 in criminal proceedings. Is it so?
Yes, yes.
PW3 is PW8 in criminal.
Yes, very much. Yes. And, my lord, these are 3 weeks. Now, my lord, this, my lord, thereafter, my lord, the matter, my lord, was taken up, my lord, before this honorable court in an appeal, in a criminal appeal, and my lord, which came to be dismissed, by the, which was filed by the state, which is at page 74. Page 74.
Yes.
May I come to, my lord, the evidence in the departmental inquiry?
Yes.
My lord, page 77. This is the, my lord, the deposition of the PW1. My lord, may I read the entire, my lord, or my lord, the relevant portion? Kindly.
Relevant you take.
Please. Please. And my lord, here, page 78, para 5.
This is PW1.
PW1, the complainant. Para 5. Page, internal page, para 5, page 70, page 78.
Yes.
We left the Lokaयुcta office. My lord, here, before, my lord, going into the witness, my lord, it is to, my lord, mention that, my lord, there were two, my lord, the punch witness in this departmental inquiry and one complainant. But, my lord, the one punch witness, my lord, who had, my lord, accompanied along with the complainant, my lord, to the spot, my lord, where the, my lord, the accused was there. He was one of the, my lord, the crucial witness. He has not been examined either in the criminal proceedings nor in the, my lord, even in the departmental inquiry also, for the reasons best known to them. And it has come in the evidence of PW2, one of the punch witness. Now, my lord, here, my lord, page 78, para internal page 5, my lord, we left Lokaयुcta office and reached DDP office at about 4:15 p.m. The vehicle was stopped about 200 meters away from DDP office. Myself and punch witness went inside the DDPI office. Punch witness was standing near door and I went to meet DGO. When I inquired DGO, she informed that she has already completed work and asked to go go to outward section. Therefore, I asked to receive rupees 2,000. DGO refused to take. Page number 78. DGO refused to take. When I kept money on the table, she pushed the money. Money fell into the drawer. Punch witness gave a signal to police. Immediately, police came inside and asked DGO to take out and give money. DGO took out the money and handed over to DGO. Police took the hand wash of DGO and it turned into pink color. The amount was tallied and found that it was the same which I presented before the Lokaयुcta police. Place of drawer was swabbed with the help cotton and dipped into solution. It turned into pink color. Police seized the documents pertaining to 14 students. DGO gave a statement before Lokaयुcta police. Police have drawn up trap measure, EXP3. Statement of DGO is marked as EXP4. Copies of the documents pertaining to students are marked as EXP5. Copy of attendance register is marked as EXP6. Lokaयुcta arrested the DGO and took her to Lokaयुcta office. Lord, at the request of presenting officer, witness is treated as hostile and permission is granted for cross-examination. Now, my lord, in the cross-examination at my lord, internal page 7, it is false to say that DGO demanded rupees 200 per head to do the work, and on bargain, DGO agreed for rupees 2,000. And this conversation was recorded in mobile, and mobile was produced before the IO. It is true that Shri Suddarna Gowda Mallanna Patil kept money into my shirt pocket in Lokaयुcta office. It is false to say that when I went inside the office and approached DGO, again DGO demanded rupees 2,000. Then I gave it to DGO. DGO received from her right hand and kept money in the drawer. It is false to say that DGO never refused to receive money. It is false to say that shadow witness was with me. All along the incident took place in DGO office. It is false to say that in order to help the DGO, I am deposing falsely. Cross-examination by GA, advocate for DGO. It is true that 18/8/2000 was Saturday. It is true that 19/8/2000 was Sunday. Manoj, this may be of not relevant. Page para 10, Manoj. Para 10. On 25/8/2012, all the students had come with me to meet DGO. It is true that 25/8/12, DGO informed me that her part of work is completed and asked me to correct the year in all the applications. It is true that therefore students took me to Lokaयुcta office. It is true that the Lokaयुcta students also informed the police that till today that their work is not completed. It is true that Lokaयुcta police informed me that to get work completed early, students have to lodge the complaint. It is true that when students forced me, I have signed the complaint prepared by Lokaयुcta police. It is true that rupees 2,000 was contributed by students and it was not my money. Para 11. It is true that DGO never demanded money from me. Lordship may kindly note. It is true that I have not voluntarily lodged the police complaint and only force made by students. I had lodged the same. It is true that all the 14 students demanded DGO on 25/8/12 to give permission letter immediately. There was a quarrel between 14 students and DGO. It is true that IO had not given any instructions to myself and punch witness. It is true that in Lokaयुcta office, neither IO nor me told two panchas against whom trap is prepared and going on. It is true that until Panchas came to DDP office, they were not aware to which office they were going, and after trap only they came to know about DGO and her office. It is true that pre-trap measure EXP2 and trap measure EXP3 was drawn only for the arrest of DGO and took her to Lokayukta office. It is false to say that I did not present cash of rupees 2,000 before Lokayukta police. Police did not apply any powder and it was not kept in my shirt pocket. No, no. This is the PW1 and PW2 is one of the punch witness. Next page. The is relevant portion would be in the last para of page 81. We left the Lokayukta police station and reached DD5 office at 2:45 p.m. Vehicle was stopped about 200 to 300 feet away from the DGO office. The complainant and Punch Shri Chandrasekhar went inside the office of DGO. Lordship, here kindly note that there was one another punch witness who was along with the DGO, that is Chandrasekhar, who was not examined at all. After 10 to 15 minutes, complainant came out and gave signal. Immediately, IO staff and myself went inside the office of DGO. Complainant informed that DGO received and kept money in a drawer. Police held the hands of DGO. A hand wash was taken in the solution. It turned into pink color. Amount was in table drawer. On verification, money was tallied with the amount which complaint presented in Lokayukta office station. Police seized bribe amount. Swab of drawer portion was taken. It was dipped into solution. It turned into pink color. Now, Malad, I will come to the relevant portion, Malad, which is at page 63, Malad, last para 7. It is true that IO informed me to maintain secrecy. It is false to say that IO had not informed against whom the trap was prepared. It is false to say that the complaint had not presented any bribe amount before IO. It is true that Lokayukta office is situated about 2 kilometers away from the office of DGO. It is true that the road is running from north to south. On the other side, DC office is situated. From the road, portico of the office of DGO is situated about 100 meters away. We are standing outside the compound. It is true that place of DGO is not visible and their conversation was not audible to us, to the place where we were standing. Lordship may kindly note, Malad, that this witness, Malad, had not accompanied Malad with the DGO. And Malad, in his cross-examination, he states, Malad, that it is true that place of DGO is not visible and their conversation was not audible to us, to the place where we are standing. And next para, it is true that I came to know from complainant and another punch about receipt of money and I did not see him personally. Lordship may kindly note. It is false to say that the hand wash of DGO was not taken and did not turn into pink color. It is false to say that complaint and punch witness had not informed the statement given by the DGO is false. These are things, Malad, again, which is not disputed as to the pre-trap and the post-trap proceedings. And
one more witness. Who is the one more witness? PW3?
Malad, PW3 is the Malad IO. He has deposed with regard to the pre and post-trap, Malad, the proceedings. This IO. And Malad, another Malad witness, Malad, who was
is also standing outside the office.
Malad, it is Malad, Lordship may kindly see the statement of PW2, Malad, at page 81 para 2.
What is the say of PW3? Whether he was inside the office or outside the office?
According to Malad, the PW2, another punch.
What is the evidence of PW3? Just go through the evidence of PW3.
PW?
Just go through the evidence of PW3.
Please.
No, copy, it is not
Idrale copy
available.
Either copy illa, may I Malad take to Malad the
Idiya nimmalli. Chief odi idre. Nimmalli idya.
ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರು
PW2 is not a shadow witness, Marks. He is a co-puncher. His work is to, before putting the money.
PW3 now.
PW3, as per him, Marks, he is a IO.
ನಿಮ್ಮಲ್ಲಿ ಫೈಲ್ ಇಲ್ಲ? You don't have file.
Original
ಇಲ್ಲ
file,
ನಿಮ್ಮಲ್ಲಿ?
original file.
Next. PW, my lord,
PW2 says PW3 informed me, complainant and PW3 informed me. Now we have to go through the evidence of PW3, whether he was outside or inside, whether he went along with the PW1 inside the office. What we want to see that.
PW3, my lord, is the IO.
ಹೌದು, our PW2 evidence ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ, PW3 ಮತ್ತು 1 and 3 informed ಅಂತ.
ಇಲ್ಲ.
ಹಾ.
That the complaint informed to disjure is
Correct. So we want to see that what did he say? Did he support? Did he say? Can you get it
yes, ma'am.
tomorrow?
Yes, ma'am.
Tomorrow.
My lord, I will because it is not available with me. I'll have to, my lord, find it from my client.
Elinda, where is that?
If they are able to, my lord.
ಮಲ್ಲಾಪುರ್, ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಇದೆ?
ನಮ್ಮ office ಅಲ್ಲಿ.
ಫೈಲ್ ಇದೆಯಾ?
No, only this. Personal. Don't have the original file, I have to get it.
My lord, may I read it from the, my lord, the findings, my lord, of the inquiry officer?
ಆಯ್ತು, ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ನೋಡಿ.
Show us the file.
Inquiry report, my lord, please.
Otherwise.
Yes, my lord. Yes, my lord. It has come in the, my lord, the inquiry report. Page 122. Ink page 122.
Inquiry report. Page number 98.
Yes.
My lord, page, para 52.
Para?
52. The evidence of the evidence of PW3, who is the investigation officer, also makes it very clear with regard to the procedure of pre-trap and trap, as well as the seizure of amount and consequential documents from the possession of the DGO. It is necessary to mention, as per the contents of the documents, really in the event of fulfilling the grievance of the complainant and the students, well in time, absolutely, there was no occasion for the complainant to lodge the complaint. The partial hostile evidence of PW1 itself will not take away the case of the disciplinary authority, as he admitted the material suggestions put forth during the course of cross-examination conducted by the learned presenting officer. In view of the contents of the complaint, no importance shall be attached to the portion of the hostile witness of the complainant. It is necessary, my lord, once again, my lord, if I were to advert, my lord, to PW3's, my lord, the version, page 56. Sorry, my lord, para 56. Para 56. The overall consideration of evidence PW 1 to 3. May I read? Para 56, 124. The overall consideration of the evidence of PWs 1 to 3 also makes it very clear with regard to the facts and circumstances of the case. It is necessary to mention the acquittal in special case number 6 of 2013 by judgment dated 13/4/15 on the file of the Honorable Principal Sessions Judge Special Judge Vijaypura, and dismissal of criminal appeal number 20009/015 is also not a ground to reject the case on hand. It is necessary to mention departmental inquiry is being conducted under the provisions of KCS rules 1957 for having committed misconduct as enumerated in the provisions of KCS conduct rules 1966. And there is no question of proof beyond all reasonable doubt. And in the case on hand, the probabilities itself is sufficient to accept the case of the disciplinary authority. In the case on hand, the evidence of DJO is not sufficient to reject the case of disciplinary authority, and the decisions referred to and relied by the defense counsel are not applicable to the facts and circumstances of the case on hand. My lord, here, the only thing, my lord, what we could, my lord, get, my lord, from the inquiry report, insofar as the evidence of PW3 is concerned, it is, my lord, that pre and post trap events, which is clear. And, my lord, and based on the pre and post trap, my lord, events, my lord, now, my lord, these, my lord, the entire, my lord, the findings, my lord, are held to be, my lord, approved by the, my lord, the disciplinary authority. And, my lord, now comes the question, my lord, as to, my lord, the charge, my lord, is, my lord, the demand and, my lord, acceptance of, my lord, bribe amount. My lord, they will have to, my lord, by way of, my lord, since the onus is on the prosecution, my lord, to prove in the departmental inquiry based on the evidence, my lord.
In the criminal case, what is the evidence?
Yes, ma'am.
Referred to of this IO?
Yes, ma'am. Yes.
PW8.
PW8. My lord, page 50, page 50. Page 50, sorry, ma'am, page 69, in page 69, internal page 24. My lord, adralli middle alli bandide. So the evidence on record indicates that PW8 has not made any preliminary inquiry into the allegations made in the complaint against the accused, and without taking proper inquiry, he has conducted the trap. In this case, the prosecution has not examined the shadow witness to establish the demand and acceptance of bribe amount by the accused, let alone there is inconsistent version of complaint which is not corroborating the evidence of PW8, the TLO on certain crucial aspects. As mentioned in the trap, Mahazar, the mere recovery of tainted money from the accused and positive result of phenolphthalein test as per EXP 25. The FSL report would not establish the guilt of the accused unless the demand is proved by the prosecution. When the demand is not proved, the motive cannot be established, and the presumption fails if the motive is not established, and it weakens the case of the prosecution. And therefore, bearing in mind the principles enunciated in the decisions relied by the learned counsel for the accused, I am of the considered view that the accused is not entitled for is entitled for acquittal. And now, my lord, PW, my lord, 8, my lord, even in the, my lord, the criminal proceedings. And one more, my lord, aspect, my lord, which I would highlight, my lord, that, my lord, one another witness, my lord, who had, my lord, accompanied with the.
No, that point you have made.
And, my lord, here, except, my lord, with regard to these, my lord, the events, my lord, with regard to the demand acceptance, my lord, of the bribe amount, my lord, there is no evidence whatsoever with regard to, my lord, the demand and acceptance, my lord, of the bribe amount. When, my lord, there is a specific charge, my lord, with regard to, my lord, the demand and acceptance, my lord, of the bribe amount, my lord, it is for them to, my lord, lead with an evidence.
The hold?
My lord, tribunal, my lord, at page
What is the finding of the tribunal?
Page. Para 3, 4, 5 and 6.
Govinda. Govinda and para 3 nodi. Read para 3. Page 290.
No reply statement. That is, no reply statement has been filed either by the government first respondent or Lokayukta institution. Second respondent, although adequate opportunities have been accorded to the respondents to file their reply statement, Lokayukta council was not present during so and so and hence could not be heard in the proceedings on the submissions made by the land council for the applicant. The learned government pleader has strongly opposed the application and has contended that the application is without any merit and deserves to be dismissed. The land government pleader has stated that the DGO applicant in her deposition has admitted that the amount was received by her and that work of the complainant was pending with her. The land government pleader also contended that acquittal in criminal proceedings is not bar to the initiation of the initiation or for continuation of disciplinary proceedings on the same set of facts since the purpose of the two proceedings are different and the manner of the evidence required to prove the charge in both the proceedings are different. In criminal proceedings, it is a proof beyond reasonable doubt, while in the disciplinary proceedings, it is a preponderance of probability. The land government pleader has also referred to the trap majeure and statement of applicant at the time of the trap, which has been relied in the inquiry.
Just a minute.
This regard, the first question I have for consideration. Lord, 5 minutes. 2 paras of PW1, 2 paras. It is a partial hostel. Therein it was contended, page number 77. On so and so date, did DGO to take up the examination of 14. There is narration with regard to the demand, my lord, 2,000 rupees. For that reason only he approached the Lokayukta and he lodged the complaint and he gave the money. This is the pre-trap proceedings, my lord. And thereafter, I request your lordship.
In the cross-examination, he said.
Yes, my lord. Therefore, partial hostel. Here it is a pertaining to departmental disciplinary inquiry, departmental inquiry. My lord, page number 84. This is page number 84. It is a cross-examination of the DGO. DW1 ರವರನ್ನು ಕರೆಸಿ ಪ್ರಮಾಣ ವಚನ ಬೋಧಿಸಲಾಯಿತು. needy one to so and so case, they are relying only on the basis of the acquittal, on the sole basis of acquittal and the dismissal of the criminal appeal. ಪಾಟಿ ಸವಾಲು ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರದ ಪರವಾಗಿ ಮಂಡನಾಧಿಕಾರಿಯವರಿಂದ ದೂರುದಾರರ ಪರಿಚಯ ಇದೆ. ನಾನು ಡಿಡಿಪಿಐ ಕಚೇರಿ ವಿಷಯ ನಿರ್ವಾಹಕರ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿ. 14 ವಿದ್ಯಾರ್ಥಿಗಳು ಬಾಯಿ ಮೂಲಿನ SLC ಪರೀಕ್ಷೆ ಬರೆಯಲು ಅನುಮತಿ ಕೋರಿ ಸ್ವಯಂಸರಂದು ಡಿಡಿಪಿಐ ಕಚೇರಿ ಅರ್ಜಿಸಿದ್ದೆಂದರೆ ಸರಿ. ಅನುಮತಿಯ ಪತ್ರವನ್ನು ಕೋರಿ ದೂರವರು ಸಾಕಷ್ಟು ಸಲ ನನ್ನನ್ನು ಭೇಟಿ ಮಾಡಿದ್ದರೂ ಸಹ ನಾನು ಅನುಮತಿ ಪತ್ರ ತಯಾರು ಮಾಡಿ ಸಹಿಗಾಗಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ದಿಸ್ ಡಿನೈಸ್. ದಿನಾಂಕ ಸ್ವಯಂಸರಂದು ದೂರದಾರ ನಾನು ಭೇಟಿ ಮಾಡಿ ಅನುಮತಿ ಪತ್ರ ಬಗ್ಗೆ ವಿಚಾರಿಸಿದಾಗ ನಾನು ತಲಾ ವಿದ್ಯಾರ್ಥಿಗೆ 200 ರೂಪಾಯಿ ಅಂತ ಲಂಚದ ಹಣ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ತಲಾ ವಿದ್ಯಾರ್ಥಿಗೆ 200 ರೂಪಾಯಿನಂತ ಹೆಚ್ಚಿಗೆ ಆಗುತ್ತದೆ ಎಂದು ತಿಳಿಸಿದಾಗ ಒಟ್ಟು 2000 ರೂಪಾಯಿ ಲಂಚವನ್ನು ಕೊಡುವಂತೆ ನಾನು ನಿಗದಿ ಮಾಡಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಸಂಭಾಷಣೆಯನ್ನು ಮೊಬೈಲ್ ನಲ್ಲಿ ದಾಖಲು ಮಾಡಿಕೊಂಡ್ರೆ ಸರಿಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ ಈ ದಿನಾಂಕ 25/8/12 ದೂರದಾರರು ಸಂಜೆ 5:45 ವೇಳೆಗೆ ನನ್ನನ್ನು ಭೇಟಿ ಮಾಡಿ ಅನುಮತಿ ಪತ್ರ ವಿಚಾರಿಸಿದಾಗ ನಾನು ದೂರುದಾರ ಬಳಿ ಹಣ ತಂದ ಬಗ್ಗೆ ವಿಚಾರಿಸಿದಾಗ ಅವರಿಂದ 2000 ರೂಪಾಯಿ ಲಂಚದ ಹಣವನ್ನು ಬಲಗೈಯಿಂದ ಪಡೆದು ಟೇಬಲ್ ನ ಬಲಭಾಗದಲ್ಲಿ ಡ್ರಾರ್ ನಲ್ಲಿ ಇಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದಿಸ್ ಈಸ್ ದ ಎಕ್ಸಾಕ್ಟ್ ಮಲಟ್. ಶಿ ಟುಕ್ ದಿ ಮನಿ ಅಂಡ್ ಕೆಪ್ಟ್ ಇನ್ ದಿ ಡ್ರಾ ಬಟ್ ಇಟ್ ಇಸ್ ಸಜೆಷನ್ ಡಿನೈಡ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅದೇ ವೇಳೆ ಲೋಕಾಯುಕ್ತ ಅಧಿಕಾರಿಗಳು ದಾಳಿ ಮಾಡಿ ನಿಪಿ 3ರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಟ್ರ್ಯಾಪ್ ಪ್ರಕ್ರಿಯೆ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ತನಿಖಾಧಿಕಾರಿ ಹಿಯರ್ ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ದೀಸ್ 4 ಲೈನ್ಸ್. ತನಿಖಾಧಿಕಾರಿ ತನ್ನ ಬಲಗೈಯನ್ನು ದ್ರಾವಣದಲ್ಲಿ ತೋರಿಸಿದಾಗ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ಬದಲಾವಣೆ ಆಗಿದ್ದರೆ ಸರಿ. ಅದಂತೂ ಹೋಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ ಸಾಕ್ಷಿದಾರರು ದೂರುದಾರರು ಒತ್ತಾಯದಿಂದ ಹಣ ಕೊಡಲು ಬಂದಾಗ ನಾನು ಹಣವನ್ನು ತಿರಸ್ಕರಿಸಿ ನನ್ನ ಬಲಗೈಯಿಂದ ತಳ್ಳಿದಾಗ ಟೇಬಲ್ ಡ್ರಾ ನಲ್ಲಿ ಬಿದ್ದಿದ್ದು. ಆಕ್ಚುಲಿ ತಳ್ಳಿದ್ರೆ ಹೊರಗಡೆ ಹೋಗ್ಬೇಕು, ಡ್ರಾ ನಲ್ಲಿ ಹೋಗಲ್ಲ. ಆಮೇಲೆ ಡ್ರಾ ಯಾವಾಗೂ ಓಪನ್ ಇರಲ್ಲ.
ತಳ್ಳಿದಾಗ ಅಲ್ಲಿ ಬಿದ್ದಿದೆ ಅಂತ
ಡ್ರಾ ನಲ್ಲಿ ಸ್ವಾಮಿ, ಡ್ರಾ ಸ್ವಾಮಿ ಯಾವಾಗ್ಲೂ ಮಲಾಡ್ ಆಲ್ವೇಸ್ ಡ್ರಾ. Here she admits.
Like a criminal case, you have to prove beyond reasonable doubt.
No need to prove, my lords. The preponderance is, a preponderance is if someone doesn't accept, he will push it back to him.
Complaint himself turned hostile. BW1 himself
But
turned hostile.
not hostile, my lords.
In a trap case, you have to prove the 3 things: demand, acceptance, and pendency of the work.
Here pendency of the work is then what she has complained.
Also PW1 denied in cross-examination.
He doesn't deny the contents of the complaint. That is very important.
Huh?
He doesn't deny that he has not given the complaint.
Huh.
For my lords, there is acceptance. And secondly, my lords, PW2, if your lordship go through evidence of PW2, my lords, the documents were on her table. That has not been cross-examined by, they have not denied.
Who is a hearsay witness? He was outside the office.
No,
He said, yes.
the punch witness work is to not to hear, or the shadow witness has
He
not
was
been
outside
examined
the
anywhere.
office. He
But
said after
he's-
giving signal by PW1 gave signal to him,
Yes.
and thereafter he entered the office.
It is his job, my lords, to take the notes and verify whether they are the same notes that he had kept it in the pocket of that is it. And also the documents that are seized, in his statement, he specifically says the documents belonging to the complaint, subject matter.
Mr. Mallapur, who has to say about the demand and acceptance?
Demand and exception, PW1 and
PW1.
shadow witness.
PW1 has to say.
Yes.
So according to PW2, PW1 only informed PW2 about the
Yes,
demand and
because
acceptance.
he will be standing outside, yes.
Is it so? PW1 only informed to PW2.
Yes.
So now PW1 himself turned hostile.
My lords,
But
here,
he
it
has
is not
approached
the
the local.
beyond reasonable doubt, my lords. Here the,
Preponderance
yes, my
and
lords.
probabilities.
Yes, my lords.
Huh.
When he accepts,
And there is no evidence.
my lords,
See, the apex court said, even in Ramlal case or Rudrappa case, Rudrappa's case, the coordinate bench of this court. So, and Ramlal case, the apex court said, if there is no evidence and the judgment is perverse. In this case, where is the evidence? Just show. Say.
No, what is the article of charge? There is a demand and acceptance. Demand is not supported anywhere. Where is the demand? Now he may have taken it. He may have taken it and put it in his drawer. That's what is your case, isn't it? But where is the demand?
My lord,
Evidence for demand is not there. Money may have fallen into the draw, they may have given, etc. Where is the demand? What is the charge? Charge is demand and acceptance. Where is the demand? No evidence.
By going through these two paras, my lord, because of the demand only, he approaches the Lokayukta.
Just come to page number 307. 307. The reasoning of the tribunal, para 16.
16.
Huh.
The applicant has contended that there is no application of mind in the entrustment order. It is not the case of the applicant that at this stage that there is no prima facie material constituting a charge of corruption against the applicant. The applicant having been caught in trap proceedings conducted by Lokayukta police. Hence, the contention that there is no application of mind on the part of the first respondent in entrusting the case for the conduct of disciplinary proceedings to the Lokayukta institution is untenable at this stage and is amusing to say the least. The reliance placed on judgment of so
Evidence for this. Where is the evidence? Evidence ಎಲ್ಲಿದೆ ಅಂತ?
evidence are there.
Sit base ಮೇಲೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ? There must be some evidence ಅಲ್ವಾ? Say, that's what even in Ramlal case, before Ramlal case, ಯಾವ್ದು ಮತ್ತೊಂದು case.
My lord, I have produced, my lord, the Rudrapa's case, my lord, in addition. At additional, my lord, in synopsis, page, in page 47, sorry, in page 108.
You just go through ಬೇಕಿದ್ರೆ ನಿಮಗೆ ಏನಾದ್ರು ನೀವು judgment produce ಮಾಡೋದಿದ್ರೆ ಮಾಡಿ. See, even the law laid down by the apex court in Umesh case, 2022.
Yes.
Thereafter, Ramlal case and the coordinate bench of dispute in Rudrappa case. Just go through. Rudrappa case ಅಲ್ಲಿ very clear ಹೇಳಿದ್ದಾರೆ. If the witnesses are one and same,
Yes.
and those witnesses were who was turned hostile in a criminal case, and the same witnesses are examined in DE, and they are turned hostile in that case, then cannot be sustained. That is a very clear findings in Rudrappa case, coordinate bench.
But here, my lord,
Here in the compulsory
once
retirement order.
he has accepted the contents of the complaint.
No, but
In the,
Since here in this
there
case.
must be
shadow
demand and
witness-
acceptance, isn't it? What is the charge frame that he demanded and accepted?
Yes.
Right? Now, acceptance, you may have made out a case on probability. It fell into the draw. etc.
because of demand only, he approaches the Lokayukta.
That we can't presume. That we can't presume. The charge is unbecoming of a government servant.
And insofar as acquittal, my lord, in criminal case in the,
Without entering into that, forget that
please.
for the time being. Here only the demand is not supported. We'll have it tomorrow. You just think and come. What we are saying is the charge says that he demanded and accepted. That conduct is against the unbecoming of a government servant. So he must have asked. That we can't presume. ನೀವು ಕೊಡೋದಕ್ಕೂ ಅವರು ಕೇಳೋದಕ್ಕೂ
So some evidence in respect of demand and acceptance. We'll agree over this contention.
Relist tomorrow. If you can get that PW3, just have a look.
Please.
PW3
Yes, ma'am.
evidence.
Yes.
Till number 1.
Yes, yes.
Yes, my lord, I advised them to file a press representation.
Huh?
I have advised them, my lord. They are agreed to give a press representation to the assistant commissioner, complying with all the requirements, my lord.
So we'll record that.
Please.
The present appeal has been filed by the president of the Gram Panchayat, calling in question correctness of the order of the learned single judge.
If Lordship permits,
Yes.
the issue involved in this case, it has not been settled now, my lord.
Huh?
The issue involved in this case is
Whether,
the first resolution was
We don't want to decide that unless you are ready, that the matter may be stayed and we are heard.
in the meantime, if
there
the
is a stay
petitioner,
or
in the meantime, if the liberty is given to the members to file a fresh no confidence motion,
He will raise the same contention. He is now already making galata for the previous one.
there is no bar to give another no confidence motion, my lord, as already been decided by this honorable court. So my personal opinion,
Correct. So insofar as that is concerned, we'll keep quiet. If it's open to you in law, you do it.
my lord,
Now, insofar as we are saying liberty, no, we need not give. If it's open to you in law, you do it. We will not. We'll
some-
not comment on whether you have the right to initiate or not, because that's one of the legal contention. We leave it at that. This one will stay till the next date, fix a date, we'll hear you.
state means the wrong message will be taken, interpreted by the assistant commissioner.
That's why we have given you one big door open.
Yeah, but since the point is very good, my lord, and there should be some consideration by this court.
But not, we don't, we can't do an academic exercise.
Please,
If you're ready to wait, we can do.
let them file fresh.
So you file a memo.
Please.
Anybody give it? Passed in WP 200131 of 2025, wherein the learned single judge has rejected the petition upholding the proceedings initiated for moving the motion of no confidence. Counsel for the appellant, so and so, has raised various contentions and draws attention to the complaint at annexure
at annexure A, sorry, B,
page
page 42.
page 42, and submits that allegations are contained in the said complaint, and that if the proceedings are permitted to go ahead with such complaint with allegations, though it is contended by the other side that what is being considered is only a motion of no confidence simpliciter. In effect, it would be a stigmatic no confidence motion passed against the president of the Gram Panchayat. Such aspect is a matter that requires consideration. However, the pendency of the present appeal and its disposal would take time. And when such aspect is taken note of by counsel for the respondent, counsel for the respondent files a memo. In light of the same, the present proceedings are disposed of as calling for no adjudication, while liberty is kept open for the members to initiate fresh proceedings in terms of section 49(1). While it is observed that the contentions, all contentions, other contentions are kept open.
The notice dated 30/12, annexure A has to be squashed.
In light of the stand of the respondents, the notice at annexure A is set aside.
Please.
Dated 30/12/24.
Annexure A dated
30/12/24 at page number 41.
30/12/24.
My only impression will be, there should not be another round of litigation.
Now, that's why now you conduct it carefully, you say how it is to be, complaint is to be given, etc. Government will comply. Now they are familiar with the procedure.
Please.
So it's only on the nature of your complaint. You make it simplicity 2 line. So then Kadakanji has no legs to stand.
And another one humble request, ma'am. The order may be kindly released today or order may be kindly released tomorrow or today.
Surely, surely.
Please,
Give that memo.
please, ma'am. Much.
Yes.
Number 31, Mahesh Patil.
Not serial number 31.
Yes, sir.
Only on the, without going into merits, on technicalities. My 50% of my pension, has been reduced, by virtue of, the impugned punishment order, which is at page 89.
Page
89. This is by way of a measure of punishment.
89.
Yes, in a departmental inquiry, which was entrusted to the Honorable Upala.
First tally agala.
Is
Yav annexure.
annexure L.
Page 89 is
Sorry,
middle.
annexure N, 85.
85.
Annexure N.
Those are the findings, annexure.
This is the order, annexure N, page 85. This is, I'm sorry, I'm sorry. This is, even in this, matter, my wakalat is there. But my learned colleague, in another matter, this is the next matter. I'm sorry.
Huh?
I'm sorry. My colleague,
He's
she will. I'm,
Not, I may permitted to.
I'm
argue
sorry.
this.
Yes.
Please.
This is my next matter. Sorry.
Yes. This is 31. May I make some submissions, my lord?
Yes.
Yes. My lord, this is the matter, my lord, where the petitioner, my lord, sir, asked me to file a synopsis that I have filed, my lord, along with the judgments and his acquittal order. Lord, now I come to the subject.
There was no second notice.
No, there is a second notice. My lord, what happens, my lord, the petitioner who is retired in the year of 2019. My lord, while he was working, my lord, there was a trap was laid on 11/11/2011, my lord.
There was a
Trap, my lord, on 11/11/2011.
yes.
My lord, by the Hanmant Rao, who is the complainant.
No, this is the case, isn't it? The disciplinary authority.
Yes, my lord. Yes, my lord. The inquiry was completed.
Disregarded the inquiry proceedings.
Yes, my lord.
And took a contrary decision and imposed the punishment.
Not imposed the punishment. The inquiry officer conducted the inquiry, and the deposition copy also I have produced that the complainant itself is accepted that there is no demanded. He has taken hand loan, therefore he has been returned that. The same thing has came before the inquiry officer. He told that there is no evidence. Therefore, remember, they gave a inquiry report saying that the charges are not proved.
Then what happened?
Well, now, my lord, the respondent government, they have issued the fresh inquiry on the same set of charges. That is annexure 8. Yes,
fresh inquiry is not impermissible.
Yes, my lord. Yes, my lord.
As per the order in
that is annexure 8.
8. No,
Yes.
which is the?
In page number 94.
No, just 1 minute. In your synopsis,
Yes, madam.
you have relied on that order, which says there cannot be a fresh inquiry.
Yes, madam. Fresh inquiry cannot be ಅನ್ನೋದಕ್ಕೆ ನಾನು petition ಅಲ್ಲೇ produce ಮಾಡಿದ್ದೇನೆ judgment. That is in page number 112.
112.
Yes, my lord. The petition, writ petition number 5838 of 2022, or the order correct position is page number 112. My lord.
Just take us to that relevant paragraph.
Yes, ma'am. My lord, I'll read that para 12.
Page?
Page 1. Yes.
Yes. Read.
The proceedings which are directed to be initiated pursuant to the order of Denovo inquiry are initiated on two settled principles of law. First, being conducted of Denovo inquiry by a different inquiry officer merely because of the disciplinary authority does not accept the findings of the inquiry officer in the light of the law laid down in Apex Court order, that is KR Dev versus CCE reported in 1971 to SCC 102, wherein it is held as follows. Rule 12, para 12. It seems to us that the rule 15 on a face of it really provides for one inquiry, but it may be possible if in an particular case there has been no proper inquiry because some serious defect has crept into the inquiry, or some important witness were not available at the time of the inquiry or were not examined for some other reason. The disciplinary authority may ask the inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside the provisions inquiry on the ground that the report of the inquiry officers does not appeal to the disciplinary authority. The disciplinary authority has enough powers to reconsider the evidence itself and come into the conclusion under Rule 9. Thereafter, my lord, the later effects court following the afore extracted judgment in the Vijay Shankar Pandey Union of India reported in the 10 SCC 589 held that yes, my lord. The question is whether the disciplinary authority could have resorted to the such practice of abandoning the inquiry already undertaken and resort appointment of fresh inquiry authority. The issue is not really whether the inquiry authority should be single member or a multi-member body, but whether second inquiry as the one under challenge is permissible. The Constitution went so and so. Examine the question of the context of Rule 15(1) of the CCA. Central Civil Services Rules 1957. It was case where the inquiry was ordered against the sub-inspector central so and so. The inquiry officer held that the charges was not proved.
No,
Thereafter,
that rule, similar rule we have.
Actually, this is CCA rules, my lord. This is Rule 15, my lord. This is central, and I'm saying about the state. Even though, my lord, the subsequent judgment I have produced, my lord's judgment only. That is produced, I have collected with the Satish and I have produced it.
No, correct. Now, the only point you're saying is that there cannot be a de novo inquiry after evidence is led in and the inquiry officer records a finding that charges are not proved. There's no, that's all, isn't it? On that point.
Yes, ma'am. That point.
So what does the tribunal hold? Is one judgment tegiri?
Lord, annexure C is the decision.
Just 1 minute. KR Dev versus KR Dev, DEB versus CCE, 1971, 2 SCC 102. Now you first take us to the finding inquiry report. Inquiry report.
My lord, inquiry report is annexure A4.
A?
A4. Page number 56. It starts from page number 56, my lord. That is on the dated 31/6/2019.
So you find, show us the finding, charge finding. What is?
My lord, here clear finding is that, my lord, in series page number 65.
65.
Page number 65. Yes, my lord, I'll read it. My lord's funds.
Anyhow, it says charges are not proved, isn't it?
Yes, my lord, because there is no evidence.
Page 65, is it?
Yes, my lord.
Just read that paragraph.
My lord, para number 20. Dೂರು ಸಲ್ಲಿಸಿದ.
Yes.
Yes, ma'am. ದೂರು ಸಲ್ಲಿಸಿದ ವ್ಯಕ್ತಿ ಹನುಮಂತರಾವ್ ತನ್ನ ಪುರಾವೆಯಲ್ಲಿ ತಾನು 2 ವರ್ಷಗಳ ಹಿಂದೆ ಅಂದರೆ 2011 ಸಾಲಿನಲ್ಲಿ ಆಪಾದಿತ ನೌಕರನಿಗೆ ರೂಪಾಯಿ 15,000 ಸಾಲದ ರೂಪದಲ್ಲಿ ಪಡೆದುಕೊಂಡಿದ್ದೆ ಮತ್ತು ಆಪಾದಿತ ನೌಕರ ಅದನ್ನು ಕೇಳುತ್ತಿದ್ದನೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಈ ರೀತಿ ಹಣ ವಾಪಸ್ ಕೇಳುತ್ತಿದ್ದರಿಂದ ನಾನು ಲೋಕಾಯುಕ್ತ ಅವರಿಗೆ ದೂರು ಸಲ್ಲಿಸಿದ್ದೇನೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಪೊಲೀಸರು ನನಗೆ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಕೊಡಲಿಲ್ಲ ಮತ್ತು ಆಪಾದಿತ ನೌಕರರ ಮನೆಯಲ್ಲಿ ಪಂಚನಾಮ ಮಾಡಲಿಲ್ಲವೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಕಾಮಗಾರಿಗೆ ಅನುಮತಿ ನೀಡಲು 4 ಲಕ್ಷ ಮೊತ್ತದ 3% ಅಂದರೆ ಸುಮಾರು 12,000ಗಳನ್ನು ನನಗೆ ಕೊಡಬೇಕಾಗುತ್ತದೆ. ಆಪಾದಿತ ನೌಕರ ಹೇಳಿಲ್ಲ ಮತ್ತು ಈ ಹಣವನ್ನು ಕೊಡದಿದ್ದಲ್ಲಿ ಕಾಮಗಾರಿ ವಹಿಸಿಕೊಡುವುದಿಲ್ಲ ಅಂತ ಆಪಾದಿತ ನೌಕರರು ಹೇಳಿಲ್ಲವೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ವಾಟ್ ದ ಸೇ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್. ಲಂಚದ ಹಣ ಕೊಡಲು ಇಷ್ಟವಿಲ್ಲದಿದ್ದರೆ ಲೋಕಾಯುಕ್ತ ಕಾರ್ಯಾಲಯಕ್ಕೆ ದೂರನ್ನು ಸಲ್ಲಿಸಲಾಯಿತೆಂದು ಸೂಚಿಸಿದಾಗ ಅದನ್ನು ಆತ ನಿರಾಕರಿಸಿದ್ದಾನೆ. ಮಂಡನಾಧಿಕಾರಿಯವರು ದೂರಿನಲ್ಲಿರುವ ವಿಷಯವನ್ನು ಹಾಗೂ 2 ಪಂಚನಾಮಗಳಲ್ಲಿರುವ ವಿಷಯವನ್ನು ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ಸೂಚಿಸಿದಾಗ ದೂರುದಾರ ಅದನ್ನು ನಿರಾಕರಿಸಿದ್ದಾನೆ. ಹೀಗೆ ದೂರಿನಲ್ಲಿರುವ ಸಂಗತಿಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ದೂರುದಾರ ತನ್ನ ಪುರಾವೆಯನ್ನು ಹೇಳಲಿಲ್ಲ. ಅದೇ ರೀತಿ ಪ್ರಾಯೋಗಿಕ ಪಂಚನಾಮನೆಯಲ್ಲಿರುವ ಸಂಗತಿಗಳ ಬಗ್ಗೆ, ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮಗಳಲ್ಲಿರುವ ಸಂಗತಿಗಳ ಬಗ್ಗೆ ದೂರುದಾರ ಅದನ್ನು ಪುಷ್ಟೀಕರಿಸಲಿಲ್ಲ. ಈ ರೀತಿ ಘಟನೆ ನಡೆದೇ ಇಲ್ಲವೆಂದು ಹೇಳಿಬಿಟ್ಟ. ದೂರುದಾರ ತನ್ನ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ತನ್ನ ಕಾಮಗಾರಿಯ ಬಗ್ಗೆ ಆಪಾದಿತ ನೌಕರರ ಕಾರ್ಯ.
Now you come to the decision to hold a fresh inquiry.
No, yes, ma'am. Now, my lord, that is annexure 8.
Annexure?
8. Page number 93.
Yes.
Yes, ma'am. ಶ್ರೀ ಮಲ್ಲಿಕಾರ್ಜುನ ಕಟ್ಟಪ್ಪ ಕರಂಜೆ ಇವರು ಹಿಂದೆ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರಾಗಿ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಸೇವೆ ಸಲ್ಲಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಪ್ರಕರಣ ದೂರುದಾರರಾದ ಶ್ರೀ ಹನುಮಂತರಾವ್ ತಂದೆ ರಘುನಾಥರಾವ್ ಚಿಂಚೋಳ್ಳಿ ಗುತ್ತಿಗೆದಾರರು ಬಾಲ್ಕಿ ತಾಲೂಕು ಬೀದರ್ ಇವರಿಂದ ಲಂಚದ ಹಣಕ್ಕೆ ಬೇಡಿಕೆ ಇಟ್ಟು ರೂಪಾಯಿ 12,000ಗಳ ಅಕ್ರಮ ಸಮಾವನೆಯನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು ಲೋಕಾಯುಕ್ತ 11/11/2011 ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಬಯಸಿದ ಬಲೆಗೆ ಸಿಕ್ಕಿಬಿದ್ದಿರುವ ಮೇಲ್ನೋಟದ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿಯವರ ವಿರುದ್ಧ ವಿಚಾರಣೆ ನಡೆಸಲು ಪ್ರಕರಣವನ್ನು ಲೋಕಾಯುಕ್ತಕ್ಕೆ ವಹಿಸುವಂತೆ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಸೋಯನ್ಸು ಉಪಲೋಕಾಯುಕ್ತ 1 ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಇವರ ದಿನಾಂಕ 12/7/2013 ವರದಿಯು ಪ್ರಸ್ತಾಪವಾಗಿತ್ತು. ಈ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಮೇಲೆ ಕ್ರಮಾಂಕ ಸೋಯನ್ಸು ಕಂಟೆಪ್ಪ ಸಹಾಯಕ ಅಭಿಯಂತರರು ಲೋಕೋಪಯೋಗಿ ಉಪವಿಭಾಗ ಬಾಲ್ಕಿ ಬೀದರ್ ಜಿಲ್ಲೆ ಇವರ ವಿರುದ್ಧ ಲೋಕಾಯುಕ್ತ ಟ್ರ್ಯಾಪ್ ಪ್ರಕರಣ ಸಂಬಂಧ ಕರ್ನಾಟಕ ಸೋಯನ್ಸು ನಿಯಮಗಳ 14ರ ಅಡಿಯಲ್ಲಿ ಅದೇ ನಿಯಮಗಳ 11ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಕಾರ್ಯವಿಧಾನವನ್ನು ಅನುಸರಿಸಿ ಇಲಾಖಾ ವಿಚಾರಣೆ ನಡೆಸಲು ಪ್ರಕರಣವನ್ನು ಉಪಲೋಕಾಯುಕ್ತ 1 ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತರ ವಹಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಗೌರವಾನ್ವಿತ ಉಪಲೋಕಾಯುಕ್ತರು ಮೇಲೆ ಆದೇಶದಲ್ಲಿ ಪ್ರಕರಣ ವಿಚಾರಣೆ ನಡೆಸಲು ನಿಬಂಧಕ ವಿಚಾರಣೆಗಳು 11 ಇವರನ್ನು ನೇಮಿಸಿ ಆದೇಶ ಹೊರಡಿಸಿದ್ದು ವಿಚಾರಣೆಗಳು 11 ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಇವರ ಮೇಲೆ ಕ್ರಮಾಂಕ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಮಲ್ಲಿಕಾರ್ಜುನ ಕಂಟಪ್ಪ ಕರಂಜೆ ಹಿಂದಿನ ಸಹಾಯಕ ವಯೋನಿವೃತ್ತಿ 31/6/19 ವಯೋನಿವೃತ್ತಿ ಹೊಂದಿರುವ ಇವರ ಮೇಲಿನ ಆರೋಪವನ್ನು ರುಜುಪಡಿಸಲು ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು
Is there any rule authorizing, what does rule 11A1 say?
Yes, ma'am. That I have extracted in my grounds in the before the KAT.
Page.
In petition page number 8. First ground. My first ground is, it is that. 11A, action on the inquiry report. 11A1. May I read it, my lord? My lord's got it, my lord.
No, but under 11A, there appears to be prima facie power to remit the case for further inquiry. Now it's a total de novo inquiry without reference to evidence already recorded as of now.
Yes,
What has
ma'am.
been?
There is no evidence.
No, no. Now what has been ordered now
Yes,
is
ma'am.
going to be a completely fresh inquiry
Yes, ma'am.
without reference to the earlier proceeding.
Yes, ma'am.
That you say is not permissible under 11A
Yes, ma'am. Yes,
because
ma'am.
it only refers to further inquiry.
Yes, ma'am.
Yes, what do isn't it that appears to be the correct position? Now, further inquiry, of course, that power is there. So suppose there's a gap. Now one extra punch witness is not examined.
Left out.
You can do
In
that.
subsequently, my lord.
Yes.
Subsequently, he has acquitted from the criminal case also because there is no evidence.
Correct. That will leave. That will leave. Keep aside. So
Yes,
it cannot further inquiry cannot mean de novo inquiry.
The tribunal on the opinion that, my lord, it does not constitute initiation of fresh disciplinary proceeding, but it is a continuation of the proceedings for
How
the
it
remand.
can- Correct. That you have to demonstrate. Now the inquiry report is set aside now, literally. Huh? Now it's a de novo inquiry, isn't it? That
Yes.
you can't. Now, suppose there's a lacuna, the punch witness, like in that other
Only
case.
for that purpose.
That you, because it says further inquiry and submit report. That means the old material is on record and only for further inquiry you are sending it. Further inquiry will not mean that the earlier inquiry disappears. Because it says further inquiry. That means the earlier inquiry is still there. Isn't
Yes,
it?
sir.
But here, what is
For fresh proceedings,
that
inquiry
you can't do a fresh-
remitted to the.
We'll go back to the order. Annexure A8.
Operative portion, may I read, madam?
Page 90, 93, 93.
Page number 94.
Now, is it a de novo inquiry or further inquiry?
Further inquiry.
What do you say, madam? Is it only further inquiry?
No, my
ಪ್ರಕರಣವನ್ನು
lord, what-
ಹೆಚ್ಚಿನ ವಿಚಾರಣೆ.
My lord, here they what says, my lord, in the order portion before that, my lord, ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಸರ್ಕಾರವು ಪರಿಶೀಲಿಸಿದೆ. ಇವರು ಈ ಹಿಂದೆ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರಾಗಿ ಲೋಕೋಪಯೋಗ ಇಲಾಖೆ ಉಪವಿಭಾಗ ಇಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ 11/11 ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಬೀಸಿದ ಬಲೆಗೆ ಸಿಕ್ಕಿಬಿದ್ದಿರುವ ಮೇಲ್ನೋಟದ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣಾಧಿಕಾರಿಯ ದಿನಾಂಕ 28/3/2016 ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರವರು 1 ಇವರು ಆರೋಪಿತ ವಿರುದ್ಧ ಮಾಡಿದ ಆರೋಪವು ಇಲಾಖಾ ವಿಚಾರಣೆಯಲ್ಲಿ ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲವಾಗಿದ್ದರಿಂದ ಪ್ರಕರಣವನ್ನು ಹೆಚ್ಚಿನ ವಿಚಾರಣೆ ಮಾಡಲು ವಿಚಾರಣಾಧಿಕಾರಿಗಳಿಗೆ ವಹಿಸಬೇಕೆಂದು ಶಿಫಾರಸು ಮಾಡಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ದಿ ಲೋಕಾಯುಕ್ತ itself given the report that the charges are not proved. Along with that, my lord, the recommendation has given for the fresh inquiry. For that, my lord, that reason they are doing this. That for that also they have to secure the records. They have to examine materials, which is a properly duty of the inquiry, the disciplinary authority. That is also they have not done. Directly they have stated that, my lord, there one more inquiry. And report has to submit. One more report has to submit. That is also they have mentioned. ವರದಿಗಾಗಿ ಪ್ರಕರಣವನ್ನು ಹೆಚ್ಚಿನ ವಿಚಾರಣೆ ಮತ್ತು ವರದಿ both has to be submit. That means ವರದಿಗಾಗಿ ಅಂದ್ರೆ that they have to conduct the fresh inquiry along with the fresh report.
We'll have it tomorrow. We'll have it tomorrow. List the matter. We have listed preliminary hearing list. Preliminary hearing list tomorrow. Now this Constitution bench judgment.
Yes, ma'am.
Now you are saying though the word used is, though the wordings is further inquiry, in effect it will amount to a complete new inquiry is what you are saying.
Yes, my lord. The inquiry is completed, report is given. That means they have to conduct the fresh inquiry only.
Comment, you have to say which area Lokayukta left over
Please,
or vacuum ಅಂತ ನೀವ್ ಹೇಳ್ಬೇಕು.
for what purpose further
Yes,
inquiry is
yes,
required?
Required.
Yes.
Please,
So, but that, and that should be apparent from the order.
available
Ah,
records.
Gill's case. Kan? So the reasons
Yes, ma'am.
must be reflected in the order itself. Mohinder Singh Gill's case. That is, so we'll have it tomorrow.
Please,
Anything you can make a
please.
mention.
Please.
Yes.
Number one, the government advocate may be directed to intimate the
Just
assistant.
intimate. 3:30 meeting will not take place.
Madam, handle it.
Could it? That's the memo you have filed.
I have ready the memo, but sorry, 2 sets I have not. I will give to the mains clerk.
That memo also you give
Please,
to complete a dictation.
please.
Serial number 33, man, kindly be taken off week after next month. I have
30?
not received
Malad,
it.
33, Malad, tomorrow, it is, Malad, we are, it is on technicalities, Malad. And without, Malad, Malad, not competent, Malad, as on the date of, Malad, initiation of departmental inquiry, there were no C&R rules at all. The entire departmental inquiry, Malad, is non-est in the eyes of.
No rules as on.
No
the date
rules,
of
no rules as on.
The articles of charge.
Yes, Malad. As, thereafter, Malad, within few months, Malad, the C&R rules came into.
Correct. As on that date, there's no.
No, no, Malad.
They have not adopted it.
They're not adopted. Only after some 2-3 months, Malad, they have adopted.
Okay, we'll have it. Monday, Tuesday.
So week of, I have not received the instruction. I have sent the file, not, they have to entrust me.
Any one date for next week.
Date. Huh? 4th. 4th of February.
Please.
Malapur, look into and complete your instructions by the next.
32 also, Malad, to maybe taken tomorrow. It is also same trap case, acquittal. 32, Malad. This is also trap case, acquittal in a criminal case as well as in the departmental detail. Just like 29 months.
No, no,
You
no.
want
Both will be
29 is not similar with the 32 lordship.
no,
In
correct.
this present matter lordship, after lapse of 6 years,
Huh?
the article of charges have been framed. So lordship, and thereafter, after 5 years,
No, so we'll see. Today, we'll have it on some other day. Today afternoon.
tomorrow. If possible to.
one day flow never over.
Huh? Tomorrow.
It is not as similar as 29 lordship.
Huh?
Identical matters, what
No,
they
no, no,
follow.
that is not.
Date, 29 April.
Not tomorrow. Not tomorrow, we'll have it some other day.
Lordship, I'll take only 10 minutes.
No,
If
correct.
Lordship
We have
taking
to finish the
Yes,
other matter. 29, 29.
please.
ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು ಮಲ್ಲೇಪುರ ಅವರೇ, ನೀಟಾಗಿ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಕೂಡ. ಅಸಿಸ್ಟ್ ಪ್ರಾಪರ್ಲಿ ಎಲ್ಲ ಲೋಕಾಯುಕ್ತ ಕೇಸಲ್ಲಿ.
ಬರ್ರಿ ಸರ್, ನೀವು ಫೋನ್ ಮಾಡ್ತೀನಿ ತಗೋರಿ ನಾನು. ನಾಳೆಗಿಲ್ಲ, ನಾನು ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
Court officer, madam. Court officer, madam.
ಹಾ ಸರ್ ಹೇಳ್ರಿ, ಒಂದೇ ನಿಮಿಷ ತಡ್ರಿ ಸರ್.
Okay.
ಯಾವ್ದು ಇಲ್ಲ ಸರ್, ಪ್ರಿಂಟ್ ಬೇಕಂತ ಸರ್. ಹಾ ಸರ್, ಎಷ್ಟು ಪೇಜ್ ಇದೆ ಸರ್? ಸರಿ. ಹಾ ಹೇಳ್ರಿ ಸರ್.
Madam, serial number 35 ರೀ.
2:30ಗೆ ರೆಡಿ ಇರಿ ಸರ್. 2:30ಗೆ ನಿಮ್ದೇ ತಗೊಂತಾರೆ. ಒಂದ್ 4 ಫಾಸ್ಟ್ ಓವರ್ ಇದೆ, ಫಾಸ್ಟ್ ಓವರ್ ಆಗತ್ಲೆ ನಿಮ್ದೇ ತಗೊಳ್ಳೋದು.
ಹಾ ಸರಿ ಆಯ್ತು. ನಂದೊಂದು ಕೋಟಾಲ್ 2 ದಾಗ ಒಂದು ಮ್ಯಾಟ್ರ್ ಐತ್ರಿ, ಅದ್ ಮುಗಿಸಿ ಬಂದ್ಬಿಡ್ತೇನೆ. ಓಕೆ. ಹಲೋ.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಸರ್ ಅಲ್ಲಿ?
ಇಲ್ಲ ಅದು 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 ಪಿಟಿಷನ್ ಫಾರ್ ವಿಡ್ರಾವಲ್ಗೆ ಐತಿ, ಅದು ಮೆಮೊ ಕೊಡ್ಬೇಕಷ್ಟೇ.
ಸರಿ ಸರ್.
ಓಕೆ ಸರ್, ಏನಾರ ಕೇಳಿ ಸ್ವಲ್ಪ. ನಾ ಇವತ್ತು ಮಾಡ್ಲೇತೀನಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಇವತ್ತು. ಓಕೆ.
List number 2. Orders met serial number 1. Subhash Malla.
Nine and one are same. Serial number 9 and 1. Arising out of same order. WP 202318. Two zero two three one eight has been filed by the Karnataka Lokayukta, seeking for setting aside of the order of the Karnataka State Administrative Tribunal in application 311 of 2018, whereby the tribunal had disposed of the application setting aside the bills of charges, while noticing that the employee had attained superannuation, while reserving liberty to the government to initiate fresh action against the applicant employee if so advised, and if the claim of the government is within the period of permissible period of time permissible in terms of Rule 214 within bracket 2B Roman 2 of KCSR. WP 201741 of 2021 is filed by the Lokayukta against an identical order of the tribunal. It is to be noticed that the tribunal had passed a common order in application number 311 of 2018 and 310 of 2018, and accordingly, as the two writ petitions are filed challenging orders in the aforesaid applications, both the writ petitions are taken up for disposal and disposed of by a common order. It is the case of the facts are that the delinquent government officer, while working as assistant executive engineer, had completed certain works and defects were noticed, and accordingly, in light of such defects in work done, noticing lapse of the government officer, proceedings were entrusted by the government for inquiry. Articles of charges were also framed. Meanwhile, framed. Before the tribunal, the employees had challenged the validity of the proceedings, raising several grounds, including that they had attained superannuation. The tribunal has
disposed of the applications, taking note of the retirement of the petitioners and the relevant observations found at para 7 are reproduced. Para 7 and 8 are reproduced below. Next. Said orders as against the employees have been challenged. Full stop. It is to be noticed that insofar as aspect of the applicants in both the matters having attained superannuation in terms of the observations of para 7, that such aspect is clear that the articles of charges were framed after they had attained superannuation. Insofar as the right to hold inquiry is concerned, the observation of para 8 makes it clear that if the acts complained of fall within the time permissible under Rule 214 2B Roman 2 of KCSR, it's up to the government to initiate fresh action. In light of the undisputed fact that the employees had attained superannuation, if at all proceedings were sought to be initiated under 214 2B2, it is necessary that the action, which is a subject matter of inquiry, should have occurred 3 years prior to the date of superannuation, isn't it? Full stop. If that were to be so, such aspect is taken care of by the observation made at para 8. Accordingly, we find Lokayukta cannot be prejudiced by such observation nor aggrieved. And accordingly, we find no merits in the said petitions, and accordingly petitions are disposed of as not calling for any interference. Needless to state, observation at para 8 of the tribunal is always would take care of the interests of the respondents. AG accepts notice in serial number 9 for the state. ಆಮೇಲೆ ಇದರಲ್ಲಿ one sentence add ಮಾಡಿ that office objections are waived in WP 201741 of 2021. Further, notice may also not be required as regards the private parties in light of the matter being rejected, disposed of without interfering with the order of the tribunal, and accordingly no prejudice will be caused to the employee. Yes.
Number 2, SV Deshmukh.
Challenger annexure email.
Annexure
Email.
Page.
Let second respond when
Page.
Page
31 mail. Second respondent without following the procedure, he has accepted the notice matter because the two members are present, but he has not taken any photo of their members. Whether their members are panchayat or not, they have not mentioned.
No, what is your grievance?
No conference motion.
Huh?
Annexure E, no conference motion. Notice.
What is annexure F? Previous round.
Please.
Annexure F.
earlier representation, the earlier notice for the fixing date were quashed and liberty was reserved. After the, my lord, liberty, accordingly, they have filed one more
notice.
representation. This is the annexure E.
So what did the single judge do?
This order copy
It's
hachilla.
not statement. It's
Huh?
not statement.
Not state.
Yes.
Okay, so now what is your
ಇಲ್ಲ
grievance?
dismissed ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
Huh?
Stay.
Petition
You
is
are
dismissed, WP is dismissed.
dismissed.
Page
and
number
not
12.
But
Page
order,
number, it's an,
order is still awaited.
Yes.
yes.
So now what is the ground you are making?
My lord, notice is not proper, my lord.
Why?
Because when second respondent has issued notice, he has not taken any photo because that is a mandatory taking the note before
Where
the
is it
CC
mandatory?
cam. Pardon?
Where is it mandatory? Under which rule it's mandatory? Now, where is it mandatory to take photograph?
No, that is the. Just a necessary, man.
Huh?
Just a necessary to take the photos.
No, correct now. Where is it provided you have to take photos? Now, annexure D is the,
Yes, ma'am.
what is annexure D? The complaint
Yes, ma'am.
that is made to the assistant commissioner,
No,
Yes.
complaint has become influential.
isn't it?
Yes, ma'am.
So now what is your point now? They've given one complaint.
Yes.
There ends
And
the
they have
matter.
moved another motion also. No conference motion, they have moved.
Correct. Now, by virtue of annexure D, they have moved the motion of no confidence.
Yes.
Where is it that you have to take photo?
No, that is not mandated, but usually they will take the photos and the
That's
signature.
not required. Are you saying they didn't give it at all? Are you saying that these people didn't give the complaint at all? I'll issue notice, no stay. We'll see. They have to give the complaint. What does the rule say? They have to give in person, no?
Persons,
What
person,
rule?
they had given person, but whether members are present or not, they have not stated.
No, no, which is the rule? Rule 3(2), na? Yavdu?
4 million.
Let us see the rule.
No member of the Gram Panchayat vote on take part in the discussion any
Huh?
person.
Rule
All-
3,
Yes, madam.
written notice.
All
of-
the questions.
Alla, rule 3 ತಗೊಳ್ಳಿ. A written notice of intention to make the motion shall be in form 1, signed by so and so, together with copy of proposed, shall be delivered in person. In person. Yes, in person. In person. ದಿನಾಂಕ 1/1/21 ದಿನಾಂಕ 1/1/25 ಒಟ್ಟು 6 ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಸಲ್ಲಿಸಿದೆ. ಅಲ್ಲಿ ರಿಟನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ.
Yes.
ಯಾವ ಪೇಜ್? annexure D ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ 1/1/2025 ಒಟ್ಟು 6 ಸದಸ್ಯರು ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅಷ್ಟೇ ಮುಗೀತು. ಅವನು ಬರ್ದಿದ್ದಾನಲ್ಲ. ಸೊ ದೆನ್ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಇದೆ ನೋಡಿ. annexure D ನಲ್ಲಿ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಪೋರ್ಷನ್. ನಿಮ್ ಕಾಪಿ ಕೊಡಿ, ಅವ್ರಿಗೆ ಸರಿ ಕಾಣಿಸಲ್ಲ.
James.
ಸೊ ದೆನ್ ಹಿ ಇಸ್ ಬರ್ದಿದ್ದಾನಲ್ಲ, ಖುದ್ದಾಗಿ ಬಂದಿದ್ದಾನೆ. I'll issue notice, I'll make it subject to the result.
Please.
Issue notice, AGA accepts notice for the respondents.
1 and
1 and 2. Emergent notice to the remaining respondents. Petitioner is liberty to serve counsel who appeared for the private respondents in the writ proceeding.
Well, tomorrow's meeting is there. Tomorrow,
Now it's staying, but
please.
IF2 of 25 is allowed when petitioner is dispense with production of certified copy of WP order. Yes.
Astor mat. Number 10. Itcom dress.
Yes.
10.
Burnley, next pass.
Bill number 30. Santoshi.
Relist one.
27. Bill number 70. Ratna and Shivayogi Mat.
That's in this case, approach the tribunal by challenging the order dated 30th/7/2024, produced at Annexure A6. The earlier transfer order, my lord, produced at Annexure A2, 15/7/24.
This order of annexure A5 is
A6, that's one. Transfer order, impugned transfer order, Annexure A6.
A6.
Yes, ma'am. First one is, my lord, A2, that is 15/7/24. My name is found place in serial number, ink page 26, serial number 4, and
Serial number
A2, the page number 26, madam.
A2.
Yes, madam. That is first order, transfer order, madam, earlier, previous order. Ink page 26, serial number 4.
Anil Kumar.
Yes, my lords.
So you were posted as
In the Krasi Maratha Ilake, Kalaburagi.
Assistant Director, Agriculture Marketing.
Yes, my lords. Then the private respondent herein has transferred to Authorized vacant place. It was vacant.
So this order was passed on
15/7, madam.
15/7/24.
Yes, ma'am.
Now Savita, who is the second respondent?
Savita here, yes, ma'am.
She was transferred to Aura.
Authorized.
As a secretary, grade 5.
Grade 5, my lords. In her, that is her post.
Ah.
Grade 5, she is a grade 5 secretary.
Ah.
Then, my lord, the impugned order A6, my lord. My cadre is assistant director, grade 4 secretary. That is a private response is grade 5 secretary.
Annexure A6.
A6 is the impugned order, transfer order. Ink page 37.
This is on 30th July.
Yes, my lord, 30th July.
So you are saying it's premature.
Sir.
Now-
Yes, premature. Yes, my lord. That is the, yes, my lord, A6.
Now, in terms of annexure A6,
Yes, ma'am.
you are transferred where?
Transferred in ink page 38, my lord. In my place, she has been transferred to my place.
Savita has been transferred to your place.
My place, my lord. See, though she is a grade 5 secretary.
There is no order of transfer of you.
ಇದೆ. Let's the next serial number 7. ಸ್ಪೆಷಲ್ ಆಡಿಟರ್ ವಿಶೇಷ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು.
ವಿಶೇಷ ಲೆಕ್ಕ ಪರಿಶೋಧಕರು.
ಕೃಷಿ ಮಾರಾಟ ಇಲಾಖೆ, ಕಲಬುರಗಿ.
Now anyhow, irrespective of that, you are saying it's premature.
Premature, yes, my lord, the ಮೇಲೆ ಇದೆ transfer. It says that it discloses that is a transfer. In page AC 37 ದಲ್ಲಿ ಫಸ್ಟ್ ಮೇಲೆ ಹೇಳಿದಾರೆ ನೋಡಿ, ಅಧಿಸೂಚನೆ ಅಂತ. A6 in page 37. ಕೃಷಿ ಮಾರಾಟ ಮ್ಯಾರಿಡ್ ಕೃಷಿ ಮಾರಾಟ ಇಲಾಖೆ ಕೆಳಕಂಡ ಗ್ರೂಪ್ ಮತ್ತು ಗ್ರೂಪ್ ಬಿ ವೃಂದದ ಅಧಿಕಾರಿಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶವರೆಗೆ ಅವರುಗಳ ಹೆಸರಿನ ಮುಂದೆ ಸೂಚಿಸುವ ಸ್ಥಳಕ್ಕೆ ವರ್ಗಾಯಿಸಿ ಆದೇಶಿಸಿದೆ.
Yes. Now, is there any change in the new transfer guidelines?
If it is changed, my lord, they have to mention that it's not a transfer. They have issued this notification as a transfer.
Correct. No,
Yes.
but what is the transfer guideline? What does it say? New transfer guideline?
New transfer guidelines, the last occasion, the government advocate, it is produced in annexure.
The statement of objections are filed, my lord, wherein it is mentioned, my lord, it is not a transfer, it is a chalana movement, chalana valananta. That no, that my lord, GO, the order of Sarkarada Nadivaligal, the proceedings of the government is at annexure R1. As per R1, statement of objection ಜೊತೆಗೆ annexure R1 ಇದೆ.
A5 ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ, that is new guidelines. A5 in page 32. They are saying that first time they are taking contents and that it is not a transfer.
There are 10 of the statement of objection, my lord, that was narrated. Then.
Paratenದಲ್ಲಿ stated it is, they use the word as transfer, not the.
ಗೈಡ್ಲೈನ್ ಅಲ್ಲೂ ಮೇಲೆ ಅದೇ ಇದೆ ಸ್ವಾಮಿ, ಸರ್ಕಾರಿ ನೌಕರರ ವರ್ಗಾವಣೆಗಳ ಬಗ್ಗೆ
ಅದನ್ನೇ ಅವ್ರು implementation if it is, they have not disclosed that, first time they are taking such a that it's not transfer. They use the word in the issuing, while issuing notification, that is transfer. Well, as may kindly see the next annexure which I have produced in the annexure A7, my lords, for a moment, in page 39. Kind permission, lords may kindly see annexure A7 for a second.
Annexure?
A7, in page 39, my lords. Second para. ಸರ್ಕಾರಿ ಇದು this is the circular, the ಸರ್ಕಾರ ನಿಯೋಜನೆ ಸಂಬಂಧಿಸಿದ ಸೂಚನೆಗಳು issued. ಸರ್ಕಾರಿ ನೌಕರರ ವರ್ಗಾವಣೆ ಬಗ್ಗೆ ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ಹೊರಡಿಸುವ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ ಸೋ ಖಂಡಿಕೆ 6ರಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಹುದ್ದೆಗೆ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ಮಾಡುವ ನಿಯೋಜನೆಯ ಗರಿಷ್ಠ ಅವಧಿಯು 5 ವರ್ಷ ಎಂದು ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿದೆ. ಮುಂದುವರೆದು ಹಿಂದಿನ ನಿಯೋಜನೆ ನಂತರ ಮಾತೃ ಇಲಾಖೆಯಲ್ಲಿ 2 ವರ್ಷಗಳ ಚಾತುರ್ಮಾಸ್ಯ ಅವಧಿಯನ್ನು ಮುಗಿಸಬೇಕಾಗುತ್ತದೆ ಎಂಬ ಬಗ್ಗೆಯೂ ಸಹ ತಿಳಿಸಲಾಗಿದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಯೋಜನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಗಂಡ ಮುಂದುವರೆದ ಸೂಚನೆಗಳನ್ನು ನೀಡಲಾಗಿದೆ. ನಂಬರ್ ಡಿ ಮೇಲೆ ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್ ನೆಕ್ಸ್ಟ್ ಲಿಂಕ್ ಪೇಜ್ 40 is applicable to my case. The 40 ink page 40. This is one of the condition. I'll transfer. ಯಾವುದೇ ಇಲಾಖೆಯಲ್ಲಿ ಆದರೂ ಕೆಳದರ್ಜೆ ಅಧಿಕಾರಿಗಳನ್ನು ಮೇಲ್ದರ್ಜೆ ಹುದ್ದೆಗೆ ಸ್ವಂತ ವೇತನ ಶ್ರೇಣಿ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡುವುದನ್ನು ನಿಯೋಜಿಸುವುದನ್ನು ನಿರ್ಬಂಧಿಸಿದೆ.
Once more you read.
ಯಾವುದೇ ಇಲಾಖೆಯಲ್ಲಿ ಆದರೂ ಕೆಳದರ್ಜೆ ಅಧಿಕಾರಿಗಳನ್ನು ಮೇಲ್ದರ್ಜೆ ಹುದ್ದೆಗೆ ಅಂದ್ರೆ ಹೈಯರ್ ರ್ಯಾಂಕ್ ಪೋಸ್ಟ್ ಸ್ವಂತ ವೇತನ ಶ್ರೇಣಿಯ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡುವುದನ್ನು ಅಥವಾ ನಿಯೋಜನೆಗೊಳಿಸುವುದನ್ನು ನಿರ್ಬಂಧಿಸಿದೆ. She is a grade 5 secretary. Grade 5 secretary. Respondent, private respondent is a grade 5 secretary. She is not entitled to force their place in her pay scale to the post of the assistant directors. That is grade 4 secretary post.
Grade 4.
Yes, my lord. My post is a grade 4. In my place, she has transferred in her own pay scale. She is a grade 5 secretary. I have produced the cadre rules also.
But where is her posting?
ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದರಲ್ಲಿ one second. Ink page 26. 26 ಅಲ್ಲಿ
Own pay scale ಎಲ್ಲಿದೆ? Own scale. Own scale ಅಂತ.
Yes, yes.
ಎಲ್ಲಿದೆ ಅದು?
ಇಲ್ಲಿದೆ ಇದು. ಅವ್ರ ಪೋಸ್ಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಹೇಳಿದ್ದಾರೆ. ಇಂಕ್ ಪೇಜ್ 26 ಅಲ್ಲಿ ಅವ್ರ ಪೋಸ್ಟ್ ಡಿಸ್ಕ್ಲೋಸ್ ಆಗುತ್ತೆ.
Page 20.
26 ಆ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ನಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವಳು ನಂಬರ್ 5 ದಲ್ಲಿ ಕಾರ್ಯದರ್ಶಿ ದರ್ಜೆ 5, ಸೆಕ್ರೆಟರಿ ಗ್ರೇಡ್ 5. ಅವಳು ಇಲ್ಲಿದೆ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಇನ್ 3723 ಅಲ್ಲಿದೆ. ಅವಳು ಸ್ವಂತ ವೇತನ ಸ್ಕೇಲ್ ಅಂತ ಇದೆ ಅವಳು. ಇಂಕ್ ಪೇಜ್ 23 ಅಲ್ಲಿ her name is shown in serial number 2.
No, now government, they are saying that she is of a lower grade on own pay scale.
Yes.
She cannot be posted to a
Higher post.
Is it so?
For
Is her scale, is her grade less? If a grade is less, they are saying
yes,
that such posting is contrary to the direction at annexure
A7.
A7 circular that is issued by the government, the respondent here in secretary government. In A7, ink page 40.
What do you say?
Then ma'am, ink page 80 my lord, this is he has to promote from the grade 2 to grade 4 in the grade 2 ಹೋಗ್ಬೇಕಾರೆ it is 50% quota is there to promote from grade 4 to grade 2. Grade 2 secretary. Lord Assembly kindly see ink page 80 assistant director post ಗೆ. I have produced the cadre rules also.
No, that we see now, Mr. Tengli, you will have to clarify that. That's all. If your own says that you can't be posted on own pay scale.
As per A7, it is 23 notification and that is 13. It is Chalana Valana. As per, that is the only ground, my lord, for this to the government.
Correct.
Same city nalli only table change agide anta.
That is possible. That is possible.
Yes,
Chalana
madam.
Valana.
Whether the lower cadre officer can be given higher post, that I have to.
In terms of annexure A7D.
Please, my lord.
By referring that A7 my lord, you are solemnly kindly see produce annexure E, ink page 105. The similar, it may not be proper, but it was produced in the tribunal, my lord. Therefore, I am brought to the notice of this court. Ink page 105. Similar, same department, similar, identical circumstances. That judgment, it was produced before the court, my lords.
Page?
Therefore, I have produced 105, that is judgment, my lord. They have produced that circular, on the basis of that circular, in identical circumstances, my lords. They have allowed the application that, that has been extracted in the ink phase 118, my lords. That circular is extracted in the said judgment, in the identical same circumstances. Other 117, the last, adon the last para, my God, my lords permit.
Yes,
117, the last from last para.
yes.
By referring all those above judgments, my lord.
Yes.
In the instant case, though prior approval of the Honorable Chief Minister has been obtained, the fourth participant is not eligible to hold the post of grade 4, who is grade 5 official, and he has been posted to higher post on his own pay scale. It could be seen from the impugned order. As such, we have gone through the circular dated 12/9/23, produced along with memo dated so and so. ಯಾವುದೇ ಇಲಾಖೆಯಲ್ಲಿ ಅದರದ್ದು ಕೆಳದರ್ಜೆ ಅಧಿಕಾರಿಯನ್ನು ಮೇಲ್ದರ್ಜೆ ಹುದ್ದೆಗೆ ಸ್ವಂತ ವೇತನ ಶ್ರೇಣಿ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡುವುದನ್ನು ನಿಯೋಜನೆ ನಿರ್ಬಂಧಿಸಿದೆ. This has been issued by the Under Secretary Government. As this circular, the transfer and posting of fourth one to the higher post on his own scale is contrary to the above said circular. As such, plea taken by the applicant holds water. While admitting the application, the tribunal directed both the parties to maintain status quo as today, respect of the impugned order dated
Yes,
so and
yes.
so.
Now you find out.
But I'm-
Tomorrow,
I am for the contesting respondent in this matter, my lord. This question raised, my lord, by the, my lord, petitioner, my lord, may not be, my lord, required to be considered. The reason is, my lord, in the year 2023, my lord, at page number 23, as per annexure A1.
yes,
As per annexure A1, my lord, Anil Kumar is the petitioner, my lord, before the court first, serial number 1, my lord.
yes.
Number 2, Savita is, my lord, the present respondent.
Hmm.
I was posted, my lord, pursuant to this order as against the Anil Kumar Hadimani Yuras Thalake. My lord, he was sent to, my lord, Karatgi. Under this order, my lord, he was sent to Karatgi and I was posted against his vacant post. This order is not been challenged by him. He accepts this order.
No, no, that's okay.
Now, my lord, this is one aspect, my lord. Second aspect, my lord, I being, my lord, grade 5 category, my lord, I am due for promotion.
No, that's a different matter. Till promotion is.
I am eligible. I am eligible for the post. It is not that, my lord, a candidate, my lord, who is eligible, not eligible.
We don't know when promotion order will be passed.
My lord, that is
On date, as on date, whether it's, you can hold that post.
yes,
or
yes,
not.
yes. Because C&R rules, my lord, the primary requirement is for assistant grade, assistant director of agriculture marketing.
Let us
is-
see.
I should have considered.
No, let us see. Yes, government, you take instruction. Simple question.
Please.
Now, the Chalana Valana, they don't have a case. You are correct.
Please,
But in so far as A7D, you
Please.
take your stand.
please.
Tomorrow, day after tomorrow, when?
24th. ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಬರಕ್ಕೆ
24th ಬೇಡ.
ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಒಂದ್ ಡೇಟ್ ಬಂದ್ ಹೋಗುತ್ತೆ.
24th ಬೇಡ.
24th ಬೇಡ ಅಂದ್ರೆ 28th ಆಗ್ಲಿ.
ಇಲ್ಲ, 23rd ಗೆ ತಗೊಳ್ಳಿ ನಾನು.
ಅವ್ರು ಬಂದ್ರು ಅಂದ್ರೆ ನಮ್ಗೇನಿಲ್ಲ ಇವ್ರು ಲೇಟ್ ಬಂದು ಹೇಳ್ತಾರೆ.
23rd it may be.
No, ಏನೋ ತಗೊಂಡ್ಲಿ ನೋಡು. 27th.
May I request on 30th, my lord, I am out of station on that day.
No, let us see.
ನಾನು ಊರಲ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. It will be without, my lord, 30th, may I request, I will be here.
30th.
Please.
But we are making clear that
Please.
you will have to take.
Please,
your
madam,
stand.
Please.
Now, Ravi Patil is all contingent argument. ನಾಳೆ ಪ್ರಮೋಷನ್ ಆದ್ರೆ
As in,
ಅಂತ ಅವ್ರು ಆದಂಗೆ
ಇಲ್ಲ,
ಆಗ್ಬೇಕು.
what happens, my lord, there are several posts which are vacant due to promotion. The government doesn't take a call. They simply post us, my lord, based on, my lord,
Let us
own pay scale.
Let us see.
And he is holding dual post, my lord. That is also, my lord, request.
That will see.
Dual charge.
That will. Yes.
Number 23. Vishal Pratap Singh.
Filing objections.
Manoj, in this case, even if we take the case at its face value, may I request your lordship?
Want to have a look at what they filed?
Manoj?
Want to have a look at it?
Yes, yes.
Then
I-
tomorrow.
We'll have it day after tomorrow, Manoj. Day after tomorrow, hearing on IA. I'll just go through this.
PW3 is the eyewitness, my lords.
Hostile.
Hostile,
And
yes.
hostile.
Grateful.
Relist. Objections filed. So IA for suspension of sentence, relist on.
23. 23. Grateful, Manoj. I'm very good.
For 25.
Lordship, please. Is it serial number 25, Lordship?
Yes.
Lordship, I've taken the instructions. Lordship may remand me back, send me back for the fresh adjudication, Lordship. I'll participate.
In fact, my lord, in this case, that the learned single judge is permitted to be appellant to file an appeal before the Joint Commissioner Appellate Authority. If the delay is condemned also, he can establish his grievance before the Appellate Authority also.
No, correct. 74(5), if there's a violation.
I leave to principle of natural justice, let him have.
Yes. Now, just point out the relevant facts and where you are, the adjudicating authority has not afforded any opportunity under 74(5).
75-4, Lordship.
75(4).
Lordship, in my petition at page number 23, I've awarded.
Page 20.
Page 23, Lordship. There is a specific averment, para 22.
So now this proceedings of adjudication, where is the adjudication order?
Lordship, adjudication order
Next year.
starts from Lord's page number 161.
So now they have disallowed, or what is the adverse order now
Lordship,
passed?
Lordship, there was a dispute with regards to the difference of tax liability. I, as a contractor, was paying at the rate of 12%, wherein there was a notification which said that it has to be paid at the rate of 18%. So there was a difference of 6%. Lords may find that at page number 176, the amount which is quantified, Lords. Page 175, the table is there. Lords have page 175.
Yes.
Conclusion, Lords, at the top.
Yes.
Second param, Lords, you may be permitted to read. There is no doubt that the reduced rate of tax is applicable to the subcontractor effective from the date so and so and henceforth. But it is pertinent to note that the legislature also has not categorically mentioned that the reduced rate of 12 from 18 is applicable to the subcontractor providing services to the government entity prior to the issuance of said notification. And it would be against the interest of the revenue to extend the benefits of any law, provision, notification, circular, etc. prior to its date of issuance. So that is the controversy, wherein we are saying that the lower rate is applicable to us, and the department's contention is that the higher rate is applicable to us. So therefore, we want to present ourselves that why we are saying that the lower rate is applicable. So once an opportunity is afforded, we will be making a detailed submission with regards to that, and then they can pass a fresh order.
Now this opportunity is different from opportunity afforded to show cause.
Lordship, please.
Isn't it? That's your case.
Lordship. So they have issued show cause and they have passed an order because no one has appeared. Because the reply was not filed and the time barring was approaching. So they have passed the order. The time barring was...
Irrespective, you're saying irrespective of whether you replied or not, if an adverse order was sought to be passed
Lordship,
of,
they were supposed to give me an opportunity, last opportunity.
yes, Mallarao, we'll send it, we'll keep all contentions open.
Please, Lordship.
The present petition has been, present appeal has been filed in the order of the learned single judge passed in WP 200893 of 24, which came to be rejected. Which came to be disposed of, which came to be dismissed. Writ petition was filed by the SSC, calling in question correctness of the order, correctness of the notification number 9 of 2023 dated 31/3/2023. Petitioner had also challenged the validity of the show cause notice dated 29/9/2023 and summary show cause notice dated 30th September 2023. And the consequent order dated 21/12/2023 and summary of order dated 21/12/2023 after adjudication
Lordship.
at annexure C and C1.
Lordship.
The various contentions were raised before the learned single judge, including as regards the validity of the notification, extending time to complete the assessment proceedings.
Lordship.
The learned single judge, after a detailed order, while rejecting such contentions, has declined to uphold the contention of the petitioner insofar as notification 9 of 2023 dated 31/3/2023. While dismissing the petition, the petitioner SSC was permitted to file an appeal and time was granted to file appeal without reference to limitation in light of proceedings before this court. At the time of hearing of the present appeal, learned counsel for the petitioner submits that they would give up their contention regarding validity of notification number 9 of 2023 and submits that the learned single judge, despite turning down their contention regarding validity of notification number 9 of 2023, ought to have recorded a finding on other contentions raised, including that during the process of adjudication, no opportunity as contemplated under section 75(4) of the CGST Act was afforded despite the authority recording an adverse finding against the petitioner. Full stop. Attention is drawn to the averment made in the writ petition at paragraph,
That's paragraph 22,
page.
page 23, Lordship.
No, in the writ petition, this contention was raised, no?
Lordship, it was raised.
Just take me to the writ petition.
I'll point out that. Lordship, it starts from page number 103, Lordship. Para 24.
My attention is drawn to the specific pleading at paragraph 24 and 25
Lordship.
of the writ petition. 23, 24, 25.
Lordship.
Para 23 to 25. Full stop. Peruse the order, impugned order at Annexure C. Annexure C, isn't it?
Annexure C, Lordship.
It is noticed that the finding of the authority is that the petitioner is liable to pay tax at the rate of 18%.
Lordship.
And not 12% as asserted. Full stop. It is submitted that when such finding was being recorded, as noticed from the conclusion of the order of adjudication, the procedure contemplated under 75(4) ought to have been afforded. It is also noticed that though the SSC was afforded an opportunity to show cause, and despite no reply having been filed, however, procedure contemplated under 75(4) requires to be followed irrespective of whether reply is filed or not. Full stop. The standalone provision of the 75(4) requires that before any adverse order is being passed, opportunity of hearing ought to have been afforded. Where is the extraction of the provision? Page?
Lordship, page 103, para 24.
It is clear. Section 75 reads as follows. From 75(4) reads as follows. From a reading of the said provision, while the SSC may be granted an opportunity where request is made in writing, the provision also stipulates that such opportunity is to be extended where any adverse decision is contemplated against such person. Full stop. It must be noticed that in case of the contingency of as contemplated under 75(4) of where an adverse decision is contemplated prior to concluding, an opportunity of hearing ought to have been afforded. No, there is no evidence of such opportunity having been afforded. Accordingly, on such sole ground, the impugned order at annexure C accordingly, the order of the learned single judge is now this what happens to single judge's order now? Irrespective of that, this has to
Lordship.
this order has to go.
Lordship.
In light of the contention raised and noticed regarding violation of 75(4), the order at annexure C is set aside.
Lordship, at C1.
C and
That is-
C1
Lordship.
set aside, and the matter is remitted to the stage of
Show cause, Lordship.
reply, stage post show cause notice.
Lordship.
Stage of furnishing of reply to the show cause notice. Full stop. All contentions are kept open. In light of the peculiar facts of the case, though the petitioner has not made his challenge, though the petitioner has given up his challenge to the validity of circular number 9, notification number 9. So the single judge's order will have to be modified only, isn't it?
To the extent of the assessment process, that only modified, remaining it what have been upheld.
In the peculiar facts of the case, noticing that the petitioner has given up his claim insofar as the notification number so and so, the order of the learned single judge is modified so far as the operative directions are concerned, in terms of the observations made above. Accordingly, appeal is disposed of.
Lordship may give me 4 weeks time to file the reply, and then they can adjudicate me also within a time bound manner.
The petitioners to make out his reply to the show cause notice within 4 weeks from date of release of certified copy of this order.
Lordship, please. Lordship, can I request for marking the appearance of my name, Lordship, my appearance?
Yes. You can
Well,
just
that
give-
with regard to the upholding, my lord, is High Court, the learned single judge order been upheld, my lordship may be considered in the order, so that it will be entire India is going to be consideration with regard to the amendment, my lord.
No, correct. So we have modified it only to the operative.
That's what, with the specific word, my lord, if the considerations with regard to the 168A, that the upholding, that it's going to be consideration, my lord. Because other assessment order is order.
I'll make some observations.
Yes.
Please, my lord, in that.
Respondent 4 and 5,
4 and 5, not I'll take notice.
GA accepts notice for respondent
4 and
number
5.
4 and 5. What about 1 and 2?
One is the Sudhir Singh Vijaypur.
Huh?
One is Sudhir Singh
Central
Vijaypur.
Vijay Kumar for 1. 2.
2, 3, my lord, Girish was Ulimani.
Girish Hulmani.
Ulimani.
Ulimani.
Grateful, Lordship. Obliged.
And subsequently the same order, my lord. Both.
ಇನ್ನೊಂದು ಇದೆ.
That observations with regard to 168, my lord, it's because it's a central government amendment, my lord. Lordship is made an observation, it will be held for other state also, my lord. That is
Correct.
only the.
No, I'll make an observation But
Please,
since they've given it up, technically, that is, you have the benefit of relying on the single judge's order, but whether it attains finality is a different. I'll observe to that. Yes.
Please, my lord, that extent, my lord, is given up, then lordship is going to be upholding this learned single judge order to the extent of that only, my lord. 168 concerned.
Yeah, correct. So we have not applied our mind, so it should not become a division bench order, but we'll say he's given up his claim.
Please, my lord. Okay.
Lordship.
Yes, yes.
Number 34, Ganesh Nayak.
Appearing for the appellant lordship, senior counsel will appear through
We
this.
will take up your matter after next week only. Mr. Sham will give some more time. Mr.
My lords. Yes, my lord.
Mr. Sham will give some more time, but
Please, my
next week we will take up. Next
Please.
week. Yes,
Please, my lord. No problem.
next week.
Lordship, date may be fixed.
It will be in the list, my lord.
Yes, yes, yes. It will be in the list.
Please, very well.
Please, lordship.
Next week.
Monday or Tuesday, probably Tuesday.
Very well, my
Next
lord.
week.
Very well.
Number 35, Girisham Party.
Lords,
Yes.
may I submit, my lords?
Yes.
My lords, as yesterday I made only a gist of argument on sentence, my lord, that I have been already been convicted under section 498A and 302, my lords, and under 498A I have been convicted for 1 year, and under 302 I have been convicted for life imprisonment till rest of my life. Charges were being framed against me for 498A and astonishingly under 307, even after the notice to the court that the deceased is dead. And the learned trial court judge has made observation to that effect also in the impugned judgment at page number 5, my lord. And afterwards, 302 has also been charged against me, and hence I have been convicted thereafter on 498A and 302, as I already told, my lord. Now, my lord, my humble submission is that, my lord, based on 3 aspects, I'm going to address my arguments. First, number 1, arguments on acquittal. Number 2, arguments on section 30402, part 2. And next, arguments on the aspect that whether the sessions court is empowered to impose life imprisonment till rest of my life, my lord. So, based upon these 3 aspects, I'm going to address my arguments today, my lords. So, hence, my lord, my first arguments, kindly, I request my lords to have a look at the basic document wherein the criminal action was, criminal law was being set into motion against me. That is a dying declaration, exhibit P8, my lords. Yes, before that, the allegations which has been leveled against me is that, my lord, I being the husband of the deceased, and on a certain day, that is on unfaithful day, on dated second September 2015, I came to the house in a drunken state, and
Read the complaint, exhibit P8.
yes, obliged, my lord. ನಾನು ಮುಕ್ತ ಅಲಿಯಾಸ್ ಭಾಗೀರಥಿ ಗಂಡ ಬಾಲಾಜಿ ನಲಬಲೆ ವಯಸ್ಸು 30 ವರ್ಷ ಜಿಲ್ಲಾ ಸಾಗರ ಬ್ರಾಕೆಟ್ ಉಪ್ಪಾರ ಉದ್ಯೋಗ ಮನೆ ಕೆಲಸ ಸಾಕಿನ ಕಾಕನಾಳ್ ಗ್ರಾಮ ಹೇಳಿ ಬರೆಸಿದ್ದು ಅಂಡ್ ನಾನು ಈ ಮೇಲೆ ನಮೂದಿಸಿದ ವಿಳಾಸದವಳಿದ್ದು ಮನೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಉಪಜೀವಿಸುತ್ತೇನೆ. ಈ ಹಿಂದೆ ನನ್ನ ಮದುವೆಯು ನಾಂದೇಡ್ ಜಿಲ್ಲೆಯ ಕಲ್ಮಲ ಗ್ರಾಮದಲ್ಲಿನ ರಾಜೇಶ್ ಇವನೊಂದಿಗೆ ಆಗಿರುತ್ತದೆ. ನಮಗೆ 9 ತಿಂಗಳು ಹೆಣ್ಣು ಮಗು ಆಗಿದ್ದು ಅದು ತೀರಿಕೊಂಡಿದ್ದರಿಂದ ನನ್ನ ಗಂಡ ರಾಜೇಶನು ಡೈವೋರ್ಸ್ ನೀಡಿರುತ್ತಾನೆ. ನಮ್ಮ ತಂದೆ ನರ್ಸಿಂಗ್ ಮತ್ತು ತಾಯಿ ಕೌಸಾಬಾಯಿ ಇವರು ನನಗೆ 6 ತಿಂಗಳ ಹಿಂದೆ ಕಾಕನಾಳ ಗ್ರಾಮದ ಬಾಲಾಜಿ ತಂದೆ ಶ್ರೀ ರಂಗ ಇವನೊಂದಿಗೆ ಲಗ್ನ ಮಾಡಿರುತ್ತಾರೆ. ಬಾಲಾಜಿಗೆ ನಾನು 2ನೇ ಹೆಂಡತಿ ಇದ್ದು ಮೊದಲನೇ ಹೆಂಡತಿ 3 ವರ್ಷಗಳ ಹಿಂದೆ ಮೃತಪಟ್ಟಿದ್ದು 2 ಗಂಡು ಮಕ್ಕಳಿದ್ದಾರೆ. ನನ್ನ ಗಂಡ
Balaji is the appellant.
Yes. Balaji is the second husband, and even for Balaji, she is the second wife. Yes. ನನ್ನ ಗಂಡ ಬಾಲಾಜಿ ಇವನು ಕುಡಿಯುವ ಚಟದವನಿದ್ದು ಮದುವೆಯಾಗಿ 1-2 ತಿಂಗಳು ಸರಿಯಾಗಿ ಇಟ್ಟುಕೊಂಡು ನಂತರ ದಿನಾಲೂ ಕುಡಿದು ಮನೆಗೆ ಬಂದು ನನಗೆ ಹೊಡಿಬಡಿ ಮಾಡಿ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕವಾಗಿ ಕಿರುಕುಳ ನೀಡುತ್ತಿರುತ್ತಾನೆ. ಹಾಗೂ ತಾನು ಕೂಲಿ ಮಾಡಿದ ಹಣ ನನಗೆ ಖರ್ಚಿಗಾಗಿ ಕೊಡದೆ ಆ ಹಣದಿಂದ ಕುಡಿದು ಬರುತ್ತಿದ್ದು ನಾನು ಈ ಬಗ್ಗೆ ಕೇಳಿದಾಗ ನನ್ನ ಜೊತೆ ಜಗಳ ಮಾಡುತ್ತಿರುತ್ತಾನೆ. ಹೀಗಿರುವಾಗ ಇಂದು ದಿನಾಂಕ 2 ಸೆಪ್ಟೆಂಬರ್ 2015 ರಂದು ರಾತ್ರಿ ಅಂದಾಜು 7 ಗಂಟೆಗೆ ನಾನು ನನ್ನ ಮನೆಯಲ್ಲಿದ್ದಾಗ ನನ್ನ ಗಂಡ ಬಾಲಾಜಿ ಕುಡಿದು ಬಂದು ವಿನಾಕಾರಣ ನನಗೆ ರಂಡಿ ಮನೆಯಲ್ಲಿ ಏನು ಮಾಡುತ್ತಿದ್ದೀಯಾ ಅಂತ ಅಂದಾಗ ನಾನು ಬಾಲಾಜಿ ಇವನಿಗೆ ನೀವು ಈ ರೀತಿ ಕುಡಿದು ಬಂದರೆ ಸಂಸಾರ ಹೇಗೆ ನಡೆಸುವುದು ಅಂತ ಅಂದಿದ್ದಕ್ಕೆ ಬಾಲಾಜಿ ಇವನು ನನಗೆ ಬುದ್ಧಿ ಹೇಳಲು ಬರುತ್ತಿ ನಿನಗೆ ಇವತ್ತು ಖತಮ್ ಮಾಡುತ್ತೇನೆ ಅಂತ ಅಂದು ನನಗೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಮನೆಯಲ್ಲಿಟ್ಟಿದ್ದ ಬಾಟಲಿಯಲ್ಲಿನ my lords, I would like to press upon this point. That is, ಬಾಟಲಿಯಲ್ಲಿನ ಸೀಮೆ ಎಣ್ಣೆಯನ್ನು ನನ್ನ ಮೈ ಮೇಲೆ ಸುರಿದು ಚಿಮಣಿ ದೀಪದಿಂದ ನನ್ನ ಮೈಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದರಿಂದ ನನ್ನ ಎಡಗಲ್ಲದ ಮೇಲೆ ಗಟಾಯಿಗೆ ಹೊಟ್ಟೆ ಮೇಲೆ ಹೊಟ್ಟೆಯ ಕೆಳಭಾಗದಲ್ಲಿ 2 ತೊಡೆಗಳಿಗೆ ಹಾಗೂ ಮೊಳಕಾಲುಗಳಿಗೆ ಮತ್ತು 2 ಪಾದಗಳಿಗೆ ಬೆಂಕಿ ಹತ್ತಿ ಸುಟ್ಟ ಗಾಯಗಳಾಗಿದ್ದರಿಂದ ನಾನು ಚೀರಾಡುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಮನೆ ಹೊರಗೆ ಇದ್ದ ನನ್ನ ಅತ್ತೆ ಮಥುರಾಬಾಯಿ ಹುಯಿಸ್ PW4 ಇವರು ಬಂದಿರುತ್ತಾರೆ. ಬೆಂಕಿ ಹಚ್ಚಿ ನನ್ನ ಗಂಡ ಮನೆಯಿಂದ ಓಡಿ ಹೋಗಿರುತ್ತಾನೆ. ನನಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದ ವಿಷಯ ತಿಳಿದು my lord, ನನ್ನ ಅಕ್ಕನ ಗಂಡ ಧರ್ಮ ಮಂಡಲಿ PW7 ಇವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದಿದ್ದು ಗಾಯಗೊಂಡ ನನಗೆ ಇಲಾಜ್ ಕುರಿತು ನನ್ನ ಅತ್ತೆ ಮತ್ತು ಧರ್ಮ ಇವರು 108 ಆಂಬ್ಯುಲೆನ್ಸ್ ಬಂದ ಮೇಲೆ ಅದರಲ್ಲಿ ಹಾಕಿಕೊಂಡು ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ತಂದು ಸೇರಿಕೆ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರಣ ನನ್ನ ಗಂಡ ನನಗೆ ಕುಡಿದು ಬಂದು ನನಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕವಾಗಿ ಕಿರುಕುಳ ನೀಡಿ ನನಗೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಮನೆಯಲ್ಲಿಟ್ಟಿದ್ದ ಬಾಟಲದಲ್ಲಿನ ಸೀಮೆ ಎಣ್ಣೆಯನ್ನು ನನ್ನ ಮೈ ಮೇಲೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದರಿಂದ ನನಗೆ ಸುಟ್ಟ ಗಾಯಗಳಾಗಿದ್ದು ಈ ಬಗ್ಗೆ ನನ್ನ ಗಂಡ ಬಾಲಾಜಿ ಇವನ ವಿರುದ್ಧ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವಿನಂತಿ ಇದೆ. So my lord, here 4 points will emerge, my lord. First, number 1, that is the only eyewitness to the.
Who recorded the statement?
Yes, it is PW13, my lord. No. Yes, PW30 Hanumantappa, who is the investigating officer.
PSI, PI. PSI.
Yeah.
Recorded
And
on 29.
Recorded. Yes, 29 only. ಅದರಲ್ಲೇ ಓದಿ ಹೇಳಿ ಕೇಳಿ ಸರಿ ಇದೆ, ಸಹಿ so and so. Yes.
At about 9, timing.
At 45 minutes.
At about 9:45 PM. At government
So,
hospital,
Yes, hospital Balki.
Balki.
ನನ್ನ ಸಮಕ್ಷಮ ಡಿ ಅಂತ ಎಲ್ಲಿದೆ ಸ್ವಾಮಿ, ತಾವು ನೋಡ್ಬೋದು ಅದರಲ್ಲಿ. In the same, in the original one, in the exact exhibit P8.
So on the strength of this complaint, he registered FIR.
Yes, yes.
In crime number 193,
2015, my lord.
Hmm.
Punishment section 498 and 307.
Hmm.
ಸೊ ಇಂದು ದಿನಾಂಕ 2/9/2015 9:45 ಗಂಟೆಗೆ ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಿಂದ ಒಂದು MLC ಪತ್ರ ಬಂದಿದ್ದು ಸ್ವೀಕರಿಸಿಕೊಂಡು ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಭೇಟಿ ನೀಡಿ ಸುಟ್ಟ ಗಾಯಗಳಿಂದ ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದ ಶ್ರೀಮತಿ ಮುಕ್ತಾ ಅಲಿಯಾಸ್ ಭಾಗೀರಥಿ ಗಂಡ ಬಾಲಾಜಿ ನಲಬಲೆ ವಯಸ್ಸು 30 ವರ್ಷ ಇವರಿಗೆ ವಿಚಾರಿಸಿ ಇವರು ಬರೆಸಿದ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡು ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಡೆದುಕೊಂಡು ಮರಳಿ ಪೊಲೀಸ್ ಠಾಣೆಗೆ 11 ಗಂಟೆಗೆ 2300 ಗಂಟೆಗೆ ಬಂದು ಫಿರ್ಯಾದಿ ಹೇಳಿಕೆ ಸಾರಾಂಶದ ಆಧಾರದ ಮೇರೆಗೆ ಬಾಲ್ಕಿ ಗ್ರಾಮೀಣ ಪೊಲೀಸ್ ಠಾಣೆ ಗುಣ ನಂಬರ್ ನಿರ್ಧಾರ ಪ್ರಕಾರ ಗುನ್ನೆ ದಾಖಲಿಸಿಕೊಂಡು ಮುಂದಿನ ತನಿಖೆ ಕೈಗೊಳ್ಳಲಾಯಿತು. ಲಾರ್ಡ್, my submission on this dying declaration is that as on the date of incident there are only two eyewitnesses, that is the husband, that is the appellant herein, and the deceased. So there are no other eyewitness to this incident.
Mr. Counsel, please complete the facts first. So
Yes,
initially this FIR registered for the offense 307.
Yes, 307 and 380. Yes, ma'am.
When she succumbed to the injuries?
Yes, she has succumbed to injuries on 21/9/2015, my lord. 21 September 2015.
20th.
After 20 days,
20th.
Yeah.
20th.
Yes.
29/2015.
No, my lord, it is 21/9, my lord. As per postmortem report, it is 21/9.
So anyhow, after 19 days or 20 days? After 18 days?
18 to 19 days.
Yes.
After 18 to 90 days?
Yes, yes. She has succumbed to injuries and
thereafter 302 invoked.
And that invocation letter is at 302. Requisition letter at Exhibit P9, my lord.
Yes.
Now, my lord, my submission on this declaration. Just before that, my lords, I would like to first go on the Exhibit P1 and along with PW1 and 2 deposition, who are the punch witnesses for spot Panchanama. Exhibit P1 is the spot Panchanama report, my lord. Here, PW1 and 2 have turned completely hostile. Because they say in only one word that PW1 says Exhibit P1 was being made to be signed by me, by the police, when they approached me while I was sitting in the hotel in the village, in the Balki village. And second, and PW2 says in the same tone that the police approached him while he was sitting in Kirana store at Balki village.
Just tell us, what is the whether this Mathuraba is supported? PW4, your father, your mother.
He has turned completely hostile.
He completely turned hostile. Okay. Whether this Dharma Mandali is supported, Dharma Mandali.
Yes, ma'am.
He
Yes,
supported.
He
supported the case of prosecution.
Yes.
What is your submission now in respect of Exhibit P8?
My lord, Exhibit P8, my lord, here undisputably 4 factors. Number 1, the eyewitness to the incident are that the deceased and the appellant herein, because the allegation is that the appellant absconded from the place after he setting his wife ablaze on fire. Number 2, the kerosene bottle has been, as per the averment made in dying declaration by the deceased, she says kerosene bottle has been taken by the appellant and it has been poured on her and chimney and with help of Deepa, the fire was been set, my lord. And hence, my lord, my humble submission is that as per the FSL report, which is at Exhibit P16, my lord, which is the FSL report only, in the spot Panchanama, they have seized 4 MOs undisputedly, and they say that 4 MOs are being seized as per the aspect of showing those 4 MOs by the PW4, who is the mother of appellant. Those four MOs are: first one, kerosene can, which is of 5 liter capacity. Number two, chimney. Number two is 5 liter capacity, and number two is semen bottle chimney, that is MO2, and MO3 is one sari. Number three is one langa. My submission is that, my lord, the deceased never said or never attributed the action, the criminal action which is being made by the appellant hearing with the help of can, which is of 5 liter.
Huh?
5 liter can, Anna. 5 liter kerosene can was never been used for committing the crime. That is my submission. But this was being seized from the spot and it is being made in connection with the crime. That is my humble first submission. Second submission, the only object which is being used.
In the complaint, there's no reference to can.
No, my lord. My lords may see in the typed copy of the exhibit P8, my lord.
Where do you get the size of the can?
Sorry, my lords.
Size of the can, you said 5 liter something you had mentioned.
Yes. It is in exhibit P16, my lord, FSL report. Page number 41 of the typed copy. Adರಲ್ಲಿ 1, 2, 3 ಅಂತ ಹೇಳಿ from the bottom, this method of analysis. One sealed white cloth packet containing 5 liter capacity. My lords, are there?
Yes.
Yes, first and in the next immediate appended page, even they have received the acknowledgement. The police have received the State Forensic Science Laboratory dated 22nd September ಅಲ್ಲಿ ಅವರು ಕೂಡ acknowledgement ಕೊಟ್ಟಿದ್ದಾರೆ that yes, we have received 5 liter can from the police car. When this material object is not being used.
So your submission would be there is a difference for chimney lamp and this can, this MO.
No, can is not at all used for committing the crime. First submission. Second, the chimney lamp which is being used for committing the crime, though it is being seized as a material object, it is not been sent as an FSL. Yes, it is not been sent for the FSL. Second submission.
What about the chimney? Was a chimney bottle?
Chimney is been seized from the place, my lord, but never sent for FSL. In exhibit P16, plastic can is been sent in spite of chimney, in the place of chimney. That is my submission.
According to you, the bottle, kerosene bottle was used as per exhibit P8.
Yes, ma'am.
So whereas the police have seized a can.
Can.
Huh?
Yes.
That is the difference.
Yes.
Yeah, yes. Right. That is the first point. Next.
Bottle is never measuring 5 liter, my lord. Can is measuring 5 liter. That is my submission. And also, my lord, in the and even very interestingly, my lord, in the FSL report as per exhibit P16, neither the police who has taken these MOs to the FSL laboratory, he has been examined. Neither the author of this FSL report has been examined. He is neither charge sheet witness nor the PW witness.
What required, Mr. Counsel? Say,
Yes.
He's
Yes,
he's an expert. His evidence can be placed, his document can be placed by the investigation officer. It is having the same evidentiary value. ಯಾವುದು section ಯಾವುದು? SPP ಅವರು. SPP section ಯಾವುದು?
Which is, sir?
Need not examine FSL.
Expert evidence.
Section.
32 minutes. 32.
Hmm?
32 it seems. 32 plus 6. Yes.
Yes.
Yes. 32 of it.
I guess, man, if I'm wrong.
32 and 36 both.
Evidence factor level. Yes. Yes.
And the third submission, my lord, as per this FSL report is concerned, the police, that is the IO, in a single tone, he says that it has been sent to Kalaburagi FSL Center. But this report is been obtained from Bangalore FSL Center, from Withdrawal. In his cross-examination, he agrees to that effect, that it has been sent to Kalaburagi FSL Center. Hence, this document is neither admissible nor reliable in the eye of law. The document itself is not reliable.
Yes.
May I?
Yes.
The first submission, my lord. And coming on to the PW1 and 2 have turned completely hostile, and they have also stated that the place of crime is not been shown by the appellant's mother, my lord, and even the appellant mother has told to that same effect, even though she has turned hostile. My lords can find that in PW4 in the first paragraph, my lord.
Now tell us one thing. Why we have to disbelieve the contents of exhibit P8?
Yes, my lord. In exhibit P8, when we come to exhibit P8, my lord, my first submission on that is that exhibit P8 never shows about the fitness certificate of the deceased man. The doctor never affirms up to that effect. And neither the doctor has been examined by the prosecution, neither as a charge sheet witness nor as a prosecution witness. My first contention. And second contention will be that, generally speaking, my lord, the mother of the deceased says that she is not aware of Kannada language. But here the IO says that Heli Barisiddu. When the victim is not aware of Kannada language, how can she tell in Kannada language, and that came to be recorded by the IO? My lords can find that in a PW6 cross-examination. She says, page number 60 of the paper book.
59. PW6.
59-60, my lord. 59 is chief examination. 60, my lord, in the last two lines, my lord. Page 60. ಅದೇ ರೀತಿ ಮೃತ ಭಾಗೀರಥಿಗೆ ಕನ್ನಡ ಭಾಷೆ ಮಾತನಾಡಲು ಬರುತ್ತಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಕೆಗೆ ಯಾರು ಕನ್ನಡ ಮಾತನಾಡಿದ್ದರೂ ಆಕೆಗೆ ತಿಳಿಯುತ್ತಿರಲಿಲ್ಲ. So these are controversial statements. Contradictory statements. Yes. So my submission would be that if I am talking to a certain person in a certain language, then if he is understanding, he will give a rational answer. If he is not understanding, then he will not reply to me. Hence, he says, "Matanadiddaru ki tiliyuttirilla." It means that what she has deposed, though he has written, when it has been again repeated to her for clarification, she was not in a position to understand that dying declaration. When she is not,
ಆಕೆಗೆ ಕನ್ನಡ ಭಾಷೆ ಮಾತನಾಡಲು ಬರುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. She denied the suggestion.
Yes, but after that, my lord, again enter contrary statement.
ಯಾರು ಕನ್ನಡ
ಆಕೆಗೆ
ಆಕೆಗೆ
yes, ಆಕೆಗೆ ಯಾರು ಕನ್ನಡ ಮಾತನಾಡಿದರೂ ಆಕೆ ತಿಳಿಯುತ್ತಿಲ್ಲ. ಸೊ ನಾನ್ ಈಗ ಮುಕ್ತ ಈಗ ನಾನ್ ಅಯ್ಯೋ ಅಂತಂದ್ರೆ ನಾನ್ ಅಯ್ಯೋ ನನಗೆ ಅವರು ಟೈಮ್ ಡಿಕ್ಲರೇಷನ್ ಹೇಳಿದಾಗ ಅದು ನಾನು ಬರ್ಕೊಳ್ತೀನಿ. ಅವ್ರಿಗೆ ನಾನು ವಾಪಸ್ ಕೇಳಿದಾಗ she not understand it.
It's not in question and answer format. She only deposed.
Yes.
She only stated. It's not a question and answer format.
Yes. And also as the Supreme Court has observed in many judgments, before taking dying declaration or this thing, the person who is recording the dying declaration, he must first ask some rational questions that whether she is in a fit condition to answer this. That is not there in the dying declaration. He starts immediately. He starts immediately. That is my submission. Hence, this dying declaration itself is not reliable. And my lord, now coming to this dharma, which is a PW7. Coming to this dharma.
This is the statement given by the injured at the earliest point of time.
Yes,
Thereafter, she lived for a period of, she was alive for a period of 20 days.
20, yes.
90 days. So, this need not necessarily be treated as a dying declaration. This is a statement, oral statement, immediately after the incident. So, this statement, evidentiary value can be attached on this statement.
Yes, my lord, but the witness certificate, nothing, lord. Nothing is there on this. Witness certificate, it became a PW13, if my lord see that. When the question was being posed to the IO, that ಇಮ್ಮಲ್ಲಿ ಡಾಕ್ಟರ್ ಇರ್ಲಿಲ್ವಾ ಮಾಡೋದಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇದ್ರು ಕೇಳಿದೀನಿ ಅವ್ರಿಗೆ ಯಾರಿದ್ದಾರೆ ನನಗೆ ಜ್ಞಾಪಕ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. He is not going to. And second point is what he says there is that
fact remains that she lived for a period of 19 days thereafter.
19. Yes. Yes.
All right. Next, dharma, evidence of dharma.
And yes, my lord. And even as per the as per exhibit as per PW13 statement, my lord, that is the IO. At one point of time says that while recording dying declaration, there was immediate presence of PW4 and 7. There was a presence of them while he was recording the dying declaration. Hence, there is high chance of tutoring. In the cross examination, he states like that. PW13. Hence, on these set of facts, my lord, I most humbly submit that the exhibit P8 is not believable. And also, my lord, if my lords see that there is one document called as Muchalike Patra, my lord, which has been signed by the same victim itself. When on the last date of hearing, I came to the court, my lord, and I saw the document myself. There is some signature mismatch, my lord, in the exhibit P8 and also at Muchalike Patra, which has been signed by the same deceased. In the original file, it is there. ಸ್ವಲ್ಪ mismatch ಇದೆ.
P8
and that Muchalike Patra is the letter that ನಮೂನೆ CRP section 170 clause 2 clause 4 ನಿದ್ದನ್ನು ನೋಡಿ ನಾನು ವಾಪಸ್ ಬಂದು ಸಾಕ್ಷಿ ಹೇಳುತ್ತೇನೆ ಅಂತ. So it is in that format, my lord. There the signed.
Mark ಆಗಿಲ್ಲ.
No, it is not marked, my lord. But the signature is mismatch of the deceased, same deceased.
How we can rely? The document is not reliable.
Yes. My apologies.
Next.
Now, my lord, coming to PW7, my lord. PW7 is the elder sister's husband of the victim, my lord. Dharma.
PW7.
PW sorry, the victim's elder sister name was Janabai, who is PW8. Her husband is PW7. Now, his role is that, my lord, the victim says in her dying declaration that after my husband has set me ablaze, my my mother-in-law came to my rescue, and after knowing the fact that I have been set ablaze, my brother-in-law came to me, and they both took me to the hospital. So when this is the exact statement made by her, now PW7, my lords may have a look at the chief examination, my lord. It is at 61, page number 61, my lord.
Read the evidence of PW7.
Yes. ಸುಮಾರು 3 ವರ್ಷಗಳ ಹಿಂದೆ ಮೃತ ಮುಕ್ತ ಭಾಗೀರಥಿ ಆರೋಪಿ ದಗ್ಧ ಮಾಡಿತ್ತು. ಮದುವೆ ಆದ ನಂತರ 1 ವರ್ಷ ಆರೋಪಿಯ ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದಳು. ನಾವು ನೆಕ್ಸ್ಟ್ ಆರೋಪಿಯ ಸರಾಯಿ ಕುಡಿದು ಬಂದು ನನ್ನ ಹೆಂಡತಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದನು. ಸದರಿ ವಿಷಯವನ್ನು ಫೋನ್ ಮುಖಾಂತರ ನಮಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ದಿನಾಲು ಆರೋಪಿ ಸರಾಯಿ ಕುಡಿದುಕೊಂಡು ಬಂದು ಆಕೆ ಹೊಡೆದು ಹಿಂಸಿಸಿಕೊಡುತ್ತಿದ್ದನು. ನಾವು ಇಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಆರೋಪಿತನ ಊರಿನಲ್ಲಿ ನಮ್ಮ ಸಂಬಂಧಿಕರು ಪ್ರಶಾಂತ್ ಈತನ್ ನನಗೆ ಫೋನಲ್ಲಿ ಕೆಲಸ ಇದೆ ಬಾ ಎಂದು ತಿಳಿಸಿದನು. ನಾನು ಕಾಕನಾಡ ಗ್ರಾಮಕ್ಕೆ ಬಂದು ಊರಿನ ಸಂಬಂಧಿಕರ ಮನೆಯಲ್ಲಿ ಇದ್ದೆ. ನಾವು ಇಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಮೃತ ಭಾಗೀರಥಿ ಫೋನ್ ಮಾಡಿ ನನ್ನ ಗಂಡ ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿ ಸುಟ್ಟಿರುತ್ತಾನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾಳೆ. ನಾನು ನನ್ನ ಸಂಬಂಧಿಕ ಪ್ರಶಾಂತಿಗೆ ಫೋನ್ ಮಾಡಿ ಆಂಬ್ಯುಲೆನ್ಸ್ ಫೋನ್ ಮಾಡಿ ಕರೆಸಿ ಎಂದು ಹೇಳಿದ್ದೇನೆ. ನಾನು ಮೃತಳನ್ನು ಆಂಬ್ಯುಲೆನ್ಸ್ ನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಬಂದು ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಚಿಕಿತ್ಸೆಗಾಗಿ ಸೇರಿಸಿರುತ್ತೇನೆ. ಮೃತ ಮುಕ್ತ ಅಲಿಯಾಸ್ ಭಾಗೀರಥಿ ಫೋನ್ ಮಾಡಿದಾಗ ಸಂಜೆ 7 ಗಂಟೆ ಆಗಿತ್ತು. ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿಗೆ ದಿನ ಕುಡಿದು ಬಂದು ಹಣ ಕೊಡು ಎಂದು ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದ ಎಂದು ಹೇಳಿದಳು. ಆರೋಪಿತನ ಸರಾಯಿ ಕುಡಿದು ಬಂದು ತನಗೆ ಸೀಮೆಣ್ಣೆ ಹಚ್ಚಿ ಬೆಂಕಿ ಸುಟ್ಟಿರುತ್ತದೆ ಎಂದು ಹೇಳಿರುತ್ತಾಳೆ. ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್ ದಟ್ the incident occurred undisputedly at around 7 p.m. in the evening on dated 2nd September 2015, my lord. So, when a certain person is being set at fire, ablaze, at 7 p.m. in the night, how come that person take a phone, call him, and he comes to that place, takes her to the hospital?
Shifted then, according to you, who else shifted? Then you
I think it is the PW4 who has shifted.
PW4? Who is PW4?
Mother-in-law of the deceased man. That is, and even his presence in that village is also disputed, because he said,
just see exhibit P8, what it reads on 2/9/2000 ರಂದು ರಾತ್ರಿ ಅಂದಾಜು 7 ಗಂಟೆಗೆ ನಾನು ಮನೆಯಲ್ಲಿರುವಾಗ ಗಲಾಟೆ ಆಯಿತು. PW7 says 7 ಗಂಟೆಗೆ ಆಗಿತ್ತು, ಫೋನ್ ಮಾಡಿದಾಗ 7 ಗಂಟೆ ಆಗಿತ್ತು.
Yes, my lord. That is okay, but my submission is, when I am in the state of fire, I have been set into fire. How can I take the phone call and ring that person and call him from different place? Come here, please rescue me. I am on fire. How can I do that? That is my submission. When I am on the verge of fire, the first immediate rescue would be that I would call for help. I will not take the phone and call other person to come. Yes, you please come me and you please take me to the hospital. That I will not do. And when the doctor affirms that on the date of incident, she was sustained 35% of injuries.
So immediately after the incident, she was unable to call Antla. That is
yes.
Your imagination.
No, my lord, my humble submission, not my submission. That is my submission. And so second,
we have to disbelieve the evidence of exhibit P7 and exhibit P8, PW7 and P8. We have to believe your version that it is impossible to call her Anta. That would be your submission. Next item. Yes.
Now, my lord, but what I have prepared, I am submitting, my lord. I seek apologies if I make wrong submission.
Mr. Counsel, first of all, you have to bear in mind that the apex court and this court repeatedly held the minor contradictions in the evidence or in the documents which does not go to the root of the prosecution, those discrepancy cannot be, it cannot be, it can just, we can neglect those discrepancies. If any, the contradictions which goes to the root of the prosecution case, then only those contradictions can be considered.
Yes,
Huh?
true.
While appreciating the
Yes,
evidence. That is how
Yes,
evidence
indeed.
has to be appreciated in a criminal case. Hmm. Yes, yes.
So, my lords, the second contention which I am raising before the honorable court, as far as PW7 is concerned, my lord,
Hmm.
he is saying
Hmm. Either disconnected. Huh? Hmm. Yes, SPP, why these police have not recorded the statement thereafter for a period of 20 days?
As per the exhibit P9, my lords, they have given requisition to the Tashildar,
Hmm.
who is a CW20, who has not been examined, my lords.
Hmm.
And this particular deceased has been shifted to the Latur, my lords.
Hmm.
It comes in Maharashtra.
Hmm.
So thereafter, it has come in the charge sheet that, my lords, the Tashildar has recorded the statement of that particular deceased, my lords. But that is not with me, my lords, but his name is in the charge sheet column. But he has not been examined, Tashildar.
The Tashildar, huh?
Yes.
They were not visited, they never visited that hospital at all.
And
The
no,
subsequent hospital.
no, my lords. Only shifted over there, and after her death only they went over there, and inquest Panchnama has done, and that has been same has been
Was
translated.
treated for 18 days in
In Maharashtra, Latur. Latur.
The police have not visited there.
Not visited. But all the investigation has been done by PW13.
Hmm.
The almost 80% investigation has been done by him. Yes. And the
Now
defense
the mother-in-law, obviously, she turned hostile.
obviously, my lords.
Hmm.
And all have supported the case of the prosecution.
So, but PW 4 and 5, the parents are hearsay.
Hearsay and also they have, of course, my lords.
They stated about
But
498.
as far as PW 7 is concerned, my lords, they have defense has taken two defense. One is the deceased has got a illicit relation with PW 7. And there they have, the same has been denied, and even they haven't said in 313 statement also, this particular appellant, my lords. If that is there, you would have given any explanation in 313.
What is their explanation?
Nothing, only denial simply.
Denial.
Yes. And secondly, my lords, suicide ಮಾಡ್ಕೊಂಡಿದ್ದಾಳೆ ಅವಳು ಅವನ ಜೊತೆ ಇದ್ಳು ಅಂತ ಹೇಳಿ, that is the defense which has been taken. Where they
PW 7.
PW with PW 7. She happens to be the PW 7's wife sister.
Brother-in-law.
She is wife sister, yes. Nah. So, my lords, there must be some documents or there must be some evidence to the effect that she was having illicit relation with him. And it has to be it has to be expressed by somebody else. And she came only sudden after her death, this has come.
The cruelty continued even after death also.
Yes, my lords.
By making such allegations.
Such allegations. And they went on going assassinating her character even after her death.
ಸತ್ತ ನಂತರ ಬಿಡಲ್ಲ ಅಲ್ವ ನೀವು ಮತ್ತು ಪುನಃ ಎಲಿಗೇಷನ್ ಆಗ್ತಾನೆ ಹೋಗ್ತಿರಲ್ವ?
That is there, my lords.
May I submit, my lords?
ಬೇರೆ any other evidence? 4 and 5. Just a minute, Mr.
Yes.
4 and 5. 4 and 5 are the parents.
4 and 5 are the parents, my lords.
No. 5, 6, 7, my lord. 5, 6, 7, and 8, my lord. 4 is the mother-in-law.
6 and 7.
Mathurabai, 4 is the accused mother. And 5 nursing and 6 Kosabai is a deceased father and mother. Parents.
What is their evidence now?
That is in 55 and 57 and 59 minutes. The page number.
May I submit, my lord? On that?
Just a minute.
Yes.
57. Nursing who is a father, deceased father. Shall I read, man? And my lords may kindly have a glance on the cross-examination wherein it has been done. Nothing has been elicited. Even in the investigating agency, they have cross-examination only in 3 lines. So rather Dr. 2.
Yes. So according to PW 5 and 6, she made oral statement before them.
Yes.
In the hospital.
Yes.
May I submit, my lord?
Just a minute, Mr. Counsel. Just a moment.
Yes.
And PW 7, my lords. Why he went over there? He narrated. Shall I read? Mrata Mukta. My lords, the page number 61. 3 ವರ್ಷಗಳಿಂದ ಮೃತ ಮುಕ್ತ ಬಾಗಿಲು ಸೊ ಅಂಡ್ ಸೊ ಮದುವೆಯಾದ ನಂತರ 1 ವರ್ಷ ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿಯನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದನು. ಆರೋಪಿಯು ಸರಾಯಿ ಕುಡಿದುಕೊಂಡು ಬಂದು ತನ್ನ ಹೆಂಡತಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದನು. ಸದರಿ ವಿಷಯವನ್ನು ಫೋನ್ ಮುಖಾಂತರ ನಮಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ದಿನಾಲು ಆರೋಪಿ ಸರಾಯಿ ಕುಡಿದುಕೊಂಡು ಬಂದು ಆಕೆಗೆ ಹೊಡೆದು ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದನು. ಆರೋಪಿತನ ಊರಿನಲ್ಲಿ ನಮ್ಮ ಸಂಬಂಧಿಕರು ಪ್ರಶಾಂತ್ ಅಂತ ಇದ್ದನು. ನನಗೆ ಫೋನ್ನಲ್ಲಿ ಕೆಲಸ ಇದೆ ಬಾ ಎಂದು ತಿಳಿಸಿದನು. ನಾನು ಕಾಕನಾಳ ಗ್ರಾಮಕ್ಕೆ ಬಂದು ಊರಿನ ಸಂಬಂಧಿಕರ ಮನೆಯಲ್ಲಿ ಇದ್ದೆ. ಮೃತ ಭಾಗೀರಥಿ ಫೋನ್ ಮಾಡಿ ತನ್ನ ಗಂಡ ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿ ಸುಟ್ಟಿರುತ್ತಾನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾಳೆ. ನಾನು ನನ್ನ ಸಂಬಂಧಿಕ ಪ್ರಶಾಂತನಿಗೆ ಫೋನ್ ಮಾಡಿ ಆಂಬುಲೆನ್ಸ್ ಫೋನ್ ಮಾಡಿ ಕರೆಸಿ ಎಂದು ಹೇಳಿದ್ದೇನೆ. ನಾನು ಮೃತಳನ್ನು ಆಂಬುಲೆನ್ಸ್ ನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಬಂದು ಭಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಗಾಗಿ ಸೇರಿಸುತ್ತೇನೆ. ಮೃತ ಮುಕ್ತ ಅಲಿಯಾಸ್ ಭಾಗೀರಥಿ ಫೋನ್ ಮಾಡಿದಾಗ ಸಂಜೆ 7 ಗಂಟೆ ಆಗಿತ್ತು. ಆರೋಪಿತ ಹೆಂಡತಿಗೆ ದಿನ ಕುಡಿದು ಹೊಡೆದು ಹಣ ಕೊಡು ಎಂದು ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದ ಎಂದು ಹೇಳಿದಳು. Even she has made oral statement before him also, as he has narrated in chief examination. And thereafter, the ಆರೋಪಿತನ ಸರಾಯಿ ಕುಡಿದು ಬಂದು ತನಗೆ ಸೀಮೆ ಎಣ್ಣೆ ಬೆಂಕಿ ಸುಟ್ಟಿರ್ತಾನೆ ಎಂದು ಹೇಳಿರ್ತಾರೆ. ಮೃತ ಭಾಗೀರಥಿಯನ್ನು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗಾಗಿ ಭಾಲ್ಕಿ ಆಸ್ಪತ್ರೆಯಿಂದ ಲಾತೂರು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದೆ. That is on 4/9/2015, my lords. She admitted at Bhalki hospital on 2/9, and for higher treatment, she was shifted to the Latur hospital on 4 and after 2 days. And thereby she succumbed to injuries.
Let us see. Yes, Mr. Counsel.
My lords, as far as PW 7 statement is concerned, my lord, no doubt she has stated before him that such and such incident happened with me, and I succumbed with the injuries. But my lord, my submission is that his presence on the date of the incident at the home of the deceased itself is not admissible. Number one. Number two, my lord, his presence in the village itself is not admissible.
Why?
Because, my lord, if my lord see the cross-examination of the PW7, my lord, ಫಸ್ಟ್ ಲೈನ್, ಆ ದಿವಸ ನಮ್ಮ ಸಂಬಂಧಿಕರ ಪ್ರಶಾಂತ್ ರವರ ಮನೆಗೆ ಬಂದಿದ್ದೆ. ಸದರಿ ಪ್ರಶಾಂತ್ ತಂದೆ ಮತ್ತು ಅಡ್ಡ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ನಾನು ಕೆಲಸಕ್ಕೆ ಬಂದಿಲ್ಲ. ಅದೇ ದಿವಸ ನಾನು ಕೆಲಸಕ್ಕೆ ಬಂದಿದ್ದೇನೆ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್, ಇಫ್ ಮೈ ಲಾರ್ಡ್ ಸಿ ದಿ ಲಾಸ್ಟ್ 3 lines of the same para, ಪ್ರಶಾಂತ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ 62 ಮೈ ಲಾರ್ಡ್.
Yes, yes.
ಪ್ರಶಾಂತ್ ರವರ ಬಳಿ 3 ದಿವಸ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಇದ್ದೇನೆ. ಸದರಿ 3 ದಿನಗಳಲ್ಲಿ ನಾನು ಮೃತಳ ಮನೆಗೆ 1 ದಿನ ಮಾತ್ರ ಹೋಗಿದ್ದೆ. ನಾನು ಪ್ರಶಾಂತ್ ಏನವರ ಮನೆಗೆ ಕೆಲಸ ಮಾಡಲು ಬಂದಿದ್ದೇನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. At a single tone he says that only 1 day I was in the village. Next he says for 3 days I was in the village. Then my lord, which is reliable? That is my submission. If he is an eyewitness, if he knows special circumstances, if it is well within his knowledge, then he could have said, yes, I was there in the village at this time. I just went to this
Make any difference? Does it make any difference whether he stayed there for 1 day or 3 days?
Yes, my lord, because he is the next eyewitness.
27.
No, my lord, my submission is he is the next eyewitness to the incident. Apart from this Mathura Bai, who is PW4, he happens to be the person who has got information about the incident. He should be very clear before the court that as to the time and date when he was there in the village, and secondly as to the time and date when he got information from the deceased. Nothing is clear.
According to him, at about 7 p.m.,
Yes.
about 7 p.m., he received the information from there. He received the call from deceased
Yes, my lord.
about the incident. Immediately he went to the spot. He rushed to the spot. There, the injured, injured, she revealed the act of the accused.
Yes, my lord. Yes, my lord. But the calling itself is not admissible. That is my point. When I am on fire, everything is put on fire on me. How can I call that person some other person? First I should think some person to douse my fire.
Where is your cross-examination to that effect? Who suggested? Whether he suggested to the doctor in such a position is unable to call to any other person.
Doctor is not examined, my lord. He is neither a judge nor PW witness.
How you can say in an appeal whether you can take such a stand? So we have
That
to
is my
believe you,
submission.
Mr. Counsel.
That is my submission. Doctor is not brought to the light, my lord. That is my submission. He is not being brought to the court, my lord. Even my lord, astonishingly.
Some expert has to say, Mr. Counsel, some expert has to say, it is impossible to call if a person with the flame or caught by fire, you are unable to call on the, who has to say?
PW10 is a doctor who treated first.
PW10 is the doctor.
Yes, my lord.
Have you made
Chief
any such
Member-
suggestion?
Nothing.
Have you made any suggestion?
She says that on the date of incident that when she was admitted to hospital, only 35% injuries were there and they were fresh. Only to that effect she makes the statement, madam.
So that when she got admitted in the hospital, there was only 35% of burn injuries.
Yes, madam. Yes.
Minors. Sorry for it. As per the medical jurisprudence, my lords, in developing countries like India, looking at the nursing care of patients and time lapse between the incidences and starting of treatment, 30% or more burn injuries are sufficient to cause death of person. Here is 35%, in some extent 45%. It went on increasing. 30% is merely sufficient to cause a death.
Thereafter, septicemia, she
Yes.
died. That
Yes,
is,
yes.
say, Mr. Counsel, the evidence of PW7 has
Yes.
to be treated as he's a res gestae witness. Immediately, the injured narrated the entire incident to him. He went to the spot immediately. She narrated the entire incident. So it's section as per section 6 of the Evidence Act.
Yes.
So we can't discard the evidence of PW7.
But my submission, his presence in the spot itself is
That cannot be.
information.
ಅವ್ರು ಹೆಂಗೆ ಕಾಲ್ ಮಾಡಿದ್ರು ಹೆಂಗೆ
Yeah.
ಕಾಲ್ ಮಾಡಿದ್ರು ಅಂತ ಯಾರಲ್ಲಿ ಕೇಳ್ಬೇಕು ಅದು?
You know, my lord, the learned HCP has submitted 35% is enough to to die because of injuries. 35% is there, my lord. How can she call some person for call for help?
So please reveal these facts to him.
And my lord, coming to the even his presence in that village, he says that only one day I was there, and the next version he says for 3 days I was there. Hence his deposition cannot be based as some reliable statement, my lord. His presence in the village itself is disputed. That is my submission. And also, my lord, coming into the deposition of PW 5, 6, and 8, my lord, who are the interested witnesses.
SPP, whether the admission register placed case sheet exhibit P15 ಏನು ಹೇಳ್ತದೆ ನೋಡಿ?
Yes, ma'am. Case sheets are there. Where she was being treated, ma'am. Exhibit P6, inpatient case.
15.
Inpatient case sheet is there, my lords.
May I make one submission as per this document is concerned, my lord? Only one submission.
Just a minute.
Yes.
Yes. Total 31 pages there.
33 pages, my lord.
Yes.
Lord, even
SPP. Who admitted ಅಂತ ಯಾರು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಲ್ಲಿ ಅಂತ ನೋಡಿ. ತಗೊಂಡೋಗಿ ಇನಿಷಿಯಲ್ ಅವಳನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ಯಾ?
the answer is no. The answer is no, my lord. My lord, interestingly, my lord, as per exhibit P15 also, in the front page itself, there is an admission that because of 55% superficial to deep burn, she was being admitted to the this Latur hospital. CW19, who happens to be Dr. Anmol, who gave treatment to deceased Mukta at Latur hospital. CW19, my lord. In the charge sheet, my lords can find that. He is also not been examined. Only he gives 161 statement and then he disappears. Then my submission is how this document is held reliable. That is my submission. And next, subsequently, and also very interestingly, the postmortem also, which has been conducted by 2 doctors, who are, which is at exhibit
CW 18 and 19.
Exhibit P13, my lord. Which is the first, second line, my lord. Dr. Gutte, GP, and Dr. Mane, SV, my lords will find it. Who have conducted postmortem, my lord. They happen to be CW 18 and 19. They are also not been examined. They give this statement and they might have record 161 statement. Even I don't know that, but surprisingly, they have not stood for the test of cross-examination before the honorable trial court. CW 18 and 19. Hence, my submission is even post-mortem report is also not admissible.
Yes.
And my last submission would be that, my lord, very interestingly, PW 5, 6 and 8, my lord, who happens to
PW?
5, 6 and 8, father, mother and the elder sister of the deceased, my lord.
Yes.
Yes. To put it in a single statement, my lord, the deceased states that after the incident, I have been taken to the hospital, and sorry, after the incident, PW7 came to the spot. I told him what has happened with me, and then PW7 is the key witness who says that he has taken the trouble to call these witnesses one by one. 5, 6, 7 and 8, 5, 6 and 8 at around 9 p.m. and 10 p.m. by the night on the same day. And they arrived at the hospital around midnight 1 a.m. to see the deceased. And there the deceased told them everything. So this is the actual version which has been put in the chief and cross melon of all PW 5, 6 and 8 in the same version. So apart from going from, sorry,
The
Malad.
evidence of PW5?
Yes, Malad.
The evidence of PW5.
Yes. Murta Bhagirathi alias Mukta ನನ್ನ ಮಗಳು, ಆರೋಪಿ ನನ್ನ ಅಳಿಯ, ಮೃತ ಭಾಗೀರಥಿ alias ಮುಕ್ತ ಇವಳ ಗಂಡ, ಚಾಸ 5 that is PW7 ಧರ್ಮ ನನ್ನ ಅಳಿಯ, ಚಾಸ 6 ನನ್ನ ಮಗ. Chasa 6 is Govind, my lord. Yes, in my later part of my argument, I'll come to this point, my lord. Chasa 6, he is not a PW witness. Chasa 6 ನನ್ನ ಮಗ, Chasa 10 ಕೌಸಾಬಾಯಿ, that is PW6 ನನ್ನ ಹೆಂಡತಿ, Chasa 11 ಜನಾಬಾಯಿ, that is PW8 ನನ್ನ ಮಗಳು. ಸುಮಾರು 3 ವರ್ಷಗಳ ಹಿಂದೆ ಮುಕ್ತ ಇವಳ ಆರೋಪಿಯೊಂದಿಗೆ ಮಾಡಿರುತ್ತೇವೆ. ಮದುವೆ ಆದ ನಂತರ ಆರೋಪಿತನು ಸುಮಾರು 2-3 ತಿಂಗಳು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿರುತ್ತಾನೆ. ನಂತರ ಆರೋಪಿ ದಿನಾಲೂ ಸರಾಯಿ ಕುಡಿದು ಬಂದು ಮೃತಳಿಗೆ ಜಗಳ ಮಾಡಿ ಹೊಡಿಬಡಿ ಮಾಡುತ್ತಿದ್ದನು. ಆರೋಪಿ ತೊಂದರೆ ಕೊಡುವ ವಿಷಯವನ್ನು ಮೃತ ನನ್ನ ಮಗಳು ಫೋನ್ನಲ್ಲಿ ನನಗೆ ತಿಳಿಸಿದಳು. ದಿನಾಂಕ 2/9/2015 ರಾತ್ರಿ 9 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ಚಾಸ 5 ಧರ್ಮ ಈತ ನನಗೆ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ್ದೇನೆಂದರೆ, ಆರೋಪಿತನು ಮೃತಳಿಗೆ ಮೈಮೇಲೆ ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿರುತ್ತಾನೆ. ಸುಟ್ಟ ಗಾಯಗಳು ಆಗಿದ್ದು ಅವಳನ್ನು ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ತೆಗೆದುಕೊಂಡು ಬರುತ್ತಿದ್ದೇವೆ. ನಮಗೂ ಬರಲು ತಿಳಿಸಿರುತ್ತಾನೆ. Yes, my lord. And now what this is important. ನಾನು ನನ್ನ ಮಗ ಚಾಸ 6, ಚಾಸ 10, ಚಾಸ 10 that is PW10, PW6, ನನ್ನ ಹೆಂಡತಿ ಚಾಸ 11 ನನ್ನ ಮಗಳು ಜನಾಬಾಯಿ that is PW8, ಎಲ್ಲರೂ ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದಿರುತ್ತೇವೆ. ರಾತ್ರಿ 1 ಗಂಟೆಗೆ ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದಿರುತ್ತೇವೆ. This is very important. ಮುಕ್ತ ಭಾಗೀರಥಿ ಇವಳಿಗೆ ವಿಚಾರಿಸಲಾಗಿ ಅವಳು ತಿಳಿಸಿದ್ದೇನೆಂದರೆ, ಆರೋಪಿತನು ಸರಾಯಿ ಕುಡಿದು ಬಂದು ನನ್ನೊಂದಿಗೆ ಜಗಳ ಮಾಡಿ ಮೈಮೇಲೆ ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿ ಸುಟ್ಟಿರುತ್ತಾನೆ ಅಂತ ತಿಳಿಸಿರುತ್ತಾಳೆ. ಆ ದಿನ ಮೃತ ಭಾಗೀರಥಿಯೊಂದಿಗೆ ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಉಳಿದು ನಂತರ ಲಾತೂರ್ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಚಿಕಿತ್ಸೆಗೆ ಸೇರಿಸಲಾಯಿತು. ಚಿಕಿತ್ಸೆ ಪಡೆದಿದ್ದಾಗ 20 ದಿನಗಳ ನಂತರ ಸುಟ್ಟ ಗಾಯಗಳಿಂದ ಗುಣಮುಖ ಆಗದೆ ಮೃತಪಟ್ಟಿರುತ್ತಾಳೆ. ಪೊಲೀಸರು ನನ್ನ ವಿಚಾರ ಮಾಡಿ ಹೇಳಿಕೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ.
Yes.
And now continuing to cross, my lord. Cross of the ಮೃತ ಭಾಗೀರಥಿ ಅಲಿಯಾಸ್ ಮುಕ್ತಾಯ ಮೊದಲ ಕಲ್ಮಳ್ಳಿ ಗ್ರಾಮದ ರಾಜೇಂದ್ರ ಎನ್ನುವರಿಗೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದೇನೆ. ಸದರಿ ಭಾಗೀರಥಿ ರಾಜೇಂದ್ರ ರವರೊಂದಿಗೆ 3 ವರ್ಷ ಸಂಸಾರ ಮಾಡಿರುತ್ತಾಳೆ. ಮೃತ ಭಾಗೀರಥಿ ತನ್ನ ಮೊದಲನೇ ಗಂಡ ರಾಜೇಂದ್ರನೊಂದಿಗೆ ವಿವಾಹ ವಿಚ್ಛೇದನೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾಳೆ. ಭಾಗೀರಥಿ ಮೊದಲು ಸಹ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ರಾಜೇಂದ್ರ ಸರಾಯಿ ಕುಡಿಯುವ ಕಾರಣ ಆತನೊಂದಿಗೆ ತನ್ನ ಮಗಳು ವಿವಾಹ ವಿಚ್ಛೇದನೆ ಪಡೆದುಕೊಂಡಿದ್ದಳು. ಆರೋಪಿಯೊಂದಿಗೆ ಸಂಬಂಧ ನನ್ನ ಮೈದುನ ಜ್ಞಾನೋಬ ಮಧ್ಯಸ್ಥಿಕೆಯಲ್ಲಿ ಮಾಡಿರುತ್ತಾನೆ. ಆರೋಪಿಯ ಬಗ್ಗೆ ಲಗ್ನಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಆತನ ಕುಟುಂಬದ ಬಗ್ಗೆ ವಿಚಾರ ಮಾಡಿರುತ್ತೇನೆ. ಆತ ಮೊದಲಿನಿಂದ ಗೊತ್ತಿರುತ್ತಾನೆ. ಆರೋಪಿಯು ಮೊದಲು ಸರಾಯಿ ಕುಡಿಯುತ್ತಿರಲಿಲ್ಲ, ಲಗ್ನ ಆದ ಮೇಲೆ ಸರಾಯಿ ಕುಡಿಯುತ್ತಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿ ಭಾಗೀರಥಿ 2-3 ತಿಂಗಳು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿದ್ದ. ನಂತರ ಸಾರಾಯಿ ಕುಡಿದು ಆತನೊಂದಿಗೆ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 2/9/2015 ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿ ಗಲಾಟೆ ಮಾಡಿಲ್ಲ, ಸೀಮೆಎಣ್ಣೆ ಹಾಕಿ ಸುಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 5 ದಟ್ ಇಸ್ PW7 ರವರು ಫೋನ್ ಮಾಡಿದ್ದಾನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಮಗಳು ಮಾಡಿ ವಿಷಯ ತಿಳಿದ ಮೇರೆಗೆ ನನ್ನ ಮಗಳು ಮನೆಗೆ 2-3 ಸಲ ಬಂದು ಹೋಗಿದ್ದೇನೆ. ಆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ನೆಂಟರನ್ನು ಭೇಟಿಯಾಗಿದ್ದೇನೆ. ಅವರ ಹೆಸರು ನೆನಪು ಇಲ್ಲ. ನಾನು ನನ್ನ ಮಗಳು ಮನೆಗೆ ಬಂದಾಗ ಆರೋಪಿ ಯಾವಾಗಲೂ ಕುಡಿದೇ ಇದ್ದ. ಆತನಿಗೆ ಬುದ್ಧಿ ಹೇಳಲು ಪ್ರಯತ್ನ ಮಾಡಿರುತ್ತೀರಿ ಎಂದರೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಊರಿನಲ್ಲಿ ಯಾರಾದರೂ ಆ ಸಮಯದಲ್ಲಿ ಊರಿನ ಹಿರಿಯರಿಗೆ ವಿಷಯ ತಿಳಿಸಿರಿ ಎಂದರೆ ತಿಳಿಸಿಲ್ಲ. ನಮ್ಮ ನೆಂಟರಿಗೆ ತಿಳಿಸಿದ್ದೇನೆ. ಆರೋಪಿ ತಾಯಿ ಪ್ರಾಸ 4ರವರಿಗೆ ವಿಷಯ ತಿಳಿಸಿರುತ್ತೇನೆ. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ನುಡಿದಂತಹ ಆರೋಪಿ ತಾಯಿ ಪಾರ್ವತಿ ಇರಬಹುದು. ನನ್ನ ಮಗಳು ತಾಯಿ ಪಾರ್ವತಿ ಇರಬಹುದು. ನನ್ನ ಮಗಳೊಂದಿಗೆ ಆಕೆ ಗಂಡ ಆರೋಪಿ ಹಾಗೂ ಆತನ ತಾಯಿ ವಾಸವಾಗಿದ್ದರು. ಮೃತಳು ಆರೋಪಿಯೊಂದಿಗೆ ಲಗ್ನ ಆದ ಮೇಲೆ ಆತನೊಂದಿಗೆ ಸಂಸಾರ ಮಾಡುವ ಇಚ್ಛೆ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಮಗಳು ಆರೋಪಿ ಹೇಳಿದ 2-3 ಸಲ ನಮ್ಮ ಮನೆಗೆ ಬಂದಿರುತ್ತಾಳೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಮಗಳನ್ನು ಜಬರ್ದಸ್ತಿಯಿಂದ ಆರೋಪಿ ಮನೆಗೆ ತಂದು ಬಿಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 5 ಧರ್ಮ ನನ್ನ ಮೊದಲ ಮಗಳ ಗಂಡ ಎಂದರೆ ಸರಿ. ಸದರಿ ಚಾಸ 5 ಧರ್ಮ ನನ್ನ ಮೃತ ಮಗಳೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡಿದ್ದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಕೆ ಮೊದಲು ಗಂಡನನ್ನು ಸಹ ಆ ಕಾರಣಕ್ಕೆ ಬಿಟ್ಟಿರುತ್ತಾಳೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಕೆ ಧರ್ಮನೊಂದಿಗೆ ಇರಬೇಕೆಂಬ ಇಚ್ಛೆ ಇತ್ತು, ನಾವುಗಳು ಒಪ್ಪದ ಕಾರಣ ಆಕೆ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡಿದ್ದಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 5 ಧರ್ಮ ಕಾಕನಾಳ ಗ್ರಾಮಕ್ಕೆ ಬರುತ್ತಿದ್ದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಘಟನೆ ಆದ ದಿವಸ ಚಾಸ 5 ಧರ್ಮ ಕಾಕನಾಳ ಗ್ರಾಮದ ತನ್ನ ನೆಂಟಸ್ಥರ ಮನೆಗೆ ಬಂದಿದ್ದ. ಕಾಕನಾಳ ಗ್ರಾಮದಲ್ಲಿ ಚಾಸ 5ರವರ ಬೇರೆ ಯಾರು ಸಂಬಂಧಿಕರು ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 5ರವರ ಮಾತು ಕೇಳಿ ಆರೋಪಿ ಮೇಲೆ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತೇನೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಎಂದೂ ಕುಡಿದು ಬಂದು ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಕೆ ಮೃತ ನಂತರ ಆರೋಪಿಯನ್ನು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡು, ಕೇಸು ಮಾಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆತ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡದ ಕಾರಣ ಆತನ ಮೇಲೆ ಸುಳ್ಳು ಕೇಸು ಮಾಡಿ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ.
One more defense. Re-defense.
My lord, my humble submission is that, my lord, they say at around, they means PW 5, 6 and 8, they all say in a single tone that they arrived at the hospital at around 1 AM in the midnight on dated 3/9/2015. That too along with CW6, who also happens to be one of the brother of deceased, Govind. Interestingly, my lord, this Govind is only a charge sheet witness. He is not a prosecution witness. Now, my submission is that he calls the police after the death of the deceased around on 21st September 2015, and the IO tells him to come to the police station for the purpose of recording that statement to the effect that the deceased has died. And he tells, yes, I will come in 2-3 days. Then he will not turn to the police station. Then 2 of the constables, they go to the place of these people where they're actually living. They record the statement in their own handwriting, and they are the charge sheet witnesses. They say that yes, we had been to that place, we recorded the statement of Govind, and they come to the police station and they just hand over that this 161 statement. My submission is, in that 161 statement recorded on behalf of the pertaining to the CW6, who is Govind, he says that no, we have not come to the hospital on the date of on 3rd September 2015 around midnight 1 AM, but we have come to the hospital on dated 3rd September 2015 at afternoon 1 PM. At afternoon 1 PM. Cannot we see his statement, my lord? And this has been affirmed by the police constable who had been to their place. That is actually the native place of the victim.
What prohibited you to examine on behalf of defense?
It is known by the trial court.
Huh?
He is not, unfortunately, he has not been examined, my lord, as a PW witness. But those documents form part of the record, my lord. The lords may see that. In that statement, I'll just read what is relevant portion, my lord. of
discarding,
CWC.
counsel, by discarding the evidence of PW 5 and 6, we have to rely the statement, 161 statement recorded by the police.
No, my lord,
Is it the submission?
no, my lord, my submission is that why he been not brought to the cross examination because of the only this lacuna, because there is a time, because when the deceased states in a single tone that after dharma, that is PW7, I have informed to my acquaintance, that is my father, mother, and my elder sister, who have come to the hospital at around 1 a.m. in the midnight.
What is the evidence available before the court? But appreciate the evidence. That's all. You can't argue that some document is there, some 161 statements there in the file.
But that
And then we
161
can
statement
compare
clearly
this
denies
evidence to
the-
161 statement. What is the evidentiary value of 161 statement? How you can rely? Whether the statement is marked?
No, it is not been marked, my lord, but the actual version which has been recorded.
That is the case, you would have examined him. That is your duty for prosecute this one defense as a defense witness. The evidence of PW 5 and 6, they stated that the deceased, their daughter clearly narrated the incident to them in the hospital on the date of incident, whether it is 7 p.m. or the next day. So according to them, she clearly stated that the accused poured kerosene and set her ablaze. So why we have to disbelieve the evidence of PW 5, 6, the father, mother, PW 7, the brother-in-law, PW 8, the wife of PW 7.
Even PW 8 also, my lord,
Cross-examination, what you have suggested to the witness PW 7 in the cross-examination that she had an illicit affair with PW 7.
Yes, ma'am.
Whereas PW 8 is the wife of PW 7.
Yes, ma'am.
So what is the, have you suggested, what is the reply? She denied that.
As far as yes, my lord, as far as the immoral relationship which was happened to be with the deceased and the PW7, there's nothing in the evidence of PW 5, 6, and 8. I do agree, my lord. I admit, my lord.
PW 8 being the wife of PW 7, she denied your suggestion.
Yes, ma'am. I admit, ma'am. But my
That
submission
shows
is.
your defense is not a probable one.
Yes, my lord.
The
Yes, my
defense
lord.
itself is not a probable one.
Yes, my lord.
Then?
But the time of arrival at the hospital itself is not admissible then. Yes, that is my humble submission of these three witnesses.
That without examining that the person who stated so, how we can discard the evidence of this witness, Mr. Counsel?
And even my lords can find in the chief examination of PW8, my lord, as far as the aspect of time of arrival at the hospital, my lord, she states PW8 in the 9th line from the top, chief examination, my lord. Maru divasa ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದು ನೋಡಿ ಆಕೆಯನ್ನು ವಿಚಾರ ಮಾಡಿದಾಗ ತನ್ನ ಗಂಡ ಆರೋಪಿತನೊಂದಿಗೆ ಜಗಳ ಮಾಡಿ ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಿ ಬೆಂಕಿ ಹಚ್ಚಿರುತ್ತಾನೆ ಎಂದು ಹೇಳಿರುತ್ತಾಳೆ. There PW 5 and 6 in a single tone, they say that they arrived in the midnight of 3rd September. Here she says Maru Divasa.
Maru Divasa, that is 3rd.
Maru Divasa, she alone. ಬೆಂಕಿ ಹಚ್ಚಿರುತ್ತೇನೆಂದು ವಿಷಯವನ್ನು ಫೋನ್ ಮಾಡಿ ಮರು ದಿವಸ ಬಾಲ್ಕಿ ಆಸ್ಪತ್ರೆ. She visited the hospital on the next day, according to her.
According to her, but PW 5 and 6 say that we all came to the hospital, ma'am. That is my submission.
Whether they stated that this PW 8 Janabai was also there along with them.
Yes, ma'am.
They mentioned the name of Janabai.
Yes, ma'am. In PW 5 statement, ma'am. ನಾನು ನನ್ನ ಮಗ ಚಾಸಾರು That is 1, 2, 3, 4, 5, 6, 7, 8. Ninth line from the top, my lord, PW5 chief examination. ನಾನು ನನ್ನ ಮಗ ಚಾಸ 6, ಚಾಸ 10 ನನ್ನ ಹೆಂಡತಿ, ಚಾಸ 11 ನನ್ನ ಮಗಳು ಜನಾಬಾಯಿ.
So 1 PM
ಎಲ್ಲರೂ
means next day only 1 PM. Must be 1 AM, not 1 PM.
My lord, there is a huge difference of AM
1
and
AM
PM.
is next day.
AM and PM, my lord. It's midnight and it's 4 afternoon. My lord.
Night ಅದೇ ಮರು ದಿವಸನೇ ಆಗುತ್ತೆ.
My submission, when the time of visiting of these 3 interested witnesses to the hospital itself is not reliable, then the statement made to them by the deceased is also not reliable. That is my submission. Hence, their evidence must be discarded.
See, by considering these minor contradictions or discrepancies, just to throw away the evidence of these material witnesses, 5, 6, 7, 8, exhibit P8. Anything else to say? Anything
And
else?
even, my lord, as far as the remaining witnesses, that is the court, police constable who has taken the
Yes, SPP. Anything?
Yes,
What is
yeah,
your content?
yes, my lords.
Hmm.
The
Who
as
should
far as-
beg? 10 minutes ಇದೆ.
Yes, 5 minutes.
Ah.
So looking to all the witnesses which have been added before the trial court, my lords, that are PW 1 to 14. Of course, PW 4 is the mother of the appellant. Obviously, she has to be turned hostile, and she has been turned hostile. She has turned hostile. That is different. So in page number, the trial court has meticulously appreciated, my lords, in page number 97 of that. In the evidence, shall I read, my lords? In the evidence of PW 14, the police inspector, Balki Police Station, exhibit P15 is marked, which is case sheet consisting of 31 pages maintained by Government Hospital, Latur. This detailed case sheet reveals the treatment underwent by victim for 4/9/2015 to 29/2015 for burn injuries. This shows, my lords, that definitely it's a homicidal death. And thereafter, my lords, the trial court and the as per the opinion of the doctor, the death is due to Septicemic shock due to birth.
Septicemia.
Septicemia. That has been written over here. Shock due to burn. So obviously, my lords, what the exhibit P8 says, what the deceased has narrated in a statement, my lord, that corroborates this particular certificate, my lords. And also, my lords, why the exhibit P8 is to be believed. The page number 108 in last, my lords, page number 109, 109 of that. The statement can be treated as a dying declaration, that exhibit P8. Why it has to be believed? That narration that has been given by the trial court judge. 109. Our Honorable High Court, Kalaburagi bench in Vijay alias Vijayendra versus State of Karnataka on 20/11/2020 in a case of 304 IPC, followed the judgment of Honorable Supreme Court reported in 2019-15 SSC 344, wherein it is held like this. More so where the version given by the deceased that the dying declaration is supported and corroborated by other prosecution evidence, there is no reason for the courts to doubt the truthfulness of such dying declaration. And thereafter, my lords, this portion was accepted by our Honorable High Court. In the said case before the Honorable High Court, the statement of the victim was recorded on 27/4/2009. The victim died on 7/6/2009. Here is the same, my lords. The Honorable High Court treated the statement of the deceased as dying declaration. In the case on hand, also 20 days after the incident, Mukta died. Therefore, the statement of Mukta is equal to dying declaration.
But what is your effort, Mr. SPP? Say the faulty investigation by the investigation
Of course, in some
officer.
extent, my lords,
After
it's a
20
fact.
days, she was alive.
Yes, my lords. She was
Not made venture to go to the hospital,
the
visit
Tahsildar,
the hospital,
Tahsildar would
or
have
to
gone
take
over
any
there.
statement.
Yes,
Huh?
that he has, he would have been, but
When she shifted to the hospital at Maharashtra
on 4th.
on 4th,
Yes,
she was there even after giving exhibit to P1, even after recording this exhibit to P8 on 2/9.
wow,
She was there in that hospital for 2 days
2 days.
till 4/9.
Ah.
Why you have not made any effort to record her statement or to get at least get a fitness certificate? Huh?
Even while recording PW 13 has stated in his evidence that, my lords, he met doctor and taken the consent of the doctor and inquired him, and doctor has suggested that she is fit to give a
Who is
statement.
that doctor? At least you would have cited him as a charge sheet witness.
PW9, man.
PW9 has stated that.
Yes, my lords.
Where is the evidence of PW9?
My lords, opinion that might not have come, my lords.
Whether he has stated that?
No, my lord, PW9 is the police constable.
PW10.
Huh.
To that extent, that is not, ನಾನು ಕಳೆದ 5 ವರ್ಷ ಬಾಲ್ಕಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಮಹಿಳಾ ವೈದ್ಯಾಧಿಕ, but it has been stated by the PW 13, and to that extent there is no cross examination also.
But he has not stated this. So.
That is only to that extent. Yes, ದಾಖಲಾಗಿದೆ ಅಷ್ಟೇ ಹೇಳಿದಾಳೆ. But it has been narrated by the PW 13 who has registered the case and the person who has visited and recorded the statement of deceased. So in overall, my lords, the deceased has lost her life. The truth sits upon the lips of a dying man, my lords.
Yes, true.
He never states a lie. It's a true fact, my lords.
Procedure has to be followed.
Yes, that is there, my lords.
Procedure
Even
has
then,
to be
Apex
followed.
Court has held in several
See, we are
decisions.
seeing all the cases, criminal cases, the police were not making any effort, or they're totally a false
1995
investigation.
90.
This is not the way. Huh?
Even then, my lords, the exhibit P8 has to be believed. And all the witnesses except PW4, who happens to be the mother of the appellant, all have supported the case of the prosecution, and there is no cross-examination to that effect also. Nothing has been elicited. Indirectly, they have admitted in the defense also, my lords, and 3 types defense have been taken. The defense must be one, my lords.
That is one aspect. What is your say about the deceased sustained some 35% burn
Yes,
injuries initial.
Yes.
Initial.
Yes.
So she survived for a period of 20 days.
20.
Another 20 days. So incident must have caused in a, it's not that such intention that she has to the incident was not caused in such a intention to commit her.
Why he has absconded?
Hmm?
Why he has absconded? If that is there, incident has not been occurred to the effect that, my lord, the whatever she has narrated. He would have taken her to the hospital.
Yes.
Nothing effort has been made, has not been made.
It's your house, Mr. Counsel. You are the husband. You have to explain.
Yes.
You have to
May I
explain.
submit the comment?
You have to explain the reason, cause for her death.
My lords, my
Committed, who else has been committed? What happened to her?
my lord, my humble submission is that the trial court judge has straight away relied on a single concept that after the committing of crime, absconding from the scene of crime itself doubts the case of the accused. Yes, my lord. Yes, my lord. Yes, my lord. I do admit it. But there are Supreme Court judgments to that effect. And Supreme Court says very clearly that the court cannot rely on this aspect because the citizens of India or the people in certain circumstances, there is a high chance of doubt that even thinking or apprehending that yes, I may be arrested for the crime which I have not committed, there is a high chance of escaping from the place.
Sir, Counsel, this is not a case that your husband, the incident caused in your house. Section 106 comes into play. Your wife, the deceased is none other than your wife. Your knowledge, the fact was very much within your knowledge. Section
No,
106.
my submission is I was not there in the place at all. My total defense is that because of the reason that the deceased and PW7 were involved in this immoral relationship, and because of the fact that I getting to know about that said fact, she committed suicide.
That you have to explain in your evidence or in 313 statement. Have you explained? Have you examined any witness to prove that they were illicit affair? We are making such allegation or such a false defense, not a probable defense. That itself shows your conduct. Even after the death of your wife also, you behaved cruelly. That
No, my lord.
exception to 300.
No, my lord. No, my lords. It definitely comes under 299 part 2, my lords. Explanation 2, my lords.
You are not qualified to at least claim benefit under section 300, exception 4, because you behaved cruelly even after her death by making such allegation.
My lord, as far as the facts are concerned, I absconded from the place on 2nd September. I got arrested on 4th September. Then where is the question of going to the hospital and taking care of her? And even, my lord, very importantly,
we would have believed your defense if you have taken her to hospital or admitted her to hospital.
ಅಲ್ಲ ನಾನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ನಾನು ಜೆಸಿ ಅಲ್ಲಿ ಇದ್ದಾಗ ಹಾಸ್ಪಿಟಲ್ ಹೋಗೋ ಪ್ರಮೇಯನೇ ಬರ್ತಾ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ. I has been arrested on 4th September.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಡೆಸುವಾಗ ನಿಮಗೆ ಏನು ಆವಾಗ ಬಂತು ಮನಸ್ಸಿಗೆ ಬಂದ ಡಿಫೆನ್ಸ್ ತಗೊಳ್ಳೋದಲ್ವಾ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಡೆಸುವಾಗ ಜಾಗೃತೆಯಲ್ಲಿ ಡಿಫೆನ್ಸ್ ತಗೊಳ್ಬೇಕು. ಏನೋ ಒಂದು ಕೇಳುವುದರಲ್ಲಿ ಕ್ವಶನ್ ಕೇಳ್ಬೇಕೇನ ಅಂತ ಒಟ್ಟು ಕ್ವಶನ್ ಕೇಳುವುದಲ್ಲ.
Yes, my lord. I admit it. The trial court lawyer happens to be some other person, my lord. I have his interest only to argue on the appeal.
Advice ಮಾಡಿ ನಿಮ್ಮ counter party.
And my lord, just my last submission, my lord. The material objects which are not being used for committing crime, they are not being taken. They are not there on the record itself. So that chimney lamp, whether it possesses chimney or not, I don't know even today. Hence, my lord, there is no chance of committing the crime. Hence, on that ground, I may be acquitted, or further less, my lord, I may be convicted to 304 part 2 and immediately set free, my lords.
We'll take up your case, Mr. Counsel. Or ನಿಮ್ಮ ಹೆಸರೇನು? ಕುಮಾರ್ ಸಿದ್ಧಲಿಂಗ ಇವ್ರದ್ದು ಶಂಭುಲಿಂಗ ಅವ್ರದ್ದು ಕಲಿಗಲ್ಲ ನೀವು ನಾಳೆ ತಗೊಳ್ತೀವಿ ನಿಮ್ಮ ಕೇಸ್ ನಾಳೆ ಮಧ್ಯಾಹ್ನ.
One more submission.
Post line.
Serial number 38, my lord, it may be taken on Friday or something. I'm ready to argue on that case.
Will be in the list, eh? Yes.
Yes. Highly obliged.
Madam.